All right, before starting the interview, let me have some comments. We have Mr. Bubu, a member of the Commission who wasn't initially on the panel. He replaces Mr. Postovan, replaces him with full rights throughout the whole exercise because Mr. Postovan wasn't able to make it. Now, this is just for you as a comment. Now, the interview will be as follows. We give you 7, 10 minutes most in order to present your views about the prosecution development, what you've described in a management concept, and the member of the Commission will have some clarification questions or any other questions that you may feel, that we will feel like asking you. All right, thank you. Dear members of the Commission, I believe you have all seen my management concept for 2019-2026, which has been developed by me in line with the order of the Minister of Justice regarding the announcement for the selection of Prosecutor General position. Now, I've tried to align myself to the order, and my concept does not exceed 20 pages. It is made out of introduction, the current situation in the Prosecution Office of Moldova, the objectives and measures to be taken as a general prosecutor, and the assessment and monitoring, risk assessment and monitoring arrangements as Prosecutor General, and I've drawn some conclusions as well. At present, the activity of prosecution is conducted in line with the provisions of the Constitution and the provisions of Law Number 3 from 2016, 25 February, on prosecution. So, starting with 2016, we have approved 2 organic laws regarding the functioning of the specialized prosecution, anti-corruption prosecution, and prosecution for fighting organized crime. Now, I've been in the prosecution for some time, and this is the 4th law. The first one was in 1992, second one on prosecution was in 2003, the third one on prosecution was in 2008, and the last law was approved by the Parliament of Moldova in 2016. Having made an analysis of all the laws, existing laws, ever since the Moldova proclaimed its independence, now the key competences of the prosecution office are based on two tasks. This is studying criminal cases and the representation of prosecution in the court of law. Now, I should mention that starting after the application of the law on prosecution in 2016, the competences have excluded extrajudicial competences of the prosecution, which would be in line with the laws on prosecution and the Civil Procedure Code. Now, given that the prosecution had other extrajudicial powers, so this was excluded from the activity of the prosecution. These are some competences which unfortunately are required. Well, they actually are needed, and both the civil society as well as the citizens, they request to reinstate infringed rights. I would disagree with some members of civil society, some of our colleagues who equalize prosecution activity to a body, to a body that would do general supervision or prosecution. was equalized to a subject with, I mean, the decisions would not be taken by the prosecution, but the body to which the prosecution general would issue the documents. Now, from my experience of prosecutor, that I've been a prosecutor for 30 years, I've said that in some cases, these tools were much more efficient than the criminal tools. We know very well that in the criminal notion, we exclude or we don't regulate the notion of criminal liability. And we had such cases when through extrajudicial cases, by sending subpoenas, we have reinstated the rights of the state. I was deputy prosecutor of the prosecutor for Chisinau, and through a decision, they've decided to convey into the ownership of people who would rent a movable property of Chisinau Municipal Council. Different people who would lease based on lease agreements. So in line with the agreements of the law on prosecution, I've challenged this decision, and so the illicit alienation of the state assets have been terminated. Now, other cases were from public money, from public funds, they were stolen, and then they would create the normative capital of the petrol bank, and then by submitting subpoenas, we have said that the capital of this bank was created out of the defrauded money as a result of illegal actions, and in this way we have reinstated the right of the state on the shares in this joint stock company. Now, the civil case was at the same time with the criminal cases by submitting the subpoenas to people. We have reinstated the violated rights of the government in this case. Once the law on prosecution from 2016 was approved, the activity of prosecution was based on they've created the Council for the Assessment of Performances of the Prosecution, Ethics and Discipline panels, 3 panels. So in each of the panels, there are 5 prosecutors, and then there are people from the civil society. If you allow me, you have very little time. If you can summarize, maybe you want to stress something which is of major importance in your management concept of prosecution. Well, of course, the problems, the issues facing prosecution. Look, I've been a prosecutor, and then since the prosecution bodies is a part of the society, they would work in line with the political will of society. I know the public opinion barometer very well, which ranks us among the last when it comes to corruption in the system. So I would define, and I would divide the fight against corruption into, it will be 2 methods I would use. The first method is a disciplinary method, and the criminal cases. Now, I would also point out the fact that the society must be more active, and they should put pressure on the prosecution so that it works in line with the provisions of the law. Now, I wrote about the role of the prosecution inspection as part of the prosecutor's office activity. I say that the prosecution inspection should work should be work in relation to the Superior Council of Prosecutors, which is the hierarchically, which is the superior body of which manages prosecution's affairs. And there should be controls that should be conducted by. Oh, sorry, I have a bit of a. I think the members of the committee will have some clarification questions regarding your management concept, and I think we should get to the questions from the members of the Commission. Mr. Boțan, you have the question. You have the floor. Thank you very much for your presentation, Mr. Adam. I've listened to what you've said, and let me ask you whether the prosecution reform that was conducted, as you stated, in 2016, and 3 years have passed ever since. Now, in your thinking, this reform, is it worth being adjusted, tailored to the existing law, or your management concept provides for the fact that one needs to change the law, one needs to review certain conceptual matters so that things in prosecution develop in an orderly fashion? Thank you.
Well, of course, the laws are very good. The laws are very good, and practically this law, for example, prosecution system service, we've had a lot of public debates. We've been actively involved. I was myself involved, sharing my opinion about the content of that law. However, basically, finally, ultimately, at the end of the day, it's about implementation or enforcing that law. So, for example, the law on prosecution service, which is always based on some criteria like independence of prosecutors, but in practice, we had some gaps when it comes to the real enforcement of that independence. Just a clarification from the point of view of functionality, operationality. Does the reality comply with the law, or you would say that legislation should be actually amended? Well, you see, the laws are quite good. I've just shared my opinion at that time about the extrajudicial rights of prosecutors, but I think, you see, according to that law, prosecution service, we then in the country established two other specialized prosecutor's office, like that one specialized on organized crime. I think they lacked or they failed to have very good, tight cooperation with the general office, although the law says that it should be done as I've mentioned above. So I think the role of the prosecutor general should be more active in coordinating better the activity with those two specialized officers, and this kind of supervision control should be tougher, I think, stronger, by subdividing the duties among those and the prosecutor general office. Thank you very much. Yes, if no more questions or clarification about the concept, let us talk about the concept, sort of clarifying question about the concept model. Then, do we have a question about the concept? Well, it's a pretty general question, but at the same time, I would like to follow up. Mr. Vladimir Radan, you and your concept document have such an activity or such a provision. You say that prosecution office should be protected from the interference outside or external interferences. Would you please clarify it and answer to this question? How would you, what you would make to cut down the appetite of those willing to influence the Prosecutor General and Prosecutor General Office and Prosecution Service from the political point of view, on political terms? How would you exclude these kind of interferences or interventions of the political elements into the activity of prosecution system as such? Do you have something like ready to apply, a recipe? Thank you very much for the question. Actually, that is perhaps the biggest problem that our society is facing with, including the prosecution, of course. You see, dear Mr. Bobo, I believe that only by having the political will, we would be able to improve the image of the prosecution system. I would like the future Prosecutor General to be courageous, brave man that would utter, would say the things as they are, would say the things as they are, and would not be influenced by the political influence. I was working in the prosecution for a long time, and I see the whole evolution of the so-called separation of state branches, and including that as a separate place for the prosecution service. And what I see, we have seen that the prosecution service was in a way taken into account in this kind of division of branches, but it was up to until 2001. At that time, actually, practically, we had the influence of the political elements into the activity of our prosecution bodies, for example, by changing the laws, by influencing the appointments into certain positions, and so on. So it means that the future head of this service should be brave, skillful, and I think that the prosecution system service should be actually contribute to the further division, a real division of the state power. It means that we have to have a very good cooperation, not cross-influence, but cooperation between those three branches. Thank you very much. Yes.
Mr. Adam, you've given us a very comprehensive concept document, and sorry, I'll start again. Thank you for a very comprehensive concept document in which you stress the independence of the prosecutor, and you also mention in it, I think, the need for accountability as prosecutors. Could you tell us how you reconcile the two, and what do you think is the nature of accountability which prosecutors have? Who should they be accountable to, and for what aspects of their work?
Thank you very much for the question. Dear members of the committee, you've noticed maybe that my concept, I've showed up my opinion, saying that the prosecutor should have a status of magistrate. What it means? Magistrate means a real independence. Unfortunately, and some of the judges would agree that we failed in this endeavor. As I've said, starting the independence, we have this fourth law applied, adopted for this system, for this service. And unfortunately, you see, it's either we cannot get rid of this hierarchical control, but I would say that we should focus very much on developing the independence. Actually, that is the greatest, biggest problem. I know that the responsibility does not belong to those who are giving indications. Finally, the one who is accountable and liable for the decisions is the prosecutor himself. That's why he should be rather independent in taking his decision. If this, for example, would be, if it were necessary, he should have the tools of appealing. Thank you very much. Next question. Mr. Adam. you've you've exposed your position and emphasized some very important things, saying that actually the society is perceiving and rather negatively, or not, at least not positively, the system, the service. And I understand that in the future you would like to establish, develop your team, newcomers. You already mentioned new methods for those situations when somebody is to be excluded from the system, how to do it, and so on. So my question would be, how will you be able to settle and to resolve those tasks that you would like to fulfill, taking into account the following: the competence of the Prosecutor General in exercising, carrying out such activities that you mentioned above. Thank you. I would like the future Prosecutor General to be a representative person. I know that he has so many duties, tasks. I would rather like to share this responsibility, because there are, you see, the laws are pretty good, and you know that any achievements were to be reached, we need to wait for several years. We know from this, we would like to tackle the system from the very roots. For example, working with school boys and girls, talking to them about the offenses and so on. But lately, especially the Institute of National Justice is providing very good guides for the system. So we are trying, nevertheless, to exclude. We're trying still to exclude the so-called human factor, political influence upon future judges, prosecutors. So the laws are pretty good, but again, we will work, of course, take into account the political situation in the country, and depending on their attitude, we will be able, less or more, fulfill our tasks. We have very good bodies in the prosecution service, like boards of selection, board of appointment, and so on. And we should be able to guarantee all the rights. But again, sometimes our competence in the past was too large. I mean, we had to work also with the civil cases, which is not the case. Well, I think our disciplinary board, for example, should be rather transparent, should be more transparent. For example, the sanctioning decision was taken somewhere in the closed doors, and but it should be shared with all the other prosecutors, so that they would learn from the lessons of mistakes of others. That's why we need more transparency in the bodies of self-administration within our prosecution service. Thank you very much, Mr. Carmenton.
Mr. Adam, as you've said, as you've rightly said, I think you have plenty of laws in Moldova. So I wonder if part of the problem of corruption in the prosecutor's office is to do with the culture of the office. And I'd like to ask you, do you agree with that? Do you agree that there's a problem with culture? And if so, how would you go about changing the culture in which corruption can thrive?
Thank you very much for the question. I see the things like this. I will start from promoting and selecting the personnel from among the prosecutors. I would like to mention this. Before adopting the last law on prosecution service 2016, we had pretty weak guys coming as newcomers into our prosecutor's office. The problem was salary or income for that staff. But after adopting the new law and after substantial increase of our incomes, our salaries, salaries for prosecutors, I think following this increase, we should also change the attitude towards our discipline. We should try to diminish the situation when the persons are being hired within the system, but they are obviously weak, professionally speaking. We may use the specialized bodies which have been established within the prosecution service, and in order to get rid or to filter this kind of system and from the system. either through holding them liable, disciplinary liable, or through the exercise like assessing their professional skills, and so on and so forth. Thank you very much, Mrs. Botezato. Lately, half of the case files which are managed by the prosecutors are dropped on the phase of criminal investigation, criminal prosecution. In 2018, 1/3 of those cases have been dropped, according to official statistics. How do you see the unification of practice of dropping or seizing, stopping the criminal investigation, because they are stored in the archive and the society does not have the access to those cases? I mean, what kind of cases are they? Who is controlling those cases? How do you see that situation? Thank you very much for the question. Well, in my concept, practically in several sentences, and actually I wanted to develop the thought about unification of practice, I mean judicial practice, or criminal prosecution service, practice. You see, there are pretty good mechanisms already in place. In order to reduce the workload of the prosecutors, we just have to apply largely those mechanisms which are speeding up and increase the efficiency of our prosecutorial activity, like pleading guilty and other mechanisms which have been already established within our legislative framework when the criminal investigation gets quicker, or is quicker in case of plea of guilty, yes. Meaning that we have to apply them. We have to change our attitude towards some of the problems. Okay, within the court hearing, of course, we should basically submit or send only those case files which are rather complex or more complex, and the minor ones should be, I think, dealt with during the phase of criminal prosecution. Again, as I said, based on the, that's exactly what I wanted to stress. You see, it's about that category of case files which are being stopped or dropped within or during the phase of criminal investigation, meaning that nobody knows what happened to them. Well, once again, I admit the fact that most of the criminal case files, they're being reconciled. I mean, they're being settled through reconciliation between parties or plea of guilty agreements. And of course, here it's important to have the hierarchical influence of the Prosecutor General in monitoring or checking the activity of prosecutorial officers. Probably you refer to those cases which can be stopped, but they are pretty important. Well, of course, here we have to change the attitude. Perhaps you also refer to those kind of cases when the persons are being charged and they are being arrested, and nevertheless later on their case files have been stopped and not sent to the court. Of course, it's a deficiency. I mean, it's a problem. It's that is why it's a new task of the future Prosecutor General in order to check how the rights, legitimate rights of those persons are being observed. Not only those who are victims of those cases, but also how the rights of the charged person or indicted persons are being observed. And yes, if please allow me, yes, yes, in the context that you just follow up. Generally speaking, I think that you see, already for a long time in our prosecutorial bodies, we had a sort of competition between those who are investigating the criminal cases and those who are representing the state accusation in the court. So take into account that during the last 10 years, when I am head of the section on state accusation representation, I think we should change or adopted our attitude, our vision upon this. So So we should not so much focus on applying just the tough leverages, but also we should think about humanization of our criminal policies as such. Unfortunately, and let me just give one single example, because tomorrow or the day after, everybody may have the criminal record. You know very well that we had for robbery, very small robbery or stealing of 14 days, when somebody was punished for that small amount. But that is a law. I mean, this is already incriminated. We should humanize, we should diminish this kind of punishment, turning it into, for example, administrative rather than criminal punishment. So that's why we should focus very much on individualization of the criminal punishment. Some of the punishments are very tough, too tough, including the arrest-related sanctions. You see, sometimes the sanctions for stealing might be higher than for the attempt of murder, and then the person may say that, well, I would rather than dare to commit tougher crime than this easy one for which I am nevertheless punished. Yes, thank you, Mr. Bozan. Mr. Dam, your concept shows also the general strategy on expenses for long-term, for middle-term. And my question, as you as future potential manager of this prosecution service, what this strategy actually means, what's it all about? Is it about increasing the budget of the prosecution service? Maybe. And then if yes, which are the main area of focusing on which you would like to focus for this new strategy?
Thank you for the question. So the future prosecutor should have three main qualities. First, he has to be a good professional, given that he has powers provided for in a criminal procedure code as a procedural person. Now, he has to be a good manager who is managing human resources. He has to be a good manager who is managing assets. Now, how do I see this in my concept? So, not to exclude interference from politics. The Prosecutor General, when he develops the budget, he should look at the needs of the prosecution office, and then that budget should be submitted and discussed to the Superior Council of Prosecutors, which is the guarantor of prosecution independence. And then based on those activities, one would present the budget for approval for the orderly conduct of the prosecution activities. Of course, obviously, I should mention that lately, a lot was done to improve the prosecution in this regard. Let's say, you know, well, let me ask you one more thing. You said that you need an advisory body which should be created in relation to the Prosecutor General. What is this advisory body, please? Is it, I mean, do you want to create it, or is it there? And what should this advisory body do? Thank you for the question. It is not. The future Prosecutor General requires that when we go to a position, we think that we are the best. They tell us that, well, you're the best, and then we'll be at a loss without you. Look, how do I see this? It's like an advisory board with people which are very well known in society, and from former colleagues, because there are so many problems, there are so many issues, and there are acute problems that would require to be discussed at a coffee or at a tea. So that advisory board would improve the image of the prosecution general, prosecution office, because it would not be just about what the prosecutor general wants to hear, but they would discuss actual problems. So there are so many issues or problems in the system. In the past, we've had these joint meetings between prosecution and other institutions, law enforcement institutions. Thank you very much for that. A question from my side, for myself. Whether there were ever in your activity, or if not, or if you can fathom, if you can imagine, a situation when violation of law would be necessary or unavoidable. Violation of law. I've had this case. Well, but I've tried during my activity as prosecutor to be in full alignment with the law. In 98, 99, I was preparing an appeal, second appeal, and then there was some foreign investments in Moldova. To protect their business in the contract, they provided for a settlement not in the courts in Moldova, but basically, I think, in a tribunal from a foreign country, from a foreign jurisdiction. And then I was asked to prepare this second appeal, and they said there was no grounds for that. And because I said that so I prepared this appeal, and I said that I prepared it, but I disagree, and I said that the decision of the court was right. So the appeal was rejected by the criminal panel, by the civil panel of the Supreme Court of Justice, and yeah. Mr. Adam, I'm asking you this challenging question. Have you ever come across in your career a failure? Have you had a failure? Why did you fail? What did you fail at, and why? There are many failures in one's activity. Not one, but many. A leader should be able to listen and not to approve ad hoc decisions. I mean, maybe sometimes because of my nature, maybe I would jump in before a decision, and then later on, during the review, during my discussions with my colleagues, they would have influenced. Thank you. Thank you very much for the answers to the questions. That is it. Sorry, I have never been facing such a committee. Maybe I'm a bit nervous, but yeah. Well, colleagues, again, we have very good prosecutors, okay? And I don't want that the interference of politicians be so obvious as it was until now. With political will, everybody will do its own job. And I hope that the prosecutor general should be a very representative person, and so that everybody does their job. Thank you very much for that. We wish you good luck. Tudor Andronik, I have been in the judiciary for 23 years as lawyer, attorney, and judge. Why I tried to apply for this position? Simply because the philosophy of there's a philosophy that gives help when it is required. I've been in various positions. I've had attempts to give my hand to assist in order to improve the functioning of the legal system. I've worked in the prosecution for half a year, and then I worked in the judiciary in Ungain as a judge during 5 years. And in 2003, I was eliminated from the system for reasons I didn't know. They wrote that my mandate of 5 years expired. Well, then I realized that after a party came in 2001 who had a constitutional majority in the parliament, that very bad things were happening in the judiciary after that party came to force. And then I made some statements at that time, and I'm saying it to you not because I feel the victim of the system or I feel myself a hero. No, I believed, and I still believe, during 15 years from 2003, that at that time, the attempt of that party to make some reforms didn't lead to any positive result, because until then, we're seeing that from mandate to mandate of the parliament and the government, they try to reform the system. They keep trying. Now, when it comes to my concept regarding prosecution general, I believe that prosecution general has sufficient human capabilities to reform. I see this mechanism or this possibility that once you have a general prosecutor, who I believe should be a man of character, a man of intelligence. The poet Mihai Eminescu was saying that it's much easier to be intelligent for a month than give character in a day. You know, he has to be a person of character, and he has to start this assessment, this vetting of all subdivisions of the prosecution, both of specialized prosecution, anti-corruption prosecution, and of prosecution to fighting organized crime and corruption, as well as of the territorial prosecutions, by assessing the activity of those institutions, having at its disposal the prosecution inspection. A prosecutor general can, through an order, create a schedule and start this assessment. I don't know in the last 15 years that any prosecutor general who has been there to make an assessment of the internal situation in the prosecution general. Now, what would this assessment give you or give us? I think that it will determine what are the flaws in the system and in each and every regional prosecution or specialized prosecution office, and what are the performances of people. Because if you assess, if you do an internal assessment, then on certain categories of cases you would see why they didn't comply with some time frames, or why when a criminal case reaches the court, why it was acquitted, or it was seized, or terminated, or halted. But I believe that in addition, the prosecutor general should have as a priority the respect for human rights, fundamental human rights, and the European Convention should be the cornerstone of the future prosecutor general, but not only of him, but of the state in general. We each know that from year to year, the cases lost by Moldova at this age are growing, especially when it comes to preventive measures regarding arrest and the protection of property and fundamental rights, such as domicile, property, and person. And I believe that the Prosecutor General should, in cooperation with the Superior Council of Magistracy and the General Prosecutor and the Minister of Justice, they should assess the situation, and they should improve this mechanisms of protection of fundamental human rights. Can I go on? You can. Another aspect which I believe is a flaw, is a problem. I think we need to improve the mechanism of assessment of regional prosecutors. Regional prosecutors, if in the court, the chairman of the court examines a certain category of cases, then the territorial prosecutors, they only coordinate the activity of his subordinates, and they do not exercise criminal investigation on any case. And then, at the end of the mandate, he is assessed, but it's not clear according to what criteria he is assessed. So this mechanism, I think, should be improved at the legal level. Because being in a criminal case, in a judicial panel, then the prosecutor is there, and he was asked. The territorial prosecutor came to the court to represent accusation on criminal case, and he was asked whether he has recusals, and the prosecutor doesn't understand the word recusal. He was asked the second time, believing that maybe he misheard. He didn't understand the word recusal. All right? So you need to improve the mechanisms, or you need to improve the number of hours, because 40 hours for a prosecutor, I think maybe he's talking about training, I don't know, or credits. To improve, I think, yeah, it's ongoing training, 40 hours of ongoing training. I think that this is very little for him or her. But these training hours, or these training credits, they should be structured according to certain types of cases which they investigate. For instance, there are trainings where you have a number of people apply. Let's say those who are, and then you don't have enough places, and then he would go to trainings which basically he may not need. Not that they're not important, but he has a totally different specialization. What else I wanted to tell you regarding, if you can be very brief about the concept that I see to be implemented. This method of the prosecution, of liaising with the public, with the civil society, they have to do a better job in that. Prosecution doesn't have to be a closed institution. I understand that the peculiarity of the prosecution general, that in cases, in a criminal case, you have the secrecy of case, they're going to disclose certain data from the case, but in some situations, there are cases where you have cases which are of public interest, general interest. So, on some of the cases, the information could or should be disclosed to the public.
Thank you very much. Please allow me, I will be first for clarifying certain things on concept. I've seen that you focus on protecting the human rights as a priority in your program, your manifesto. So my question would be, well, practically speaking, how would you contribute to diminishing this trend of punning, excessive punishment of arrest? Yes, it's Article 5th of the Convention. Yes, indeed. That is on the level of the institution. We have to have very clear, transparent dialogue about applying this pre-trial arrest punishment. So on the level of Superior Council Magistrate, and the level of chairperson of the courts and the investigative judges, in cooperation with the Prosecutor General Office, Minister of Justice, we should see actually where are those drawbacks and shortages and why we have so harsh punishment. I mean, the pre-trial arrest, for example, I was seconded as an investigative judge, and I've noticed that indeed there are a lot of requests, a lot of motions requesting us to apply the arrest of certain persons. Many persons are left abroad, and they legally left the country without any prohibitions, without any kind of criminal record open on them. So if the person is out of the country in 3-4 months, if the criminal investigation starts, and the prosecutor is asking the judge, activity to apply the arrest, saying that the person is trying to flee from the country and is trying to avoid the criminal investigators. But then the logical question is whether the suspect was in a way subpoenaed or cited called to show up in the prosecution office. So in most of my cases, I used to reject this kind of arrest-related motion. So we have to improve this mechanism because, in my opinion, they apply successfully this arrest punishment. And by the way, how do you see? Yeah, the microphone is off. So you are saying that you are rejecting them, but anyway, what are the mechanisms that you would see? I mean, to avoid the motions of arrest as such. I mean, those ungrounded arrests coming from arrest motions from the prosecutors. What would you do? Do you have certain thought, a concept? Yes, you are right, that the person was not subpoenaed, but we have what we have. And so you, as a potential prosecutor general, what would you do with this aspect, which is actually also about the human rights observance? So how do you see it, shortly speaking? Well, I think that on the level of legislative level, lawmaking level, we should set out some norms, saying that in case if the prosecution office has certain relevant evidence showing that certain crime was committed, and by a certain person, then it is supposed to legally cite or subpoena the person, asking him to show up before the prosecutorial office. So, and at the same time, certain reasons are to be set out there that would exclude this kind of possibility. And this is to be done, in my opinion, by the lawmakers, so that to make sure that the prosecutors will not anymore file this kind of arrest motion. Maybe thinking about applying any kind of other measures where to investigate, to interview that person. Thank you.
I'm interested in hearing a little from you about how you reconcile the independence of prosecutors with the need for accountability. And I think you've already talked about vetting the prosecutors. Sorry, do you want me to start again? Yeah. I'm interested in how one reconciles the independence of prosecutors with the need for accountability. And you've already mentioned to us several accountability mechanisms. You mentioned the vetting of prosecutors, and you also mentioned examining cases which had been lost to see why they'd gone wrong. Do you see accountability as mainly an internal thing? And could you tell us a little more about what sort of vetting you have in mind, what you mean by that?
Well, in case if the mechanisms or legal provisions are clear without misinterpretation, possibility to have other interpretation made by the prosecutors, or I mean both for the prosecutors and for the judges, if the norm, if the provision is clear, saying that the arrest, for example, might be applied in case if some criteria are being met according to the Criminal Procedure Code, according to Convention, then we may find some reconciliation in order to improve this mechanism. You see, the Republic of Moldova for many years already is convicted many times by the European Court when we pay from the state budget enormous amounts of money. Perhaps misunderstood. Maybe the translation was not enough, or the question was not understood. You see, his question is about the following: how you may ensure a sort of reconciliation or balance between the prosecutor's independence and the responsibility or accountability or liability of those persons. Well, I think that they are independent as far as their procedural proceedings-related issues are concerned. So there she is independent, but if he is influenced in a way or another by the superiors or by third parties, then immediately he should disclose or denounce this situation, and the legislation is to be applied in this case. Thank you, Mr. Bocan. From from your point of view, do you think that the prosecution service is in a functional, operational condition, or there are some crisis elements over there? And I'd like also to add something. Do you think that for a good or functioning activity of the prosecution service, do you think that you will need to request some additional improvements as far as the legislation is concerned, or it's just enough for your concept of the management within the prosecution service? Thank you. Yeah, thank you too. You see any mechanism, any institutional structure always needs improvements. And of course, in any system, including the judicial system, judiciary, prosecution service, there are certain drawbacks, and nobody would dare to say that we don't have those kind of gaps or shortages. We all know what happened in the banking system, for example. We are citizens of this country, we pay taxes, we have parents receiving the pensions, which are very low. And of course, the mechanisms are to be improved. However, I am not a person who would say that we have to improve a mechanism or another one unless we are able to assess the real situation. I tell you that nobody in Moldova would dare to say that we used to have prosecutor generals who used to have already this institutional assessment. First, we have to make this kind of assessment. We have to subject the service to this kind of assessment, and then we should come up with a report so that the society would know what is the situation, the ruling parties would know about the situation. Nobody is opposing, I understand that nobody is opposing to any kind of reformation. At least I'm not opposing to changes, if they are positive, if they are reasonable, if they are well thought, and if they are bringing added value to the image of prosecution, to the society, to the expectations of our people, then I don't think that somebody should oppose. Of course, during the mandate of Prosecutor General, we have to assess the situation and to come up as a conclusion with some proposals, including law-related proposals. Yes, please. Who should make the assessment? Well, the inspection of prosecutors. The inspection of prosecutors. They are entitled to do this, and through an order, Prosecutor General may organize this kind of evaluation or assessment together with the inspection of prosecutors. I'm not against an external or outsourced evaluation, but you see, the newcomer, the Prosecutor General, having this inspection, he has already the possibility to apply that tool in order to highlight certain shortages. Thank you very much, Mr. Bobo. As a follow-up of this evaluation or assessment, how do you think to re-establish the so-called front controls? I mean, when you visit a prosecutorial office with a certain brigade or team in order to check or to verify their opinions. It might be inspectors, might be not, but so a delegation is going there, checking the activity of a prosecutorial office for the last period of 5 years. From scratch. So would you think about re-establishing such a mechanism, because it's sort of in context of this evaluation that you are speaking about? Did you think about this kind of mechanism? Well, thank you. When I say assessment, that is exactly what I mean. It is a front control, a direct control, unannounced control, on-site control of our officers. So that's exactly what I mean. In order to make assessment, one should make this kind of audit or control, of professional control, where to highlight the performance and drawbacks. I mean the regular regular front or on-site controls. For example, this month, according to calendar, we go to shoulder nest. This is checking them from scratch, verifying them from scratch. Next month in calendar, we'll have telenest prosecutorial office, and then we would draw our conclusions. So that is kind of mechanism that I was thinking about. I think it's positive. The idea is good, and when I said that we should assess each prosecutorial office, that's exactly what I mean. That's exactly what I meant. So together, Prosecutor General issuing an order, setting out a certain schedule for these kind of visits and verifications, and then inspection would help him out with this. For example, but it depends on the scale, size of that office. For example, in certain districts we have less or smaller and bigger offices than in others, so on. So we should set out clear terms, deadlines, and who is doing this, and so on. For example, what kind of issues are to be checked, like developing the indictment, this rates of success in courts and so on. So without this kind of criteria of verification, the assessment is empty in a way, because anybody may say that I did not understand what you are assessing. So certain criteria of evaluation should be set out from the scratch, from the start. So it should be done on regular cases, not that you didn't like some of it. Well, you see, we should check first. I mean, there's a basic, as a ground for this kind of assessment. We should see what are the reports, which are the statistics from different offices of our prosecution. Yes, well, we appreciate highly appreciate that you focus on assessment. But you see, as a potential leader of prosecution service, you already know, you have this concept that you have here. You have certain ideas about how this prosecution will operate under your leadership. So I would like to understand, structurally speaking, institutionally speaking, do you intend to change something? Are you going to intend to change something in this way, modus operandi of a prosecution service, or you should first subject everything to the assessment? Because by reading your concept, you said that we will make the annual evaluation assessment and the final evaluation. But actually, you see, which is the goal of this assessment? Because the assessment is just showing what should be changed in the prosecution service, or maybe you already, as a well-experienced person, have already this well-thought concept of what you are going to do immediately after taking the position. Well, as a follow-up of this idea mentioned by you, let us imagine hypothetically the consequences of this assessment. You would receive certain percentage, saying that certain percentage of your personnel are not complying with the professional expectations. So question, what would be then the mechanism taken into account the competence of the prosecutor general according to the law? You see that you should take into account the position of the Superior Council of Prosecutors. How then you would be able to select, to filter, to promote the persons as the prosecutors? Well, and so thank you. If, let's say, following certain evaluation, as I said, we would, again, starting with an order, having the schedule, applying the assessment visits during several months. I don't know exactly how this kind of assessment would last, but let's say that we, following this assessment, we see certain shortages or misconduct or even crimes committed by the prosecutors for a certain category of offenses. Then the prosecutor general have all the leverages, I mean, legal tools to initiate, to start criminal prosecution based on these materials grounds showing that somebody has a misconduct or committed a crime. Mr. Bobo, do you have an additional clarification?
Sorry, could I just ask you, would you agree that the existing culture of the prosecutor's office is part of the problems that there have been, and in particular has facilitated corruption? And if you do agree with that, how would you go about trying to change the culture of the prosecutor's office?
Well, thank you. The culture has to be changed by labor, diligence, and improving the professionalism of each and every one of prosecutors. It's not in vain that I said that prosecutor should continuously improve his professionalism by increasing those numbers of crediting hours and so on. And many other mechanisms. There are many other mechanisms I cannot now mention. You see, the prosecution is part of the society. I mean, each prosecutor is part of the society, is citizen of this society, of this country. And again, proceeding from the real situation, I think that of course, only by improving our professionalism would be able to change the culture of our prosecutors, generally speaking. Thank you. Well, you see that a great part of case files are being seized on the face of criminal investigation, prosecution. They do not reach, in other words, they do not reach the court and the judgment of the judges. How would you see how it is possible to unify, to uniformize, to harmonize the practices on these situations of dropping or seizing or stopping the criminal investigation for certain cases, because the number of those cases is pretty high? Well, first we have to set out certain to establish or to create a possibility of trainings for the prosecutors. Why? Because we would like to see the same solutions being applied to the same category of cases. So that is the unification. But what I mean, what about participation of the society in assessing the situation under which the criminal file was seized? Well, if there are some important, socially important cases, because if I'm talking about ordinary case like stealing the bike from neighbor, I think nobody is interested. But if it's a reason, I mean, highly, it's a reason. It's a case file of highly social importance. Then I don't see any problem of opening, let's say, this situation to the society. I don't have any problem with it being checked or verified by the society, including those who are reaching the court. Well, I know that there is some system of randomly distribution of the case files in the court, and they decided to publish, therefore, all the decisions, all the judgments that they are making. But we don't have this kind of system, so we do not publish, let's say. In other words, we do not publish our decisions. They are stored somewhere, but they are not made public. Also, I have a question to you. Question whether in your activity, and whether you had, or maybe you may imagine the situation when you had you've been in a situation when you had to violate the law. I didn't get it. Well, the question whether you had in your life some practical cases when it was unavoidable for you to violate the law, or you had the situation when the violation of the law was almost necessary. Yes, I'm ready to give you this example. In the case of a road accident, traffic accident, let's say that a person was wounded and has to be transported to the hospital, but the ambulance is in jam somewhere. And then the police says that please make it happen, transport it by your car. And I'm speeding up, I'm violating the trafficking rules. And then it's strictly necessary. Otherwise, we put in danger the life of a person. Thank you, understood. Thank you very much, Ms. Tatiana. I have also a question, another one. So if, let's say, you may recall, remind yourself about a failure in your life, why you consider that it was a failure. What was it, and what was the reason? Well, the biggest failure, in my opinion, was that in 2003, when they kicked me out from the system, at that time I've tried do my best to inform the international bodies, institutions like embassies, missions. At that time, I've met with the ambassador of Romania, actually with several persons from Romania embassy. I tried to inform them saying that it's not a problem that I or somebody else was kicked out of the system, but what is severe is that the person, when he is being dismissed or resigned, he should know at least the reason. He should be informed why he was kicked out. I've made some attempts, but finally nothing happened. It was a failure. I didn't end it up successfully, and I think maybe I was not insisting too much. And I'd like to say that ultimately there were some judges who died because of the stress they were subject to, because they have been dismissed. For example, Mr. Anton, they first after this they severely became sick or got sick and then died. So that's why I consider this is very important. And during our life, we should be more insistent. As a conclusion, we should be more insistent. Yes, Mr. Boțan.
You stressed the concept of assessment or evaluation, and we appreciate it a lot. Now, in your comments, you stated the high-profile cases. It so happens that the high-profile cases are somewhat connected to investigations as part of the special parliamentary committees. Now, the question to you is, do you think that the fact that there is this connection between high-profile cases and parliamentary investigation, is it telling us of a crisis in the prosecution system, or this is a normal thing? It's okay to be like this. And the question is, this prosecutor's evaluation has to be comprehensive, or you have to start it with this high-profile cases which have a larger impact on the image of the prosecution? Well, I think that, thank you for your question, by the way. I think we have to do this assessment in anti-corruption prosecution and the so-called specialized prosecutors, because the highest profile cases, most complicated cases, are in these two types of subdivisions. Now, we shouldn't assess it, select them selectively, because of course the budget of the state was damaged. Of course they siphoned off money from the banking system, but we shouldn't forget for a second that when they take over business, or when the person is forced to give the business away, it is of no less importance. I mean, we have to make them equal. X was taken off their property, or they stole money from the bank. This is equal. I mean, this problem, this assessment must be across the table. This evaluation must be across the table, because I think there are cases which are accumulating dust in the drawers, or there are cases when they would start them against certain people, you know, just to prosecute them. Of course, the government decision on investigation of the banking fraud is a political and legal document, and it has a political and legal weight. The legality of this has to be assessed by the prosecution and not by the government or parliament. But the case or this decision of the parliament will be sent to the prosecution. Okay, this parliamentary investigations, is this about interference in your work? I don't think that this is interference. As long as the parliamentary committee didn't give any orders to the prosecution to do certain investigations or to focus on certain people. This is just a political decision, a legal decision of the parliament. We cannot deny that. But at least I don't know from press or from TV or from mass media that these parliamentary committees, which are on the airport now, and Telecom, that they gave certain orders. I don't know of any. The MPs have an imperative mandate. They can say whatever they want during their mandate. Okay. I think we have exhausted our questions. We thank you very much for the time allowed. We wish you good luck. Thank you very much for listening to me. Thank you very much. Have a good day. Bye. Thank you very much for this opportunity. First of all, I'd like to mention that the concept is based more on the continuity of ensuring the continuity of the activity of the institution, and the focus is changing the perception of prosecutors on their responsibilities, because changing the institution without changing this perception is impossible. You will never have a silver bullet, an excellent remedy. Now, as a key priority is this change of the way the prosecutors discharge their duties, and how do they see their roles and their accountability. And not least, they need to understand that they don't do it just for their job, but this is having an impact on the way they are perceived by the society. So I've tried to reflect this in my concept. Now, when it comes to the technicalities of this, I will not dwell too much on those, because these are management aspects which are about organization, leadership, management. An important factor is the review of the way they are being assessed, but this is more of a prerogative of the council and of the bodies of the council. I mean the assessment and selection and career boards. I think in the concept I came with a vision that, first of all, it would be useful for the members of these boards to be seconded. I mean, there shouldn't be people holding positions, because it showed us such a big bias, such a big subjectivity in the way they assess and how they tackle, how they approach the assessments. Okay. Second, financially and from the management standpoint, I'm talking about the way it's organized. It would be better to merge these two boards, which consume time, not just for those who are members of the boards, but they actually make the prosecutors to go through two procedures which are almost the same. There should be a continuous process without having the break between the initial assessment of the prosecutor and assessment for a certain position. We would save resources as well, because the same seconded people would be responsible for the whole process of assessment, including to determine the capacities of the people for certain functions they would exercise. Now, one important thing that I've mentioned is that the interaction between prosecutors and society. I have this view, and this is to prove the webpage of the institution and to put there an online opinion poll that would allow people to look at the perception of the society, permanent perception of society regarding the performance of prosecutors. And here, it would be done not just for the organization of the activity, depending on the will of the person, but basically we would do it in order to identify the drawbacks, the shortcomings, and to understand the perception of society when we ask ourselves, how does a prosecutor interact with the simple person? How motivated is the decision? But the prosecutor must understand that even if he used all of his kit as a lawyer, sorry, as a legal person or as a prosecutor, they were not enough for the lay person. So it's not just about respecting the law, but people must understand that justice was delivered through the activities he's undertaken. One more important aspect, I believe, is the interaction of the prosecutors and the institution with the politicians. This is a subject which is high on the agenda, and it has always been affecting the activity of the prosecution. So here it is important to establish the clear rules, not just to establish the clear rules because they are in the law, but I'm talking about how are they ensured by the prosecutors, by the prosecution. I mean, independence of prosecution from any interference. It's not just a pure declaration, but this is something which needs to be respected. Independence to any political interference, and at the same time, there has to be an interaction based on the principles which allow us to keep the security of the state, certain interactions regarding the management of resources. So generally, I am of the opinion that the prosecution must be, to the extent possible, independent, without anything which would cause some people think that this institution can be influenced in one way or another by the executive or by someone else. But generally, the concept is based on changing the vision for the prosecution. Even if you appoint an exceptional prosecutor general, trust me, I come from the inside this office. If people will not follow him, and if they're not going to change their mentality, then they will not be able to change anything. So here is important to talk about training a bit, or education, because little is done in this regard. Because even though we do professional ethics courses, we need to focus prosecutors on the need to comply. And I'm not talking about simple lessons, say, well, you comply with this code. No, you need to show them with clear, practical examples from mass media, from other areas, that the prosecutor doesn't have just to be trained and simply trained, but he must comply with the ethical norms, ethical norms. So that is in general my comments on this.
Thank you very much. A clarification question to the concept. Would you support this idea of claiming the status of magistrate? If yes, then how high independence giving to prosecutors go in line with the accountability of them? Yes, I'm sorry, I skipped this very important element, which is receiving this status of magistrate. It is a safeguard for changing the vision of the attitude of the prosecutor, because it's like laying the foundation of the whole system. It's important because then it would be perceived not just an employee with some bosses, but will be really perceived as having real independence. So having the accountability, you said, well, it is valid all the time. It does not matter whether we speak about judges or prosecutors. I mean, the magistrate and the accountability are not separated. And then any kind of intervention should be made based on the conclusions of those discipline boards. They should continue the activities. But again, I'd like to see them more independent. They also mentioned about the fact that this collegial self-administration body, which is the Superior Council of Prosecutors, should take over under their subordination the inspection of the prosecutors, and then and only then this disciplinary misconduct would be subject to the activity of this inspection, and the corroboration, and then we'll have a very good corroboration between the status of magistrate and the accountability. In my opinion, at least, they are compatible and they go online.
I just like to explore this a little bit more, because this tension between independence and accountability is very difficult and complex. You're talking about making them magistrates, which presumably means then they will have individual independence. But how do you reconcile that with accountability, or are you speaking only about people being accountable for not allowing political interference or not taking instructions from outside? In other words, how will you evaluate the quality of their work, or are you only going to look at questions of whether or not they are really independent and exercising their own judgment when they make decisions?
I don't see it like an approach depending or based on the results, meaning that let's say we have a violation of the legislation, then we have a notification about a misconduct, let's say, of the magistrates, and only then we would interfere. No, I'm speaking about those ongoing, continuous assessment evaluation mechanisms. We have them in case of the judges, which should be enforced properly, and we have them in the case of the prosecutors. We have them, but you see, they are even in separate institutions. They are the same, but created for different systems. So what I mean, it's a continuous evaluation of the activity undertaken by the magistrate from one point, from one moment to another. So these kind of assessments should be based on criteria like observing the legislation, integrity of the person, impact of the impact of the decided decisions on the human rights, or the linkage between these two. All these assets might be highlighted within the assessment. And of course, the magistrate, by having this kind of, by being subject to this kind of screening of his activity, should increase his responsibility. And that is his own sort of accountability. That's his own responsibility, because he has this kind of the magistrate status. It means that he should comply with this status. And then, of course, should be also assessed by exterior, I mean, by those disciplinary boards and so on. But what's important is to make sure that this assessment is made up of the same profession, the same professional personnel, including the representative of the civil society, who should be sort of watchdogs in order to identify those misconduct. I hope I've answered your question. Mr. Bulat, proceeding from the situation, from the fact that the Prosecutor General, including the Prosecutor General Office, so the Prosecutor General is the only person in the state with the right to prosecute, I mean, to carry out criminal prosecution. Of course, there are some other bodies as well, but the General Office is basically the only one giving this kind of right. And you are representing of the state accusation, so you are the charging ones. You have those two main competences. There are sort of other extrajudicial things, but they are different. So, criminal prosecution is done based on the police investigation, and it's finalized with indictment. And we know very well what kind of quality is this criminal investigation. And we also know that those the result, the outcome of the investigation which is given to prosecutors is also not of the best quality. So prosecutors is signing this, and then he represents this case file in the court, I mean the prosecutor. So how would you see the possibility, how it is possible to increase, to improve the quality of the criminal investigation and criminal prosecution? You know certain things from within, you know the reality very well, and you know what is the level of that quality, I mean the criminal prosecution quality. Do you see, do you have some concept, some key solution where to improve that quality? You see, you are aware, you know, is that the courts ultimately will change their attitude, and a lot of indictment will be rejected, or at least they are weak. And how to improve this weakness, how to actually to turn weakness into the strong point. Thank you very much. Indeed, it is something realistic, and unfortunately, it is this situation for many years. I see that criminal investigation is quite is a little bit wider. The final point being in the court. The criminal investigation is very important because it lays the foundation of this judicial process, but the final point, of course, the court. That's why I'm pretty alarmed when the prosecutors are going to the court with very weak and complete case files. Several years I was prosecutor representing the cases in court. I was also the regional prosecutor, so I know how it is to feel to go to the court with a case file which was prepared by another prosecutor who superficially was doing his job. But speaking of the quality of criminal investigation, that's not just about the fact that say that someone is very well trained. No, you see, they have sufficient number of trainings provided by the National Institute of Justice, outside of this institute, so on. So first, I think, in my opinion, we should reassess the workload per capita of a prosecutor. It is, if it's exaggerated, then the quality, of course, is suffering. You may imagine the prosecutor may have 40, 60, 70, up to 80 case files per month. In a month we have less days, and then even take into account the weekends, of which we tend to forget because we have to comply with the deadlines according to the procedures and with workload. That's why you start doing from this. I mean, to review, to re-examine, to reassess the workload and distribution of those case files throughout our offices. For example, somebody is dealing with something which is not prosecutorial. Somebody is dealing with less number of case files. Well, that would be the starting point, because it's not always that the prosecutors are to be blamed for this quality, but actually the task is too heavy, the burden is too heavy, and sometimes they have to fulfill something that is not in compliance with the law of our prosecution. The alarming warning situation is within the specialized prosecutorial offices. They have much more complex case files with a lot of defendants, with applying the special measures of investigation, and the efforts is much higher compared to others. The territorial officers also received a higher workload as a result of changing the competences according to the Criminal Procedure Code. I'm speaking about those criminal evasion, tax evasion, crimes, smuggling, and so on. So they have been resubmitted or redistributed to them, meaning that they've created an additional burden. And of course, people had to be adapted to this additional burden. But again, as I said, I would start from reassessing the workload. At the same time, what's necessary is to improve the interaction with the criminal investigation bodies, I mean law enforcement bodies, the police bodies. It's not just about, as a result, that we have the weak case while being submitted to the court. Actually, they receive it in a very weak quality from the police. And I recommended to the students within the National Institute of Justice, they should therefore plan very well their activity. For example, what I mean, at the initial stage, when the criminal investigation just starts, when the prosecutor establishes certain deadlines or the criteria, at that time they should develop a realistic, not promised, but a realistic plan, schedule, what and when should be done, should be executed. And then it's much easier for the prosecutor to organize the management of his case files, because he would not ever and again reinitiate the review of the case file. He will rather continuous activity. So it's the second phase after reevaluation, reassessing the workload. What we lack is a good management, and making these calendars for the case file and so on. So the management, when I say management, might be management focus on the case files, on investigation. It needs very good planning, depending on the resources and tasks set. You've mentioned in a way or another the relationship, relations with the political bodies, let's call them. But how would you prepare to exclude the interference of the political factors into the activity of Prosecutor General? Let me exemplify. Somebody is chairman of the district and he does not like the prosecutor. He doesn't like at all, and somebody stays behind him. What would be your reaction? What would be your action as Prosecutor General within your competence, according to the law? So it's a real conflict situation which was created in the district. The one does not like the other. So he is asking you to kick him out. What would you do? Okay, I'd like to ask you, are you asking how would I react as a Prosecutor General or as that district prosecutor? No, as Prosecutor General. Yeah, I wanted actually to start from other thing. It's not just about the problem of the Prosecutor General, how he should react to this situation. First, I would not react to the first request. You see, I'm not the one who is dismissing the prosecutor. If the prosecutor violates legislation, indeed violates legislation, and that was it was done when he was holding this position. First, we should verify the things. We should see whether indeed it is truthful. I could not react to the well-wish of anybody from the district. Of course, I would listen to this information, but I should not immediately take some reactions like dismissing, kicking him out of the system. Secondly, I would assess not just his professional abilities or skills, but also his behavior, conduct, because there are some individuals who are behaving in different ways, like arrogant or less arrogant, or I don't know, authoritarian way. For example, somebody would like to show that he has the authority and he should dominate this district and not the other one. All these are to be analyzed, at the same time taken into consideration when we assess comprehensively the session in the district, because the prosecutor is also the chairman of the district. The prosecutor, for district prosecution, is also responsible for what happens in the district. So again, let me rephrase. I will take into account of this notification, but I will act only based on legal foundations. So if, for example, I would see that he lacks, in my prosecutor, lacks competence or integrity, or for example, he is ethically misconducting, then of course I would use the leverages of that belong to the Prosecutor General. Thank you.
Yes, I just want to ask you something about the culture, changing the culture of the office, which it seems to me, as an outsider, it needs to be changed. And I was pleased to see that you mentioned the need to change mentality, but you seem to suggest that could be done by more training. I mean, surely when we're talking about corruption, people know perfectly well what they're doing is wrong. They don't need complicated training to tell them that they are not to take bribes to influence a case, or not to receive gifts or anything of that sort. So how would you go about changing the culture?
Speaking about anti-corruption measures, or the so-called integrity measures, we have a legislation in this regard. It's so-called integrity-related measures. And we have everything there, starting from the verification of the declarations, or verifying the activity. So speaking about the integrity, it's not just about, let's say, being corrupt. Lacking the integrity actually starts from the quality of that prosecutorial activity of that individual. This creates the foundation for potential exposure to corruption. That's why I would tackle it in a rather complex way. So it's not just about punishing somebody, but looking at this comprehensively. And of course, the court should be harsh, very harsh, for applying those kind of punishment, because it shows how important important is this for the society. But again, we do not want to discriminate them compared to other corrupt people. And the culture should be changed, not only based on training, education, but of course based on some activities, concrete activities. For example, by correct and fair assessment of them, by appreciating those who deserve to be appreciated and promoted, and not just because they are loyal to the boss. So they should be really appreciated and really promoted based on the appreciation, professional appreciation that should be given. So all these taken together should be changed by trainings, well, through trainings, through assessment, appreciation, and sanctioning or punishment. So these are the three basic pillars. Without them taken together, we would not be able to reach good results. So training, because they shouldn't be able to say that they didn't know. Assessment, whether or not it was well. And sanctioning, proper sanctioning. So pretty harsh, I would say, not just making, warning sort of conditional, let's say, punishment. No, punishment should be a real one for this kind of actions. I know that maybe I'm too radical, harsh in saying what I'm saying, and maybe some colleagues would look not with good eyes what I'm saying, but I used to tell this even before to my colleagues. I was always adherent to this kind of accountability. So in case if somebody is identified in committing this kind of crime, he should be held liable without any excuse. Otherwise, we'll not be able to change any corruption-related things. But again, corruption and integrity is not just about taking money. It's much deeper. Please allow me a clarification. You said punishment. Let us imagine the situation when, again, the Superior Council of Prosecutors is not accepting the proposals coming from the disciplinary boards and ethical boards to sanction someone or to assess someone's activity. What would you do as Prosecutor General as a consequence? Because the Council says, no, we don't see any ground to sanction this guy. And moreover, different to follow up in the same context. Let's say you will be Prosecutor General, you would like to create a good performance team, you are coming up with a proposal, you think that X, Y, and that persons working there here should be promoted, they deserve to be promoted in certain positions, and then you again are facing this opposition from the Superior Council of Prosecutors. What would you do, taking into account your competence? Understood. So first, let us forget the Prosecutor General is not God, is not the God. The Prosecutor General is limited in his competence. He has absolutely different kind of competences and functions, and the justice system as such actually provides for those self-administration mechanisms, which is called Superior Council of Magistrates, Superior Council of Prosecutors. They have a higher role, much more important role, the Prosecutor General role. And here we should speak about the quality of activities of the Superior Council of Prosecutors. A lot depends on those who are elected within that body, self-administration body. Of course, Prosecutor General, I will behave similar to the way I behaved as a prosecutor, regardless of the position I will have or not. I always will, I would say that I should insist on sanction in case if somebody committed a misconduct, regardless of that position. But again, let us not confuse. The Prosecutor General is the manager of the institution, but he is not superior body of that institution. That's why, again, I would guide myself. I follow the legal provisions to notify, to react, and so on. But I think nobody would be able to be resilient before the well-grounded notifications or report coming from those two boards. But again, this is a collegial body, and that's why we should convince not only the Council, but also the whole body, the whole institution of prosecutors, that the person has to be punished because he undermined, by his misconduct, he undermined the image of all our institutions, and he actually, and each of the prosecutors will feel the consequences of this, because the citizens will remind them about the misconduct of of saying that the whole body of the prosecutors as bad as Popescu or Ionescu. So that's why this kind of well-reasoning, well-grounds of the notification report should be done not only for the Council, but also for the rest of the institution, because they have also a word to say in electing those members of the Council.
Thank you. Please. Mr. Bulat, you mentioned a very important principle in the management, potential management by you of prosecution, the principle of continuity. At the same time, your concept provides for the development of a new strategic development plan because the current one expires. Now, you focus there on modernization of the institution. 3 years have passed since the new approach has been adopted, the new laws have been put in place. Why do you need modernization? Is this obsolete already? Is the current one obsolete already? Please develop your concept of modernization. Modernization actually covers two dimensions. First of all, we're talking about the development of the e-case system, which with very difficulty was accepted by the prosecutors, was highly implemented, because there you have a full reflection of the paper-based case is now in the system, and it makes them disciplined. There is accountability and control on the time frame they have to comply with, activities that they have undertaken, the case flow. Moreover, the system keeps track of who accessed that case, which prosecutor, when and how. So my wish is to develop the system further. Moreover, this system must be mandatorily be connected to the system from the courts. You know, the insurance system in the courts, and we have a good experience in the Baltic states where the prosecutor can submit those documents for authorizations from his office. Now, currently, the prosecutor from Botanical Weekend must run to courts, in lose time, and then there's an additional task on the judge and the prosecutor. So the modernization of the system and the ensuring interaction between the system from the prosecution and the court would allow to submit online these documents. Unless you have participation of parties, and that would really expedite criminal investigation and would reduce the burden, because the prosecutor will gain more time to dedicate to the case and investigation. Now, another important aspect of that is the utilization of the software, analytical software, and now already have them implemented in the concept. I've written that we started to implement this with the support of the projects, with the support of the US Embassy and the European Council of Europe, and we've created those analytical subdivisions which were given to us as a gift. I mean, well, not gift, well, donation, sorry. Donation, not gift. Not present, it's a donation. It's the donations of software and equipment necessary to be utilized in our everyday work. It means that the cases, the complexity of the case will be assessed through the software, which assesses the multiple connections, transfers, banking transfers, wiretapping, linkages between many people internationally. This software is connected to the current databases about people, tax, customs, vehicles. So that is the future. That is what I'm opting for. That is what I'm striving for. Now, whoever becomes Prosecutor General will have to take this into account, because it's not just a commitment, but this is a need for the institution. One more comment. Your concept on the prosecution management, does it mean that you will be making changes to the laws, or the existing legal framework is enough to conduct your activity successfully? I think that the existing framework, legal framework, is enough to conduct some of the activities. Maybe some of, well, maybe there would be made some tailoring and adjustments. Look, at the end of the concept, I talk about merging the powers of investigative officers and criminal investigation officers. But even though this is an area which refers more to the activity of the investigative body from police or from the NAC, well, still it has an impact on the activity of the prosecutor, and I'll tell you why. The prosecutor creates criminal investigation groups. Do you include their criminal investigation officers, investigative officers? Now, investigative officers don't have the equal powers with criminal investigation officers, and here you have certain differences, here you have certain delays. And if we come back to the issue about optimization criminal investigation, now, so that unification of these two functions, criminal investigation officer and the investigative officer, would be good. Now, when it comes to the legislation which regulates the activity of the prosecution, I think it's enough. It's just that we need to roll our sleeves, change the vision, and to go ahead and apply the law as we should do it. Okay, I understand your question. Your answer. Your concept provides for a review of the powers of the anti-corruption prosecution. Is it possible to do it without changing the law? Well, some aspects are already ongoing. They're ongoing. I don't know if in the next strategic development plan they will still be included. We tried. Look, the problem of the anti-corruption prosecution is that they have too large powers, and that they have a big load of criminal cases. Now we've tried that some of these cases to be transferred to align with the companies. They could submit it to another body to conduct criminal investigation activities, but there is already a draft to reduce their burden, to reduce their powers. Well, it depends on the highly esteemed Ministry of Justice if they want to promote it further. From me, a question: how do you see the unification of the practice regarding cessation of criminal investigation, of cases at the phase of criminal investigation? Because we know that the percentage is very high. That's one. Two, there you have big risks, big corruption risks. Are you talking about unification of practice to not to classify but to seize? Yeah. Yes. Yes. This area has and will always be in the loop of the prosecution general. Prosecution general, regardless of the number of people which will stay in this institution, their task is to unify the practice, the case law. And here I agree with you. We have to assess and create an additional methodology, not just to what the prosecutor should do, but also to assess these cases of cessation. Maybe you know, but the prosecution actually every year is verifying these cases. There is this practice of verification at the end of the year, and we request them after the approval of solutions, and we check them in order to come forward with the solutions to unify, or solutions for the prosecutors. What about this assessment? What about involving in this assessment representatives of the civil society? I have always been open to cooperate with any institution or representatives who have access to certain information. When I talk about seized cases, we cannot talk about a final solution on the case, because compared to sentences or compared to government court rulings, when we have a cessation of the case, can also reinstate the case. And here, representatives of the civil society, I don't know whether they could intervene, just because there's a difference between the situation in court and the situation during the criminal investigation stage. Now, in terms of mechanisms of control, civil society, on these particular cases, I don't think procedurally, they could not intervene. And then there will be complaints from the parties regarding whom or the decision is not final. Now, we've tried with the representatives of NGOs, we've tried to analyze human trafficking cases, and then we had discussions. We've involved also the IOM, and we realized that this would be a correct intervention. Well, I agree with you, but in this case, we would presume that we don't trust the activity of the prosecutors. Just like with courts, the cases have a final ruling, take them, examine them, no problem. The same situation was about arrest warrants. The arrest warrant, I mean, we agreed we would have NGOs or international projects which would assess the cases from the courts, which are archived, which have gone to the whole judiciary procedure, and then we cannot influence this anymore. And then we could have, intervention from outside, but the involvement of foreign experts to assess the results of the assessment, that's one thing. That's another thing. About the arrest, there was this draft prepared, and then they came with some assessment mechanism. They recommended of how the prosecution should assess, and then they've taken Moldova as a pioneer country. How would you assess the efficiency of participation of prosecutor at the warrant arrest? Arrest warrant. They've looked at the cases from the archive, and they said, well, this is the method proposed by us. We will improve it, and then we will apply it in other countries as well. Let me play the devil's advocate here with some more more sensitive questions. Now tell me please, whether ever in your activity, or if not, can you imagine the likelihood of such situations when the violation of law would be imminent, would be necessary or unavoidable? In my activity, where I violated law. Well, situations where you cannot avoid, it's an unavoidable, or it is necessary to violate it somehow. Button. To avoid or not to avoid, it depends on the behavior of the person. Or the situation would always lead to whether you accept or you don't accept something. But, I've always tried to apply the legal avenue because it's easier to justify. You know, we had Mr. Kirtoaka. No. Mr. Kirtoaka, the former mayor. When we were, no, sorry, not former mayor. Sorry, it was a prosecutor, old prosecutor. When you don't know what to do, do according to the law. Okay, that is how I go about it. Since integrity of candidates and of the future prosecutor general is a separate topic discussed in our society, there were information in the press about certain aspects related to potential interests and assets of yours and other candidates. Can you could give an opinion about this. Could you? We've noticed from the information that was published. Yes, it's about real estate and your cumulative income from 2002 to 2016, which from the first glance do not cover your loan contract from 2011, which until 2015, and then you've contracted 2 more. Your cumulative income doesn't cover these 2 loans, or the 2 loans. Well, yes, there was some information that I didn't hide, and I communicated to reporters that called me. I explained them the situation, explained them from where and how. This was a decision approved in the family. My sister is in Italy for many years, and she is married, and she is a citizen of Italy. This was a solution because it was a good opportunity. There was this possibility to get this apartment from 2000, no, from 94, I've been employed, and until 2017, I lived in Krulin, where I have my apartment. And I have an apartment in Krulin, which I'm now selling. Now, I've been traveling Chisinau, Krulin all the time by bus, by car, by bus, by car. It's a regular bus, regular car, and this was his decision in the family. It would be good to contract this, sorry, to take this apartment, and then we'll see how we will what will be the way of recovery. Well, that is more of a it's a family solution, and my mother is already quite elderly, and then we were thinking of getting all of us getting to Chisinau because hospitals are there and better. I've never had any other real estate, and I don't have it. There's interpretations about me having. Look, I have this apartment in Krulin, and I have this apartment which was given to the prosecutors when we had an opportunity to buy apartments somewhere else. I've never accepted that, no. So I'm explaining it to you. These were the amounts that I've borrowed from my sister, which I paid for this apartment. That's it.
Mulțumesc mult. Da.
Thank you very much. Please. In your concept that you've submitted to us, you talk about the need to corroborate the judicial map and the judicial prosecution map. Yes, we have a problem in Nisporen and Unge. And there is a big problem in this regard, because we have the court in Ungain, the prosecutors have to travel, and then there is another need, maybe in case of Dubasar with Krulin, which would also mean a merger. But the biggest problem is Nisporen Ungain courts, because we don't have one in Nisporen, and then prosecutors have to travel to other regions. We've tried. I mean, the prosecution has to match the districts, because this is how we interacted until now. And then the citizens would continue to come with complaints to prosecution office. It would be good to cover the whole district, but not subject to the court. But we see that in some districts it creates some difficulties. And we want to have a unified system. At the end of the day, you have to have a uniform system. Either we change it the judicial map, or we adjust our own prosecution's map. For that, you need to change the law or not, or the prosecution has the powers to do it. Less so. In terms of legislation, we have a parliament decision which provides for the distribution of courts. Well, I understand what you're talking about, because I said that we don't need to change the law, but I talk about more radical things, maybe. I don't see that we need to change the law in this regard. As you saw in my CV, I've also been part of reforms and policies. Mr. Bulat, from your professional activity, can you identify a failure? Why do you think you've had a failure? And how would you do different this time? Failure. Maybe I wasn't convincing enough when we've done the reorganization. You know, the activity in the area of fighting human trafficking. When at the national level they've created that team which had a very efficient interaction, and here I'm talking about the activity which would cover assistance provided to the victim, prevention of trafficking activities, education, criminal investigation, trial, and this was this team which would lead the whole process from the beginning till the end. And everything was transparent. That was a need. This was done. And at a certain point in time, this mechanism was destroyed. It was split into many segments. I'm talking about reorganization of the prosecution. I'm talking about less focus on the activity of the human trafficking center, sorry, Center for Fighting Human Trafficking, and other flaws with the coordination. And I think I wasn't convincing enough to insist. Well, the only thing I was able to do within the limit of my powers at that time was I was able to maintain the specialization of prosecutors in the area of trafficking human beings. And probably this more or less contributed to the fact that we have kept this activity at, not at this high level, but at an acceptable level, even though we have positive evaluation. But we must acknowledge that there's lots of things to do. I think this was a failure because we, from 2008 until 2016, I was part of the anti-trafficking institution area, and I've done a lot to elevate it to a very high level. And then the reforms have killed this anti-corruption unit. Sorry, anti-traffic unit. Sorry for that.
Vă mulțumim foarte mult
All right, thank you very
răspunsul la
much for
întrebări și
that,
pentru
for your
discuții.
answers to the questions.
Dacă nu mai sunt
And
întrebări, vă
unless
dorim
there's
succes,
any
o zi
other
frumoasă în
questions
continuare.
from any one of you, we wish you good luck
auzim
and
bine.
success. And all.
I would like first of all to introduce a new member of the committee whom you didn't see, according to the information published on the ministerial website. Is Petru Bobu. He replaces Mr. Postovan. The second thing, shortly, how our discussions will be going on. First, you'll be given a little bit of time, like 7, maximum 10 minutes, to introduce the most important aspects from the plan that you were proposing, and we had the opportunity also to analyze and read it. That will be followed by a range of questions from us, and the other moment, organizational one, once Mr. James Hamilton will speak to you, please don't forget to use headphones. Thank you. Now you have the floor. So, Mrs. Chairperson, members of the committee, thank you, and congratulations. Good luck to you in this exercise. I think it is sufficiently important. Of course, it will stay in the history of the Republic of Moldova as an important one. So, in this context, I would like to wish you a lot of luck. Well, so speaking now about the concept, management concept, and concept on the management of the prosecution service in 2010-2026, briefly again, I would like to speak about my own opinions, which in my opinion, is very important in order to develop further on this institution, to recover, to rehabilitate the image before the society, but also for our operational activities provided by Constitution and special laws. So, initially, in introduction, I referred to the background or history of our prosecution service, where it comes from, in Bessarabia, the Republic of Moldova. And then in the second chapter, I speak about the analysis of the current situation. I've made here the references to the recommendations, most important recommendations, which have been adopted by the Consultative Council of European Judges, the opinions, the advisory opinions of the European Community of Prosecutors, which means basically that the prosecution service in the Republic of Moldova knows very well and used to know very well these recommendations, the content of those recommendations. But sometimes certain gaps have been committed and failures have been committed, which have been manifested usually through the disagreement of our society regarding the activity of our prosecution service. I've also made some references to the prosecution as a system. I mean, the composition, the structure of that body. And also I was speaking there about the fact that it is composed by the Prosecutor General Office, Secretarial Office, Specialized Prosecutorial Offices, and then later on in the chapter number 3, I've made references to a short list of deficiencies which does exist as of today, so we still have those gaps today. In this regard, we are now confronting the situation, we're witnessing the situation when we lack sometimes professionalism in this entire institution, lack of performance, and sometimes even lack of responsibility, lack of legality, objectiveness, and so on and so forth. And to this end, I proposed to re-evaluate, to reassess those aspects in a very short time. I've identified also some internal drawbacks and external shortages. I've made the references to some of the details, not all of them, but some of them, what and how should be undertaken, what kind of measures are to be taken, which is a must for further recovery or improving the situation. The following I mentioned here, unfortunately, may see quite often the Article 5 of the Convention is not being observed, which is about pre-trial arrest or depriving somebody of liberty. As of up to now, Moldova has 74 conviction cases for violating the Article 5, which is freedom of human being. In my opinion, it's rather detailed about the quality of analysis to be undertaken in order to avoid such a violation of human rights, regardless of who they are as status in the case. I'd like also to tell you that for almost 2 years, I am a lawyer and a defense lawyer. And I used to work in different districts with different prosecutors. As a defense lawyer, I've noticed even higher number of gaps or shortages. When being prosecutors, I was not aware about this. For example, the prosecutorial interference into the civil relationship, especially, for example, when we have already the final court decision, and nevertheless the prosecutorial bodies are still jointly with the police are still undertaking some investigative related activities, although we have already final court decision. So as professionals, you understand what might be the real goal of those kind of additional investigations, parallel investigations. And also I've seen a lot of cases when the investigations were not efficiently carried out. You see both the national, international, domestic, including the case law of European Court of Human Rights, it commits our, it imposes a positive obligation of our state to undertake everything necessary in order to find out what actually happened and not leave uncertainty to be above the parties without that kind of understanding what happens. At the same time, all these deficiencies or gaps, they may lead or generate some charges, the content of which is absolutely abstract by nature. They are far from being in compliance with legal norms which are imposing upon the prosecutors to issue the indictment, showing the answers for all the charges they are bringing against a person. At the same time, not perhaps, but for sure, not only the Republic of Moldova, many other states, the phenomenon of corruption is one of the most important idea and direction to be undermined and to be punished and to be counteracted. In this context, we all witnessed already the situation when the authorities, the courts, by convicting a person charged with corruption, they used to apply some sanctions which are pretty symbolic by nature, such as fines and so on and so forth. At the same time, we know very well that even from the definition of the criminal punishment has the goal of re-educating not only the guilty one, but also the whole society. And here again, I may see sort of passive attitude from the side of prosecutors, I mean the state accusation representatives. And of course, in these situations, we may imagine what kind of role this such punishment may have. I mean, this kind of passive or lack of action attitude, or attitude without real punishment. Another chapter is about our so-called strategic goals and targets. Here, or under this chapter, I deal with the following. I am proposing here some steps to be important to be undertaken in order to reach the main targets or goals, which are dealing with the guarantees or safeguards provided to each person, each citizen. First of all, we have to ensure the real rule of law and observance of human rights. At the same time, it's necessary to guarantee the independence of the prosecutors. We need to cooperate better with the legal institutions. The constitutional competences should promote the fairness of the legal act, and also we should implement the best practices regarding the prosecutorial activities. We should ensure the transparency of the Judiciary Act by improving the mechanisms of communicating with the public in order to increase the credibility, trustworthiness for the prosecutorial body in carrying out the so-called Justice Act, and also we should improve the personnel-related policies within the prosecution service. Also, we should use better the IT devices, IT tools in our own activities, taking into account that all the scientific areas are continuously developing, and those kind of mechanisms proposed by them might be applicable within the prosecutorial office in order to increase the efficiency of our activity, of course, maybe by adjusting them to our needs. At the same time, I propose also something related to ensuring better working conditions for the prosecutors and auxiliary staff. I would like to focus a little bit on some of them, if please allow me. It should be done very briefly because 10 minutes are done over. Because members of this committee, of course, they will have some additional questions on for clarifying better the concept that you are talking about. Well, just additionally, I'd like to speak something additional to the concept that I've written regarding the management of in-prosecution service. I would like to inform you that actually the content of the deficiencies, the content of the proposals as follow-up to this concept, they are just a general part, or a short list of all the needs that are actually necessary to be implemented in order to develop further one and to improve the image of our institution. You see, indeed, in my opinion, prosecution service is one of the most important institutions to ensure the observance of human rights. Moreover, in my legal experience, I also used to work as a prosecutor. That's why I care about this profession. I care about the prosecutors. I know that they work day and night. Day and night, there are many prosecutors who are very competent, responsible. However, some or a certain small percentage of them used to have certain question marks when it comes to their integrity. They should be eliminated like an antivirus in our PCs. Thank you very much for your attention. I'm ready to listen and to answer to your questions regarding the prosecution service as such. Thank you very much too. I have a first question for clarification. You mentioned the concept, and right now when you're presenting the question, you referred to ensuring the integrity of the prosecutors. Would you please tell us more how you are going to do it? Well, thank you very much for the question. First, according to the decision taken by the Superior Council of Prosecutors last year, they created a permanent standing committee on training the prosecutors. According to the rules of procedure of this committee is competent and is dealing also with the professional training, but also with the verification or checking the information, the notifications about the integrity of prosecutor's integrity. We know very well the current structure of the Prosecutor General Office. There we have the inspection of the prosecutors, which is supposed to deal with one of the main duty of this institution, which is dealing and examining, reviewing the notifications about lack of integrity or misconduct of prosecutors. Those activities were undermining, actually, diminishing the integrity of any prosecutor. Moreover, we have the specialized anti-corruption prosecution office. They are also obliged to criminally investigate such an allegation. I'm very sorry, but I understand very well the mechanisms. We do have mechanisms, but they have been not functional, or they have been not as efficient. What would you do as Prosecutor General to make sure that this mechanism would be indeed efficient? How would you ensure this kind of integrity of prosecutors? Okay, thank you for clarification. Yes, speaking about those details, I'll tell you as a lawyer. So my answer would be this: if or when I would become Prosecutor General on the same day, on the same very day, I will issue an order on internal investigations against those prosecutors who lately, in the last several years, had certain question marks on their integrity as proceeding from the newspapers, investigation or investigative journalists. According to legal framework, we may seize the contract, working contract, if, for example, he or she has certain problem with integrity. The reasonable time is given. The timeline is given, like 30 days, within which this investigation is to be done either within the working groups that might be created from among the prosecutors dealing with these internal investigations on integrity, or another entity might be created within our service who would be asked to examine those allegations. And in this case, of course, we should announce, or we may also inform about this tool, the existence of this tool. We should inform the civil society and also the prosecutors. And the final point would be either the criminal case file, or the decision might be taken like an acquittal, meaning that integrity is okay. Yes, in this context, as follow-up, please tell me, do you confirm or not such information as if in 2012 something did happen, certain disciplinary proceedings was initiated on the case that you know. After that, the final point was, the final decision was a sanction. You appealed against it, you challenged it, but it was nevertheless upheld by the court. So would you please tell me whether it is true? Whether it is true? Well, the question is whether this indeed happened, whether you've been sanctioned, and whether the sanction was upheld by final irrevocable decision of the court. Yeah, thank you very much for the question. Actually, yes, it was. It did happen. The actions did happen while I was on vacation. I would not get deeper to details. I just would like to inform you that twice my appeal reached the Supreme Court of Justice, who every time decided that this case should be re-judged or revised by the Court of Appeal. And sometimes, as you know, we witness the investigation which are not resorting to the real evidences. Actually, I've heard this from mass media. That's why I'd like to see whether you confirm. Yes, it is true. I was warned, and this was upheld by the court. Yes. Personal, I would be interested why you decided to leave this profession, the prosecutor's profession. I understand that you did last year. Thank you very much. Good question. I'd like to tell you that actually, I may say plastically that I was born as a professional in prosecution service. I understood, but why you leave? I left the system because it was in 2017 after the reform was implemented, or after the new law on prosecution service interforce. I've left in that situation when I understood finally that in the society, the society perceive as it is shameful to admit within the society or among the citizens that you are still prosecutor. And I understood that we've been highly criticized, and so to be a prosecutor was a shameful situation, shameful condition. I was not able to change this system. That's why I decided to leave. Okay, but what about the license of 2016 that you've requested? You wanted to have it for what purposes? You wanted already to leave? I understand your question. Well, you see, it was already sort of customs. According to the law on prosecution service, the ones who may become prosecutors, either they have to have the seniority of working seniority of 15 years, or they have PhD and so on. So those who already were prosecutors or judges and they were applying to the licensing committee, they have been admitted in this profession without issuing the license. So we have to here two kind of exercises, legal exercise. One is to be admitted in the profession, another one is to be licensed. So the license is being issued only when there is a lack of incompatibility. I'm sorry, but now I have to connect better to understand better. You see, Mr. Bayesha told you about the situation. You confirmed it. You as prosecutor, you've been at that time prosecutor, yes? And so you say that the prosecution service used to already at that time would be perceived as a shameful profession. So how then we may reconcile these two things as a prosecutor who used to be a prosecutor at that time, because even if you've been in vacation, you didn't take that vacation from the institution that where you used to work. Basically, and the second, I'd like also to ask you something about the image of your profession, which you represent, even if you leave that domicile. I'm sorry, but do you refer to the conflict of 2012? Yes, those kind of altercations. Well, those kind of altercations, they did happen with some persons who used to be convicted. I presented those charges for hooliganism against all those persons who were present there. I was not present in those premises. So again, the investigation, as I said, was not efficient enough on that incident or altercation. That was the reality. Even now I have those documents. I'm not I actually wanted to speak about the image. I mean, regardless of who was doing what, I, for example, left the institution, but I still bear on me that image. You see, I'm not just a prosecutor, I'm also a man that played the role. From the concept that I've seen and I've read, you see that you propose a law to be adopted law on jury. Do you think that our society is when everybody is relative to somebody else, do you think that this kind of jury as a tool or institution might be introduced? I think this proposal is based on the lack of trust from the society, not only vis-a-vis regarding the prosecution, but also the justice as such. Of course, this concept is not the only one, it's just an opportunity, alternative. Take into account all the competence and duties of the prosecution service. You see, we have to harmonize, so we have to propose the change, or we have to propose new normative tools which might be used in this regard. So I was thinking about this. You see, it wouldn't be bad. Maybe it would be good, I would say, if we would have this kind of additional tool or institution for high-profile cases, or for the criminal high-profile cases, which, for example, in opinion of the prosecutor general, might be categorized as very severe and severe crimes. For those kind of cases, we might need the jury. I think in order to increase the legalization in the Republic of Moldova, we need, of course, to do something else. And I think the information should be also better disseminated. Legal dissemination should better disseminated among the...
I don't understand, sorry. I don't understand quite why it was in 2017 that you suddenly developed this shame at being a prosecutor. I've been coming to this country for many years, and I know that the reputation of the prosecutor's office was not a good one for a long, long time. So what suddenly happened in 2017 that didn't happen to you in 2012 or 2008 or any other period when you were working in the prosecutor's office?
Thank you. I would like to inform you that I also, as any other person, of course, I have some plans, strategy in my family, in my life, so on. So in 2017, when I resigned from prosecution service, I think it was, I felt that we are on the top of criticism against the prosecution and against the leadership of the service. We all know that this institution is being managed and led by the Prosecutor General, and we as institution, we are corporative institution. And it's one thing when the prosecutor may undermine the image of the prosecution service, and it's completely something else when the leader of that institution raises, let's say, doubts doubts about the integrity of the prosecution service as a whole. And finally, it was my conclusion that I've grown in that moment, and I think it was sufficiently right. It's not that simple, it's not that comfortable to change the area of your professional activity and to change the focus of your life. I hope that I managed to answer your question.
Could I turn to a different question? And you've given a very, very detailed concept document, and I congratulate you on it. You didn't mention this earlier, the question of accountability of prosecutors. How do you reconcile this with independence, and what sort of accountability should there be, both at the individual level and for the organization as a whole?
Thank you. As I mentioned, actually the prosecutors such in the Republic of Moldova, they are basically very responsible and accountable. But you see, we have very small percentages of those prosecutors who have key positions, let's say. They are holding key positions in the bodies of prosecution service. So once the assessment of those prosecutors, I mean those prosecutors who have certain question marks upon their integrity, when this assessment would be done, then I think that the prosecutors as prosecutorial institutions, I think, would be able to get rid of this kind of dangerous elements. So that is a sort of a short-term plan. But for the long-term run, I also described this in my concept, by the way. I would say, I propose that the ideal situation within the prosecution service might be reached by the efforts taken from within, but also through the help of being held by the central governing bodies in this state, so that we will be finally given the magistrates' status to the prosecutors. There, I would draw here a parallel with Romania and other countries. So in that situation, I would say, we would need the so-called principles of hierarchical control. So that would be a real final procedural independence in procedural terms. But in order to reach this real independence, of course, we need some time. Thank you.
Page 10 from a concept. You're stating that prosecution should contribute to the separation of branches of power. As far as I know, prosecution doesn't contribute, but it complies with. It should respect it. But while reading your statement, I find that there are flaws, right? And this principle is affected, right? This principle is violated. Reading from you, right? There's an interference between the different branches of power with the prosecution. What are those, if you could give us examples? And how do you want to go about ruling them out, eliminating these elements which violate the compliance with this principle of separation of powers? Is it clear? This question clear, yes. Mr. Bobo, with due respect to your experience, especially in the prosecution bodies, let me give you an answer to this. According to the law on prosecution, according to the Constitution, according to the regulations, according to normative documents, the prosecution cooperates with all state institutions, with all central institutions of the state. Now, I believe that this could be, I mean, look, some political actors, on the one hand, and some managers in the prosecution office, on the other hand, have exceeded their competence in a way. So what happened is that there was interference, direct interference in the activity of the prosecution office. It was displayed through requests to the management of the prosecution office, orders, sometimes orders. I think you have quite experienced, and you were in the prosecution office during different times of this country, which was led by various parties, etc. Now, this was nothing else but a direct interference, which is a political corruption, criminal corruption. Now, I've written in my concept that, and things must be interpreted in this way. Any interference must be immediately curtailed, and if appropriate, punished. I'm saying that the contribution, that's why I'm saying that the prosecution office has to contribute to the separation of powers by its own activity. So a general prosecutor should care about his institution. It would be illogical otherwise. But for good things to happen, to the benefit of the society, there should be a reaction from the prosecution office. That's what I meant. Thank you. Okay. Mr. If you allow me, a general one, but related to this. We know that any force, political party would like to have a general prosecutor of himself, to itself, right? How do you prepare to actually not allow that? How are you getting ready to rule out, to exclude the interference of politicians in the activity of prosecution office in general, so as such, and of the prosecutor general? Do you have like a ready, I don't know, ideas to put on the table? This is a very complicated matter, I know. Burdensome. You know it better than me, and maybe dangerous sometimes. But anyway, how are you ready to avoid interference of politicians in the activity of the office? I don't know that politicians want their own prosecutor general, not more than it is known to society or mass media. I never was part of these discussions, and now how do I get ready? I'm ready from the very first day in the prosecution. I don't have to be ready. You have to be vertical. That's it. I should inform you that while I was prosecutor in one of the subdivisions of the General Prosecution Office, I've done a number of investigations related to politicians which were yesterday but have a mandate even today. Now, despite legal and administrative obstacles, there was evidence collected, enough evidence collected. Now we will have to wait and see what would be the fate of those cases and where those cases are, and if they are. But even if there is no procedure to reinstate all of this evidence and information. So this is about being vertical, and this is about not allowing interference in prosecution. That's it. Thank you. I hope I was convincing enough. Mr. Kashu, your concept is well structured, as far as I'm concerned. But in your motivation letter, you mentioned something which is important, as far as I'm concerned. The reforming, so genuine reform and genuine development of prosecution office. Now, the question is, what has been done so far in terms of reforming the office? Should I understand that this was what? This was not a genuine reform? Because the way you write it, it raises certain considerations. And if we have to conduct a genuine reform, then what is this genuine reform? Would you need to make changes to the laws? Do you want to review the structure of the functional? Do you want to review the functional structure? Was this of the prosecution? Could you comment on that, please? Thank you very much for the question. The provisions, so look, I couldn't make a more detailed concept. That's why I had to refrain myself to 20 pages. Let me try and be a bit more detailed when it comes to this. There are many things that have been started in terms of reform, undeniably started. There's more good things than bad things, okay? And now what is this genuine reform? First of all, giving people good labor conditions. In Chisinau, there is an office where you have 4 prosecutors. It's unacceptable. That space is not a space. That is an office for at least for maximum 2 people, 2 prosecutors. This is one. If you want details. Now, in terms of organizing the prosecution system from Chisinau, now, once the new law was approved, they excluded the positions of deputies in territorial offices. You know that according to the law on the status of Chisinau municipality, we have 5 sectors in Chisinau: Buica, Ciucana, etc. Now, these sectors are led by offices and by chief prosecutors, and they are the deputies of the municipal prosecutor, but they don't have these positions as such. Now, in the districts, in the regions, besides Chisinau, up until now, these functions have been preserved of deputies. Now, it is logical to have subdivision. It is illogical to have not to have a deputy. And what happens? Some of the lay prosecutors exercise the position of deputy without being remunerated. So they're like a secretary, not as a prosecutor. Next, technical endowment. I would equip prosecution with electrical vehicles. You know what's expensive? Fuel, because that would save money to the budget. And when it comes to the budget of the prosecution office, according to the formula, for instance, how the ECHR is funded. These expenses of this court are funded from the budget of the Council of Europe. whose budget is a contribution of the member states. Now, subject to the number of inhabitants, such as the percentage, and the GDP per capita. So that the rule that I would apply to finance the budget of the prosecution office. So that is the detail for you. In terms of objectives and strategic directions, you start by saying to run a diagnosis, the diagnostic study of the institution. You have the concept. And after you have the concept, you want to have a diagnostic study, and then we do what? Yes, thank you. Institutional diagnostic means that you need an antivirus which should clean the whole prosecution system from those risk factors. The risk factors when it comes to the professional integrity, as well as those who are doubtful, those who are corrupt. Okay, that's what I mean when I say diagnostic. Without that, you cannot go ahead. You have to start with this. Thank you. Thank you. I hope I was clear enough. I would ask the following question. What percentage of acquittal sentences would you allow per year? Myself? Not yourself. For the prosecution. In the courts. And what measures would you take against these acquittal sentences, if you're against acquittal sentences? Okay, in this regard, there's many voices. You have a dual approach. In a democratic country where justice delivery should be complied with, there shouldn't be a problem if a court pronounces an acquittal sentence. On the one hand. On the other hand, you have the prosecutors. So you have these risks because the person has the right to rehabilitate all of its damaged rights and request the punishment of the prosecutor for, an illegal indictment, or the fact that they made him liable without any grounds, so incrimination without grounds. So that's why the prosecution bodies have to avoid to illegally indict the person. But in reality, there are many situations when you have a 50-50 thing. You don't know for sure if it's the case or not. And then a certain accused person, or if you have a criminal case against the person, then it has to go to the court, because according to the law and constitution, the court has to be the one who should rule on whether the person is guilty or not. So these risks will always exist, and they exist now. I don't say that it's wrong or it's not wrong or right to have acquittal. If it's right when it's genuine, okay, when it's genuine, and you have a genuine justice delivery. Mr. Kashu, I'm just curious, unrelated to the concept, but somehow it was induced. You want juries, right? You want the implementation of jury system. The judges and prosecutors, should they be elected by citizens directly? This is also a popular idea. Your attitude to this, what's your thinking on that? This is an unrelated question, by the way. I told you before that it's not a rigid proposal. This is an optional proposal about the juries, about your question, for the society to choose its own judge and prosecutor, as it is in the United States or other countries. I am convinced that today Moldovan society is not ready. They don't have enough level of preparedness in the legal domain to be able to choose or to exercise this potential right. And I think that this would be a huge problem, a big problem for justice currently. Maybe in some time, maybe after people have a better, are more aware, maybe we could come back to this, but no, not now. Thank you. Tell me, please, whether there were, or if not, but you can imagine in your activity a situation when violation of law would be necessary or unavoidable. Violation of law. Would I have done it? Yes, there were cases. Should I give examples? Yes. At the beginning of my career as a prosecutor, I've investigated this case about this intended homicide with intention, intentional murder. The murder was committed by the wife. She killed her husband. Now, the moral aspects of the situation, of the circumstances where this murder happened, and after I've analyzed who the victim was, who the author was, who the perpetrator was, I've requested the opinion of the chief prosecutor regarding my proposal to change this offense from homicide with intention to homicide with imprudence. Now, the author of this homicide, this lady, she was 80 years old. She was 80 at that time. As a punishment, at that time, Article 145, Paragraph 3, is from 20 to 25 or life imprisonment. That would, or the life imprisonment. Now, the chief prosecutor told me that the idea is good, and this situation was coordinated with Prosecution General, those who actually verify the activity of territorial prosecution officers, and this was accepted. The person has been freed from arrest. I, as an accuser, went to the court and I've obtained this sentence. She was convicted, she was found guilty, recognized with murder with imprudence, and her sentence was suspended. Now, the victim was immoral, an immoral guy. He didn't work, he was stealing from home, there were details. So we're lawyers, okay? So then we have to understand that any norm, besides its imperative nature, has to have a human logic to it. Okay, so professionally, legally, yes, this was a violation, but practically, professionally, this was the best decision, I guess. Thank you. Thank you very much for that. And the last question, I guess, it's about, can you identify in your personal experience a failure? What was that? And what would you do differently this time if you could change something? A failure in my professional career? It's a good question. I didn't think about it. Never thought about it. Maybe because I never had the situations. I don't know. I don't know. Thank you. I apologize that I don't give an answer, but I've never had such an analysis of my activity. Thank you. Thank you very much for the time. We wish you good luck, and let's hear ourselves soon. Thank you very much. Congratulations and good luck to you all.
Headphones to use. Now we have the floor, sir. Thank you. First, dear members of the committee, I'm honored to be here before you and I do appreciate your efforts to strengthening the judiciary bodies. I applied to this competition following the appeals, sincere appeals of government. That was what I mentioned in the motivation letter. It characterizes me, and that is my belief that my cause, what I've written over there, I am maybe a little bit disappointed because there are not many more candidates than which are included right now on the short list. I think many other people, they do deserve to apply to this position. I was born in the Bryan village in Yalovenia district. The high school, were graduated with an average of 9.5, which is almost A, 2000, and the university was one of the most students. Mr. Bayesh, you may remember the Olympic Games. You said that I'm free to go from your exams because I had to attend these Olympic Games among students. Okay. The role of prosecutor, if it's not just about civil relationship, then it's, I think, we should rather understand that we should be referee and not just the punishing tool of the institution. Otherwise, the rest of the business institution should feel free. So that's contribution of prosecutor to make justice in the society. You asked me which are my merits. I'm coming from the system. I was used to work in the National Anti-Corruption Center. That was the biggest part of my professional career, taking into account the importance of this anti-corruption center for our state, the Republic of Moldova. And then I should draw also parallel to what happened in the state and my professional activity. I started in 2008. With the factors which undermine our society, which is the devaluation of the private bank. I was at the time an investigative officer who used to investigate the case against the chairman of the bank, and I was able to deliver this charge up to the court. After that, the communist regime failed, collapsed, and I was the only one who dealt with the tax evasion of a lot of millions of lei, and finally people have been convicted in the court. What was next? First, in the other phase, in 2012, we have the robbery of the stealing of that billion in the bank system. I was already at that time dealing with some cases related to the Gachkevich group, a non-performant credits. This happened in 2013 summer. Since that time, I don't know the fate of that case file, and those persons are still free. Seeing that things are not going on well, by being a person who likes to keep everything under control, I decided to run for the prosecutor's office and the anti-corruption prosecutor's office. At that time, the competition was not announced. That's why I decided to go to the district in Basavrabaska. There I used to work for 6 months. It was the smallest prosecutor office. For 6 months, we managed to be 8th in the ranking list of the prosecutorial officers. So meanwhile, the prosecutor's service went through reform, and since that time the anti-corruption office was not anymore possible or feasible for me because I didn't have enough they didn't meet all the requirements. I was called by the custom service. They told me that we need a professional like you and integral person like you in order to move things on. I used to work there for 4 months. I created there from scratch the Department of Criminal Investigation. We brought to the budget almost 5 million leis into the budget due to our activity. We've been 12 in that department. We apprehended a lot of merchandise of more than 15 million lei. Everything is checkable. It may be checked by, if necessary. We've created the concept of criminal investigation in the customs, and finally we reached the cases of very heavy smuggling cases through Transnistria with 6 country transitions, crossing of the so-called security lines with the lorries, and finally the Customs Service wanted to change their structure, and that is how I was asked kindly to leave the service. That's why I got back to the National Anti-Corruption Center. I held the same position. I was doing it diligently. During 2 years, we recovered 2 million lei paid to paid into the state budget. We applied the sequester, and so on. All this information is public and might be checked very easily. I'm sure that you've read my concept, but however, first of all, I'd like to open it to on the page. Do I have 7 minutes? Is it right? Up to 10. Up to 10. We may see that the confidence in prosecution service, according to the public opinion survey, Mr. Bosan knows very well this barometer, so the prosecution is being trusted by only 80% of our population. So which are the reasons? Which are the reason of this disaster? First of all, the management, bad management, human resource policies, then the promotion of only of the loyal prosecutors. It means that the quasi-total control over the prosecutors have been established. It led further on, degenerated into the lack of integrity, corruption, lack of honesty in declaring the incomes, failure to investigate the notification coming from investigative journalists, using the and lack of the willingness to change things into good. So the population finally, I mean the society now is convinced that the prosecution service during the last approximately 10 years or even more did commit interferences into its activity from the side of political elements and corruption. As candidate to the position of Prosecutor General, my general policy that would define me would be decentralization, and I am going to, as a prosecutor general, I would like the prosecutor to be the main element within our prosecution. Actually, the prosecution, of course, is being done through and by means of prosecutors. So he is a person who contacts the parties. He is the representative of prosecution service. So if, in case, he would be able to increase his accountability, responsibility, promoting is based on merits with the principle of zero tolerance towards corruption, creating to him the conditions to not to be influenced by the superiors, and then would be able to create to enable him to think, to be confident that he is only one who is responsible for his own taking decisions. And the situation regarding human resources, the situation regarding criminality, probably you already know on what they do. Okay, I'll not speak. What we have the prosecution service as and his mission of fighting the crime and promoting the interests of states and the human being and human rights. In this fight, in this struggle, according to the decision of Parliament, we have 720 positions of prosecutors, among which the Prosecutor General Office we have 87 prosecutors, according to the report issued last year. In the Special Prosecutor Office we have 81, and prosecutorial we have 479. By total we have 374 prosecutors positions, out of which dealing by average 32,000 cases per year. So the workload per capita, if we're making an average, would be approximately 60 criminal case files per capita. If we look at how the forces are being distributed as human resources, then we may see that in the Prosecutor General Office we have 87 prosecutors, which is unjustified for a long time. That's my belief. The Prosecutor General Office, according to their competence and duties, they should rather focus on the policies like harmonization or uniformization of practices and so on. And they nevertheless inherited many customs from the past, and they are still dealing with the criminal investigation, criminal prosecution. Actually, these duties are not anymore compatible with to the current situation of the prosecution service, and the prosecutors are coming to the offices, but they are not. We cannot actually verify which is the real real rate of the real efficiency of their activity. That's why I would improve the organizational chart of the Prosecutor General Office, and not only in case of necessity, some of the personnel from the Prosecutor General Office should be transmitted or should be shifted to the territorial or to the specialized prosecutorial offices in order indeed to deal with this investigation according to competence that we have, so that finally everybody should, in other words, be dealing with the competences in a sort of separate way. I mean, depending on the offices where you are working without this kind of traceability. If please allow us, because we have a lot of questions to you, I would like also to come up with those questions, I mean, those coming from the committee members. And we will refer also to the management concept that we've read with attention. We also have some questions based on your concept. So the first question would be, because if I'm not wrong, from your letter of motivation, we may see that you say that you are fully confident in your forces, on the team of professionals that you are going to create. So would you please come up with the details how you are going to create that team of professionals, taking into account the limited competence of the Prosecutor General regarding the competence of the Prosecutorial Council when it comes to promotion, evaluation, disciplinary section, so on. Yeah, the difference between a professional, a person who is out of the system, who is outside of the system, is these slightly different, if you please allow, because I as a professional, I see everything from within towards outside. When I'm saying about the Prosecutor General Office, I see immediately the case files and those working on them. If I would be somebody from external, from out the prosecution service, I would rather look at this system as mechanism. But these are two different things. You are saying that I'm instigator, but you see the investigation officer usually is working side by side with the prosecutor. Usually, this is pre-trial product that we're together working on. That is the criminal case file. Without a good criminal investigation, of course, the prosecutor would not be able to deliver good products. It's okay. By having this intuition and practical experience, a very rich one, meaning, I'm not afraid of saying this, but so whenever I speak to a person, when I see the professional performance of someone, then it's immediately clear that he is fully incapacitated or empowered to deal with this profession. We have 249 professionals in the territorial offices. I'm very sure that out of those 400 and something, we may identify a lot of prosecutors who are very well trained, prepared. Most of them have underwent through the education in the National Institute of Justice, with a lot of programs, trainings being delivered to them annually. That's why I don't see a risk in this regard. I do agree, but the prosecutorial office, let's say, would reject your proposals or your appointments that you would like to see in your team. Well, when you speak about newcomers, okay, that's right, and promotions. Whenever I start investigating, I also analyze the risk factors. The Council of Prosecutors will be very soon reformed, as some attempts have been already done. That's why I don't see this Council as a threat. It's rather it's an opportunity. In case if, and I would like, of course, to strengthen constructive dialogue with the Prosecutorial Council. The duties, tasks are expressly provided in law, and they are just to contribute to the mission of prosecution service. I cannot talk to them on other subjects except those which are already stipulated by law in the best interest of prosecution and the mission of prosecution service. Nothing else. If that's something different, then if this is a white, not black, or vice versa, then we should act on the good faith basis. Whenever somebody will try to do something else, I would look at this as not at the risk again, but at the open opportunity or window of opportunity. I think we'll succeed.
Mr. Chris Morrow, do you want to put your earphone?
Oh, it's okay.
Oh, okay. You've made a very strong case in your concept for individual independence and the status of magistrate and so forth. How would you reconcile that sort of independence with the need for accountability? And specifically, can you tell us, should the prosecutor be accountable? And if so, to whom and for what? And is there a difficulty essentially in having accountability for people who are effectively made magistrates rather than part of a hierarchical system.
So perhaps you mean the status of magistrates being given to prosecutors and their accountability towards their professional duties. Actually, I'm pro this status of magistrates to the prosecutors, but I'm looking at it from a certain perspective. Why? You see, if, as of today, let's say, as of today, the prosecutor, you are already magistrate, but if we will fail to implement all the other policies in order to increase his self-confidence that he is responsible and he is responsible for any decisions he's taken. So the simple status given, additional status given, will not change the things overnight. For long run, of course, I will take into consideration this opportunity. I'm pro this. You see, once the status of magistrates will be delivered or given to them, and a new council of magistrates will be created with two boards or sections, then it will be only of benefit for us, because basically we will have there sort of a referee who would balance the judiciary branch and the prosecution branch. And of course, at that time, our practice will be better harmonized.
Okay, let me understand this better. Talk about the rich experience. How many years have you been in the system? 11 years and 7 months. I've been a criminal investigation officer. I was in custody for 4 months, but I was there and I was quite, you say, profound and deep. Management experience, okay. Let me understand it better. You are saying, or you agree, that the prosecution has powers to exercise criminal, to conduct criminal investigation, and then cases are lost somewhere along the way, right? Right? You said criminal cases are lost along the way. So you would disagree for the prosecution to have powers to exercise criminal investigation No. From the 32,000 offenses, I'll tell you why I disagree. Only 13% are exercised by the prosecutors. So I think here Mr. Byers will agree with me. There are certain very sensitive social relations. There are certain economic relations where you cannot assign the same right of investigation of police. So it's the police. If you give the police the right to investigate, then one branch has too much power in one pole, which can generate in abuses. So if there is a mechanism of counterbalances, as I specified in my policies program, then the abuses, you could decrease these abuses. You have mutual control, and the person would feel more free. There's always a way to appeal independently, and certain cases should be managed by the prosecutor. At the same time, the concentration of such cases and a certain prosecution, like the prosecution for organized crime, it actually showed that there you had real atrocities. Now, for these sensitive cases, you have to have a decentralization policy in order to have a mutual control mechanism, both by the Minister of Interior, Intelligence Service, and other bodies which have the power to control, so that people would be defended by as many institutions as possible. Okay, I understand your question. I understand your answer. I hope you answered my question. Okay. And one more question to you then. You talked about interference of politicians in the activity of the prosecutor. in general and of the Prosecutor General in general. How are you getting ready to avoid this interference? How are you ready to prepare to defend yourself and the prosecution system from interference of political interference? Do you have an idea about it? Could you voice it? If, look, there is a principle in the criminal procedure. The criminal investigative officer or the accusation has no right to act, but strictly in accordance with the code. Now, any discussion with politicians, with politics, with any other power, executive, judicial, parliament, should be done in a legal context, and the whole communication should be traceable. Any other communication with there shouldn't be any other discussion than with the Security Council. Okay, let's say our politician wants to find out some information about a criminal case. Please, on Thursday, there is the Security Council meeting, and then in that context, when there's a communication between institutions through letters, through requests, then we'll give you this information, and all actors, all decision makers know what is happening with cases. The biggest risk is when the Prosecutor General answers telephones. He allows certain favors, or he talks in the corridors. That is the biggest threat. That is why, if Prosecutor General would be sufficiently skilled to convince. Look, now it's difficult. I know that there's a lot of baggage from the past, but until you start from somewhere, slowly every actor will understand. If I want to find out something, legally I can get this information. Prosecution General will not hide any information, because according to the law on the state secret, any information regarding delinquency in the country is not a state secret. So, while respecting the law, this information will be provided to them. So, I am just for official, traceable exchange of information. That's it. Full stop. I mean, you can write letters to me if you want. The Security Council can listen, can talk to the Prosecutor General about a specific case. Within this council, they present the information generally, like in the country. Of course, the format can be too large. When the information is requested, well, you have to understand why this information is for. I mean, you have to have a legal reason to request information about a certain case. Okay. From your letter of intent, I can read that you apply for Prosecutor General this position to answer to the immediate expectations of the citizens in the investigation of the highest profile abuse cases, the highest profile cases in corruption cases and abuse cases. The immediate expectations of the citizens. What do you mean? You want to meet them by what? By expediting the investigation of these high profile cases? Or you mean something else? Can you elaborate? Immediate expectation is the following. If an injustice was done, society wants a prompt reaction, efficient reaction. As a result, these expectations, I look at them as priorities in my activity, and I will order that they are urged, that they are expedited, these cases. Because I'm specialized in this, I know, I have very vast knowledge in this anti-corruption, and I know strategies, tactics in order to work with these categories of cases, like anti-corruption cases. Thank you. with a caveat. I was never part of any investigation group which would be examined as a priority by the Prosecution General or under the guidance of the Prosecutor General. Thank you.
Sorry, I think from your concept document, it's clear that you understand the need for cultural change in the prosecutor's office, because you mentioned dealing with a management mentality at one point. Can you tell us how you would go about trying to change the culture, apart from giving prosecutors the status of a magistrate, an individual magistrate? What other ways would you try to change culture?
Yes, yes. First of all, look at this slide. It reflects. There's a clear part here. All the people, prosecutors are equal, and they go in the same direction, and they hold the same stick. Now, most of the prosecutors, prosecution offices in our country has 6 or 7 prosecutors. I worked in a region where I was a prosecutor, like a rank and file prosecutor, and then there were head and deputy head. The head prosecutor didn't have to manage any cases because it would be just a deputy. Now the deputy could hierarchically tell me that I should investigate. So what does it mean? It means that the tasks are split unevenly. The simple prosecutors are overloaded, so they are more prone to mistakes. And then here you have the administrative factor. You have the boss. He would report against you at the prosecutor's board, and then it's a risk. Well, I say that we need to reduce the hierarchical positions in prosecution offices which have less than 10 prosecutors. And we need to create a mechanism of random distribution of cases. It means that the head prosecutors would investigate cases in a smaller volume and smaller number, and that would put them on equal footing. So head prosecutor could go to the court, and then a rank and file prosecutor could also go to the court. So psychologically there's an equilibrium between the two, because they can both go to the court, and the simple prosecutor gains confidence in his own forces because some of the cases he can manage better than the head prosecutor. So mentality-wise, there's a change. There's a change, and then by promoting the whistleblowers mechanism, which I have as a priority, the prosecutors will be obliged. I mean, there's nothing bad about declaring, reporting about someone trying to influence your independence or decision. That is why, as I told you, by reducing management positions, introducing random distribution of cases, optimizing work conditions, excluding administrative pressure, traceability of control. What does it mean? The boss who checked your case, there has to be a trace of that in the e-case system. You know, you create a module. On that date, the head prosecutor requested a meeting with me, and then legally he decided the following thing. So all of this is traceable, all of this is seen. All of these measures would contribute to a change in the mentality and culture, and increasing the confidence in oneself, and would make people more accountable. One more question. Mr. Krishmaro, you, in your concept, are saying the following. Prosecutors' corps should expect exceptional measures, extraordinary evaluation based on integrity criteria, lifestyle, etc. You are talking about an exceptional measure. My question is, how would you go about and organize this evaluation as an exceptional measure of your peers, of your colleagues, if you become prosecutor general? This reform has been cleared by the Venice Commission. So all the mechanisms of evaluation will be determined. I will I'm supporting this extraordinary evaluation, and this can be easily checked looking at the information from mass media, looking at the decisions on the case. A professional, once you look at the case, it will be very easy to determine what was done on the case, what hasn't been done on the case, whether there was damages to the state because they didn't start criminal investigation. And of course, there's a lot of investigative journalism. There's a lot of things in mass media. Anti-corruption organizations, investigative bodies have done quite a good job lately. So I believe that this evaluation will be unbiased, objective, and I don't think that anyone would dare to doubt the results of this evaluation. Well, this evaluation will be done within the prosecution system or from the outside. The mechanism of evaluation, the evaluation mechanism is as it is for the judges. It's a committee, it's a commission from very well-known experts, independent experts, without, well-intended to clean the system. And I will encourage this committee. All 700 prosecutors will be assessed initially to avoid some mistakes, like those from Albania. First of all, it will be the management, specialized prosecution offices, and then the others will follow. The others will follow.
I'd like to ask you a question. You strike me as a very honest and serious young man and quite determined. But the question is this. If you had this job, you would undoubtedly come under the most ferocious pressure from some of your colleagues within the prosecution service. Do you think you have the toughness to withstand that and bring it to a successful conclusion?
Yes, I have confidence in my own toughness. I will promote a policy of constructive dialogue based on the good faith and loyalty. I will call for the support of the civil society, of mass media institutions. Look, if I promote a strong message of integrity and that things can be changed, for sure, I believe that most of the prosecutors will follow me, will support me, will encourage me, and we will succeed. You suggest a new organogram for the prosecution general. My question is simple. Is this organogram, this is your thinking? Or this is the result and the summary of some studies done by other experts? It's about a summary of other countries' experience. Could you tell us, how did you arrive to this organizational structure? Look, I do a lot of self-perfection. I read a lot. I'm interested in this domain. I know about all developments, positive developments in this area. I was studying the organogram, which was approved in 2010, 2016, and nothing was changed. Nothing has changed ever since. And it's just a window dressing. And then they just, it's what we want and what we have are two different things, two different worlds. And from the activity report of the prosecution for 2018, it's clear that the role of the prosecution general is to implement policies and to uniform jurisprudence, but not to investigate. So the organogram that I propose here is what is initially, with the help of foreign experts, with academia, was proposed in 2016. This was the intention. They never did it. You know why? Because there were vested interest. They wanted to keep their jobs. They wanted to keep the jobs of a certain prosecutor who were in 2010, and you can easily see that. Mr. Krishman, I come back to Mr. Hamilton's question. You said you have enough determination to face vested interests. Do you have in your experience a situation when you had to face had to face up to interference or to groups vested interest, and you could say that I can do it, I'm tough enough to do it. As long as I do legal things, look, and I know my position, and I can create, and if you create a reputation, and knowing the
s-a manifestat, dar și în alte instituții în care am activat.
You can surround yourself with good people. Look, the situation in another institute is not better than here in prosecution.
De aceea, când pot să constat că nu și-au permis să dea careva indicații ilegale,
so people have to know to each question that answered me, I answered legally based on evidence. So it never happened to you, right? Never happened to you. And because you were so in vertical, yes, as long as you are doing your job, yes, in line of the law, nobody will dare influence or unduly influence you. One more question, last question from me. Can you identify in your experience a failure? Let's call it a failure. What is that failure and what would you do different this time? My first failure in my professional experience was when I thought that if it happened in 2016. I have been in the Criminal Investigation Office for 8 years. I created this image and reputation among colleagues, and I thought that when I go to the prosecution in Basarabeasca, I'll show them who I am, you know, and they will open all the doors. All the doors will be open for me based on merit. This never happened. So I looked at this positively. I took my lesson. It's a professional failure because, you know, you think, well, you are blocked, you are frozen in that district, in that region. Well, because the law was changed. Well, it's a failure, but I took it as an opportunity because otherwise I wouldn't be here in front of you. Thank you so much for this. I think this has exhausted our questions. We wish you good luck. Have a good day.
Good afternoon, welcome. Just small clarification from the subcommittee. We have a new member of the committee, Mr. Pietro Bobi, replacing Mr. Prostovan, who is not anymore able to continue his obligations within the committee. We will give to you from the beginning 7 up to 10 minutes for the general presentation overview of the most important aspects that we'd like to highlight, and then come up with our members' questions. I think you would not need headphones anyway. If you need some headphones for the translation, you use them, please, from your desk, please. Now it's working, yes? Yes. So, first, please allow me to welcome you. Good afternoon. And let me tell you as an overview, well, I don't know whether it's the case, but I structured my concept by trying to identify the source of failure of this last reform in the prosecution service area or sector. I think it's absolutely necessary to identify the reason, the cause of this failure. In this regard, of course, I read everything that was possible to read in this context, on the strategy 2011-16, the reform concept, the studies made on the reform, on this reform 2014, and I was surprised, profoundly surprised by the fact that I never see the most severe problem from my point of view. The system of prosecution service, including the judiciary system, they sub-existed already for 3 decades. We've entered into the phase of 90s with institutions with relative integrity, but unfortunately we didn't know how to preserve and how to develop them, meaning that we've paid symbolic salaries to them. The best professionals, meanwhile, had to leave this system, and the people who replaced them, those who have been already formed in Soviet Union, they did not comply with the professional integrity factors, components. That's moment or an element which seemed to me very relevant in the report of Mr. Hamilton. He made references in 2015 in the report that he provided together with his colleague. He is mentioning there something very important. In 27th item, he exemplifies the difference of salaries paid, the salaries between officers of criminal investigation within the National Anti-Corruption Center and the prosecutors from the prosecution office who used to make the same criminal investigation parallel. The difference was about twice more, 2.4, meaning somebody was given approximately 2,700 lei and others were given about 12,000 lei. So I think nobody questioned about, nobody wondered ever where from the prosecutor charges, criminal investigators, the criminal investigation officers and forensic specialists used to fill in the difference, the gap. And the answer to this question is not just trivial, because they have need, they have family, they have children, and the difference many times was generated through their criminal activities. And unfortunately, nobody ever during 3 decades was not able to draw a line and to say things, to define clearly the situation. The organized crime many times is starting from those who are supposed to fight this criminal crime, because the state was paid them was paying them symbolic salary. That's why I call this sub-existence. Those people actually initially, they had first to identify those sources. These degenerated into degradation of professional ethics and of the standards. And as a result, we've got this system which is mimicking an activity which it is not able and not willing to exercise. In the phase of evaluation in 2014-15, in the concept of drafting new law on prosecution service, it seems to me that it was already late. I used to say this, I remember it well in the spring and summer 2016. I've stated several times that any structural reform in the actual current phase of this state institution development, which is actually in evolution, will lead further to the strengthening of the control, of the vertical and political control over judiciary and prosecution. I believe, and I still believe, that until 8th of June 2018, any other structural reform which was undertaken in the Republic of Moldova was made in order to strengthen the organized criminal crime who exercised an enormous influence upon these branches of justice. This was possible due to the Prosecutor General Office, due to the control, direct control over this institution, which started to be exercised in 2010. We had some episodes when a lot of political influence was done upon the Prosecutor General Office as an institution, but never ever that institution was subordinated fully. We had prosecutor generals always appointed by the politicians, but those prosecutor generals finally were the mirror of the society, and never ever things used to be as worse as since 2015 till now. Once the secret annexes were signed or concluded among the factions, who is taking what kind of institution which is prohibited by the constitution, the constitutional court, then we may consider that in that time the real separation of powers was annihilated. From that time, it was worse and worse, because after 3 parties we had 2, and after 2 we had only 1 covering all these institutions, and as a result, we don't have any more prosecution service, which might be called as it should be called according to the law prosecution service and the Constitution of the Republic of Moldova and our legislation. We cannot call it that it is a real autonomous institution within the justice system. Well, it has a chance to become autonomous once we know what we are supposed to do and once we identify the correct direction of making further reforms. Prosecutor General, actually the fact is such that the one should be appointed as integral, apolitical man, it would be a big step forward, but it would not be enough to change, to generate all the necessary changes. I'm speaking about this in my concept, and I'm telling them about, I'm speaking there about the need of good cooperation in the process of developing the justice-related reforms. I speak about the cooperation between the Prosecutor General Office with the executive branch and with the legislative branch of the parliament. So the assessment of the situation in the prosecution office, especially in the specialized prosecution offices, which have been the main tools in organizing and fulfilling or accomplishing those two international crimes, because these were two big crime operations, 2010 and later, with legislative coverage, executive coverage, with the institutional phase of appointing the men in the key positions, and with finally operational phase. These things became possible, including due to the complicity and support of the specialized prosecutor offices and general prosecution office. This should be said, this should be defined, investigated, and the sources are to be investigated. We don't have other ways out. As the prosecutor general, whoever would be that prosecutor general, that would be his main task, and I've mentioned this, the need of making the investigation on their modus operandi, the actions, non-actions of the specialized prosecutor office. I wouldn't like to forget the the municipal prosecution office. The municipal one, the territorial ones have been used since 2015. The blackmail instrument, political blackmail instrument, this also should be investigated, especially when it comes to inactivity or non-actions. I'm sure that the situation de facto, by averaging this might be changed only if a strict evaluation is made when it comes to integrity. It should be an external evaluation, because internally it's not doable given the status, the real condition, the current condition of prosecution, and I don't have enough information to say what is the real situation in the boards, those discipline boards, ethical boards, including the inspection of prosecutors. I don't have sufficient information to say whether or not they are operational, whether they may do whatever they are supposed to do, because the task of cleaning the system actually comes out from those mechanisms which have been attributed already to them, like functional independence, independence against political interference, against any kind of influence due to the law in 2016, but nothing was changed because the corruptional element was not eliminated. The bodies like Superior Council of Prosecutors and their bodies, they were not operational, they didn't function, and this inaction has an explanation. It should be identified. I cannot say exactly what it is. That's why the fastest way, I hope the fastest, would be external evaluation. It will take time to understand the real situation in the councils, what happened in the Council of Prosecutors, what happens within the committees or boards of the prosecution service and this council, and what is the real situation within the inspection of prosecutors. I hope very much that this mechanism of external evaluation will be possible and will become a reality, and then a cooperation will come through, and then a cooperation with other processes that I've described. This will come. This will make a difference. This will make a difference within this institution. Thank you very much. Somebody from the colleagues would like to raise some questions of clarification on the concept? Yes. A microphone, sorry, is off. So external evaluation. and two items you are making reference to this external evaluation of the prosecutors within the specialized prosecutors' offices, PCOCs, and anti-corruption, and also external evaluation of the integrity and professionalism of the prosecutors. First, I suppose you are referring to the same evaluation purpose, which is integrity, or something else, which would be wider. Well, since the process of the external evaluation is a lengthy one, by referring to the criteria of evaluation, that would be integrity and profession. I would like also to have the professionalism, but first would be the integrity as criterion. I mean, somebody with good intention who would be able then to improve his professionalism, if, of course, the premises are being created, the conditions are created for him. As for the fact that I mentioned this necessity of making the evaluation or assessment of the specialized prosecutors officers, including anti-corruption and organized crime prosecutors, I meant that this evaluation might be bulky, voluminous. I would like, of course, to state that I would like this evaluation of the integrity to be applied on all the prosecutors, which is approximately 740 by number right now. But anyway, the evaluation of those almost 700 persons will be again very lengthy, and then the disappointment may happen. I mean, as a consequence of this very lengthy procedure, and this is to be taken into account. That's why we have to apply here a BNR logic, like AB or 0, 1, 0, and so on. So complex process, which in my opinion will be very difficult to be balanced. That's why I would rather prefer to prioritize this process. It might, of course, be very lengthy, like years and years if necessary, but at least we should start with those offices which are of the highest interest and highest impact, and that would be the Anti-Corruption Prosecutor Office and the Organized Crime Prosecution Office. Whom would you see as those externals evaluators? So from outside, you say, or prosecution service. No, I don't think that the evaluators should be only from outside of the system. No. I don't think that they should be only from outside. I think that we in the Republic of Moldova, we have people with integrity in the system, in the prosecution, including the prosecution, but especially those who are not working anymore in the system. I'm sure that we do need to involve in this system those with institutional memory, those with good faith, from outside of the system, but from the Republic of Moldova, who used to work in the system or outside of the system, but from within the Republic of Moldova, because nobody knows better certain aspects in the context, and that's why it's very important to have in that committee representatives who are being accepted by the society as being integral and professional. If we reach the conclusion that in the Republic of Moldova we cannot identify the integral people who would be part of this committee without any kind of influence from political life and would do their job objectively, honorably, and so on, then it is very sad. The situation will be very sad. And another question. You state in your concept that the general prosecutor general may be a person only, again, from outside of the system. Do you think that we don't have at all in our prosecution service any person who are now acting there and who wouldn't lose their morale, verticality, and of course others also might be accepted. I understood your question. I would respond with a question. Where are those people? Where they were during all these years? Please understand me, I was in a certain situation 4 years ago, taking a very conscious decision. The thing that now public knows me, it wasn't an accident. I had an intention in doing this. It was my decision. And in this context, I'd like to ask, where are those prosecutors who assumed their decision of facing the risk and to flow against the system? I think that I've done it and assumed all the risk. I come from the family lawyers. I was part of the attack against us in a raider attack. That's why my choice was conscious. So if we would have prosecutors with braveness, courageous, who would be able to face the risk of the system, then where were they? And another question, as far as I know, we have 636 prosecutors in the system right now. This number suspiciously coincides with the number of prosecutors who signed a letter which whereby they violate the principle of apolitical attitude. You see, the prosecution is an apolitical institution, regardless of their position during those important days. They should not do this. 636 people signed a letter of supporting that government, which regardless of what many people believe, was representing the interface of the organized criminal group that I've mentioned above. I know very well that not all the decisions adopted in the ministries were actually adopted within the ministries. I know how this process did happen. I know a lot of information regarding this issue. So the prosecutor, I'd like us to add something. I am deeply confident that if, let's say, the prosecution at that time would do properly their job, then the people like Vlad Polokhluk, South Platon would not be part of our social life or our economical life in the Republic of Moldova. And we would now be a different state. The prosecution service failed systemically, continuously in providing and ensuring the balance, counterbalance, and to fulfill their job, to make their job. They are supposed to be the bravest, professional, integral people in the country. Please, I'd like very shortly to refer to a situation. 2013 and 14, I was working on a case. I'm sorry, I've got some cold. I was working on a case whereby the money laundering case was generated. It was the chairman of the bank who was investigated. He was called to the tax service saying that he has debts of like 56 millions, which was tax which was not paid, income tax, from a claimed income of $35 million. This tax verification, tax audit was initiated by the prosecutor, by a prosecutor who initiated a criminal case file on that tax evasion. All the acts and documents based on which this case was initiated were fake ones. That person was suspected of getting an income in China for developing a software of games which have been developed by a person of 70 years old. That person also had important volume of shares in Income Bank. It was a rider attack times when somebody was trying to take those shares by rider attack, and also it was a coincidence that the amount claimed by the tax service was equal to the value of those shares of that gentleman, I mean their price on the market. One of the companies used in this attack was called Seaborn limited. By checking that company in our database, I've discovered that in 2010 an order was issued for the benefit of this bank by receiving an amount of 200 million US dollars from two Russian companies, Limes and Omega. Those were the companies who have been repeatedly used in a raid attack against that gentleman, I mean the shareholder. And since the organizers behind this attack, they lacked at that time the company, they used again the same companies in another attack. That was possible. That was possible for us to identify those money laundering. So this order issued for $200 million was submitted by me to the investigative journalists. Another one, I've done the same for other orders issued for other amounts, like 70 million and so on. Later on, the investigation was made public. I mean, the one that you know as the so-called Russian money laundering investigation of 17 million dollars and 500,000 US dollars. It was published in the Kommersant investigation magazine. At the time, it was an independent one, and the investigation was done by Vladimir Solovyov. Later on, Rise was increasing this up to 22 billion, and finally, recently, the answer from National Bank confirmed that the amount transiting the Republic of Moldova, which are not natural for the economic processes between the Russian Federation and the Republic of Moldova, are over 70 billions of dollars.
So the question remains open between 10 and 15. How much money was laundered through Moldova? 18.5, 22, 72 billion dollars. Now, I was acting with discretion, and I realized that the prosecution and tax service are involved. I helped my client to try and challenge. And I should tell you that regardless to whom you would write, Prosecutor General, municipal prosecutor of the municipality, of Chisinau, intelligence service, president, parliament, there was always the same attitude. There is none. So there is no attitude whatsoever. No, people who allowed this to happen, where were the prosecutors? Let's say you had that prosecutor who was bought by the author of this operation. But their bosses, they all knew. Nothing happened. The case was classified. You know how was it classified? It wasn't classified for reasons of that the person was heard. They didn't hear the person at all. That citizen came from Ukraine, and he said that the litigation, or the dispute, has been solved, and he has no more claims to the owner of those shares. I could talk endlessly about this. I have the experience of opposing to the system, even though I didn't do it publicly. From 2016, I've done more public work, and I think this was a correct decision. One more question to you. How do you see? Well, how do you see the level of criminal investigation, quality of criminal investigation? Now, briefly, how do you think to reanimate the process, to revive the process, which wasn't at the sufficient level, at the appropriate level, but now it is what it is now? What would you take, Mr. Gligar? What would you do, Mr. Gligar? I would consult, first of all, with people who have experience in this case, in this regard, including you. I myself would know how to solve it. I've read the whole legislation. I looked at the criteria of recruiting the investigative officers. Besides the fact that investigation officers, I mean, by the way, we have an acute deficit of criminal investigation officers and investigative officers. Besides the fact that we don't have professional training. If someone wants to become investigation officer or criminal investigation officer, in case of investigative officer, you have to have just a bachelor's degree, and to come to the criminal investigation body and say, well, I want to become, and you should queue for that, right? There is no testing, there is no professional training courses. The National Justice Institute doesn't have a curriculum, they just simply recruited. And during their work, if they have from somewhere one to learn, they would learn. If not, not. This wasn't the case before. The investigation officers, which are an element, and these are the people who oftentimes make the difference between a successful investigation and a failed investigation. Now, these people are paid, symbolically paid, and this institution degrades not because there is no interested people. I'm sure there are interested people if these activities, if these functions would be paid appropriately. As Mr. Hamilton mentions in his report about the difference between investigation officers. Now, the investigative officers are there low. Their salaries are about 300 euros. I mean, these positions are profoundly unattractive, and there is no ongoing professional training. Now, criminal investigation officers, subject to where they work, Ministry of Interior, they have agreements signed with some universities, and through the universities, they provide the training for these people. Well, this is how the law writes. I don't know how this functions in practice. I couldn't tell that. Now, these problems, they cannot be solved only by me. These are systemic problems, complex problems, and I really believe that National Justice Institute should review its competences and include there the curriculum and the necessary capacity to train before recruiting, to train these people, to train criminal investigation officer and investigative officers. There are
Mr. Dligor, do you see any downside to, I think your experience is largely commercial, although investigative in banks, so you haven't been a prosecutor. No. But do you see any downside to that if you were to get this job?
Of course I see.
Eu răspund român, cred că. I'll answer in Romanian. For sure, I understand that I cannot compare myself when it comes to knowledge and experience in the area of conducting criminal investigation with prosecutors who are in such positions. What I'm trying to say, though, is that it's not this. This will not bring the change. Not this will bring the change to the system. I know people from the system that are very good when it comes to criminal procedure and material law, criminal law, but unfortunately, so far, this was not, they were not capable to change something. Look, we need people with vision, deprived of any, who are fearless when it comes to implementing their vision, capable to look at things, to bring an outside look. Unfortunately, if you look at the evaluations done, including by Greco, by the way, you also referred to those. If you look at other reports, not necessarily Greco, we will see that those reports are saying that between prosecutors in Moldova there is a system of relations, unofficial relations, under the table deals, which are hierarchical in nature, undeclared ones. And despite the fact that this have been correctly identified as pitfalls, as problems in the concept of prosecution reform, which then resulted in the development of the law, even though they clearly showed the hierarchy of prosecutors by changing Article 6 in the Criminal Procedure Code. So despite the fact that they have eliminated the military rankings from prosecution and they've liquidated military prosecution offices, they've cancelled the right to bear arms, they've eliminated those features which would generate an appearance of the structure to be military, because in Soviet Union, this was a semi-military structure. Despite all of this, trust me, the relations, the under-the-table dealings in the prosecution still exist. And it hasn't been changed or affected in any shape or form. This system, actually, moreover, this system made it possible that the system resists the changes which were done by approving the law on prosecution.
Can I ask you just a further question, because obviously your focus is on cleaning things up, but your long-term vision, how would you balance the independence of the prosecutor with the necessary accountability? And how would you go about the business of securing cultural change in the office, assuming that you think, as I think you probably do, that you think that the culture of the office is part of the problem?
It's a very complex question. It's a complex question.
I rolled up two questions together, I'm afraid, because we're running out of time, and it's, other people need to ask a few questions too.
But could you separate them? So that
Okay, independence and accountability, the balance there. And you've said a little in your concept document, because you talk about how the rule about not having written instructions is illusory, which I could well believe. But, you obviously, if you had this job, you've got to have a goal to work towards, and that's what I want an idea of, how you would do that.
well, I have my insider information which says that several prosecutors, if not many prosecutors, actually here. Scuzi, nu, mai bine, da, mai multă lume. Eu încerc scuze, eu n-am observat că am trecut la engleză. Scuze. Sorry. Deci, din acele informații
From my insider information that I accumulate from the system, I know that more prosecutors are trying to justify their lack of action and their being passive, and the actions that go against their job obligations through a good relation and the fulfilling the wishes of politicians. Now, currently, the system is built like a pyramid with horizontal clusters, but it is deprived of a boss, permanent boss. And in this regard, traditionally, many prosecutors believe that if they would show themselves and they would show that they are lenient and they listen to the politicians, that would save their careers. Now, I'm conscious of this, and I'm quite well informed in this area. I believe that appointing a prosecutor general who is the head of specialized prosecutors and head of specialized and regional prosecutors who can control these people, if this person were to be truly politically independent and could refuse any interference from any politicians from right to left, that will be the beginning of the change. And I think that the new prosecutor general should be very clear and direct to the prosecutors when it comes to executing any suggestions or requests that come from politicians. I know that this exists even now, as we speak, in the prosecution office. Now, Prosecutor General, according to the competences in the law, has enough competence to actually sanction and not allow, at least start the sanctioning of those people who do not respect the principle of political independence and the rule of law. These people must act based on the law, not based on orders. This is how I see things. At the same time, I should tell you that I don't believe that we in Moldova had, at least in the last 10 years, had prosecutors general who would not listen or heard what politicians want. And I think look, I really hope that as a result of this competition, you would appoint a person who for the first time ever would make prosecution politically independent. Very difficult to do, because I am aware that Democratic Party grew from 260 mayors to 700 mayors without elections. With the help of prosecutors from Moldova, Interior and judges. Well, I don't forget that. I remember that. And those people who have done this possible, they deserve an investigation. And you have to hold these people accountable. Sorry, he said investigative judges as well. Mr. Gligor, thank you very much for what you said so far. You shared your attitude and your opinion about the prosecution. Now, my natural question to you, after you've presented this image, this prosecution with its staff, should you demolish it and you should start things from scratch, or you can still recover it? I don't believe that we have time and opportunity and possibility to do something dramatic. We need to have a very rigorous scenario, well-thought scenario, but we cannot just, we don't have the capacity, we just simply the capacity to find, train, identify, train, and appoint at least 350, 400 new prosecutors who would be capable to live up to the challenge. Now, what I believe, though, is that changing the nature of the system can come through a compounded effort from two elements. This is to change the internal change by appointing an apolitical and brave prosecutor general to go against the clans from and vested interest in the prosecution office, and political will to evaluate, at least partially, this system when it comes to integrity. Well, my next question is then, in the same context, you gave a negative appreciation to 633 prosecutors who, during the dual power in the state, supported the government. Those 233 people, I mean, can they still work in the prosecution office, or you are ruling them, or you say that they are people who have showed their loyalty to politicians, in a way? I think Moldova is not just about prosecution. Moldova as a state, in the last 4 years, has gone through a process of annihilation of verticality, independence, and thinking and action. Unfortunately, our prosecutors were part of this process, of this phenomenon. Well, actually, they were the people who should have stopped it. Well, I'm sorry. Unfortunately, they didn't have the guts to do it. They didn't have the courage to do it. I, today, to tell you whether they regret this or not, for sure, out of these 133 people, there are good professionals and people who still could, if you want, make history. There are so many crimes to investigate. There are so many schemes which haven't been discussed at all in public. Well, for sure, I give them a chance. I give them a chance. There is no other way. We have to give them a chance, but at the same time, you have to give them a very clear message. Yes, but they are guilty. Well, any adequate person should have a feeling of guilt when he didn't know how to live up to a challenge. If we deviate from normality, and what can be considered to be appropriate. Look, these things are written in the law. I've read recently, again, the Code of Ethics of prosecutors. It's look, you know how beautiful, how altruist, how full of integrity, functionality, and supreme values that document is? I haven't read such a beautiful document in a very long time. I want to ask our prosecutors, have you actually read your own ethics code? How many prosecutors have resigned because of that? I don't know such statistics, and that's why I don't think we should actually really be so tough on them, because there's a whole country to be tough on. We have thousands of policemen. We have public servants. You know, the country has gone through a whole mess. Now let's see who is capable to do their job.
Well, that is exactly my follow-up question. You claim that the external and only external evaluation of prosecutors should be done, if I understood you right, and you're saying that during this evaluation period might be pretty lengthy. So how the system will operate during that period of time, since most of them, they will be subjected to this evaluation? Do you see, let's say, some, can you expect some, would you like to deliver some message to the prosecutors, like wait a little bit, since meanwhile we will evaluate? So this will be subject to evaluation. How the system will function meanwhile or during that evaluation time, which you say is lengthy, and you have a pretty negative attitude towards all these prosecutors. You see, I see this all this stuff in stages. We have specialist prosecutors who should be first in undergoing through this vetting. There's competence, impact, and importance. They are the highest ones for the national security, for the economic security, for the institutional balance. So they are the ones first to be subject to this evaluation. Later on, I would apply the principle of impact. Meaning that, well, that is the structure, and that we have urbanistic structure. We have the municipality where we have basically half of the population of Moldovan capital city and more than 50% of our national economy. The municipal prosecution office has the highest, therefore, impact on the activity, including all those economic operators in Chisinau. As an importance related to other territorial offices, the importance of municipal capital prosecutorial office is not superior, so there should be some logic in any kind of approach and any kind of reform. That is why in the first category I would include the specialized prosecutors, special officers. The second would be Chisinau prosecutorial office, and then all the others, depending on the preferences, higher, larger, less town. So although I know, and now during the time when actually a little bit the people are more open, to say the words as they are, to say the things as they are. I know that there are some territorial offices where the prosecutors are in sort of symbiosis. I mean, sort of very too tight relations with the local businessman, and sometimes you don't understand. You're a bit confused where we have the prosecutor and where is the businessman. So these are some things which are to be corrected. The efforts should be an institutional or systemic one. We need a lot of information. But again, that's the third phase. We need to get rid of, in our activity, we would like to get rid of certain drawbacks when it comes to specialized officers. Once we are done with this, then we would be better doing with very important investigations which did not happen, unfortunately, during the last 4 or 5 years, and that would be the biggest impact. That is what would generate then the efficiency, credibility, and so on. Mr. Stefan, you stated here, and you've stressed some very, very severe things about the involvement of politics in the prosecutorial activity. It's very difficult to counter-argue. So my question would be this: what would happen if, let's say, you would become the prosecutor general, and let's say out of those more than 600 prosecutors you would find, even though they find that letter, you would, let's say, be able to find some professionals and integrity, people's integrity, and the investigation that then they will do, for example, they are not that perfect. For example, they would be influenced by some political powers. For example, you would see that many of them, they are influenced by the political factions. And if let's say that the law would be adopted, that would influence it, direct political influence. So what would I do if I would see that the prosecutors are executing the orders? No. It's too simple. It's too simple. I question this. You see that all the investigations that you are doing, you may see that they are done due to a law that is adopted in the parliament by the politicians. Yes, we have this kind of circumstances already. So how to get rid? What is the solution? What the prosecution service should do? What the prosecutor general should do? What the prosecution service should apply the law and should investigate the circumstances which led to the adoption of that law, which was the reasoning behind that legislative amendment. As I've mentioned at the very beginning of my speech, those two operations were possible, first because of the legislative amendments which have been adopted to the extent as to allow that criminal activity. And in this context, I'm sure, therefore, that the authors of those amendments, they should be heard by an independent prosecutor, an apolitical prosecutor. My question is quite in the same context, but from another side. Question whether you have been involved, or maybe you may foresee in your future, including this context of exercising the prosecutor general competence, whether you may see something like where you would have to violate the law, and this would be unavoidable. I don't have enough fantasy for this. So you didn't have, even when you used to work after being prosecutor? Well, I think I was very sincere with you. I'm sure that I had a lot of situations when deliberately I violated the law as a lawyer. And I may exemplify this because, in my opinion, it was a real threat for the economy of our country. However, speaking about other cases, I think many things are very obvious. A lot of phenomena would not exist if the prosecution would exercise correctly their tasks. So that is therefore the discussion which may become pretty, how to say, populist, with different qualifications and labeling, tagging, and so on. But for me, it's very clear that the specialized officers didn't make their job properly. Moreover, they've carried out their investigation into completely another direction. They took a stray compared to what kind of evidence, realistically speaking, they had at hand. And we have such a bad situation, for example, in investigating the banking theft, first of all, because of this improperly done job. And the correction of the situation would be, of course, besides investigating from scratch everything, as far as I understand, a lot of many investigative cases, we still need to investigate those prosecutors. We should subject those prosecutors to investigation who exercise a lot of political indications, including through their bosses. We have reborn, I would say, during the last 4 years, the system of political detainees, of repressed persons, and this was done with severe violation of the current legislation. It was so obvious. But for example, by reinvestigating the case, almost even though the status limitation was over, were chasing the persons in order to impose them admitting something, putting people in jail and so on. Many severe things have been done. And what could I tell you? We know about wiretapping of the phone conversation, for example, where my organization was also involved. I mean, this wiretapped. I know about certain indications to do this against us. Well, I'm co-founder. And there are also many other things which I may tell you, but I don't know whether it is proper. Thank you very much. Tatiana still has a question. Well, I have 2 questions, one of clarification and another is a real question. So you, in your letter of motivation, you say that your public activity asked you, due to your public activity, you received a lot of requests from public to get involved in this campaign. So I would like to ask you, if the people would not insist on this candidacy of yours, would you now be in front of us? Well, it's a good question. Well, if I'll get back to the initial source of my candidacy, I think the answer would be yes. So then the motivation, which is the motivation? The motivation is very difficult to explain. Actually, I thought that we should have a separate interview with psychologists, because a lot of questions that you phrase, they are valid only if they're coming up with explanations. Actually, we have a criteria which is called motivation. Well, my personal motivation is to make things to become irreversible. Well, my conscious decision when I became a public person in 2016. I took two major decisions, I think, which in my life, if I look at my life, it was 13 years when I was 13 years age, where I decided to leave the Republic of Moldova regardless of any circumstances. It was an assumed decision, and many people do not understand it around me. And the second, that is the decision to get back into the public life in the fall of 2016. Why? In order to make things irreversible. I mean, first to stop the processes which we witnessed, and then to make everything necessary to make this happen, to ensure that it comes through. So, personally, I would like to make the next step already. I'm trying to face this challenge, which is, in my opinion, the most dangerous and difficult. Okay, thank you. And the very last question. Whether you could identify in your personal experience a failure, why do you think it's a failure? What would you change now? In 2004, I was so much disappointed of what happened in the first political project that I've contributed to. So we've been there, a group making it happen. So disappointment led me to living everything as it is. So I then stopped doing anything in this regard. And I think I was looking for the possibilities to get back into this public life and public activity in, let's say, in word conventionally speaking, to improve certain processes. However, I didn't manage to do it due to various reasons. It's a complicated discussion because I followed the public life in the Republic of Moldova very carefully during all these years, and I have an analytical formation within different analytical departments, and I have a multidisciplinary approach and contextual approach. I am not an adept of binal logic that you are using in your tests. I understand that my logic of my model is synergetic one and cross-disciplinary one, but finally I believe that in 2004, the fact that in 2004 I was disappointed what happened to our endeavors, that we failed to build up the project that we intended to build. It might be considered, of course, a failure, but there are also many other personal failures. What would you do differently? Because you've admitted that it is one of the most difficult tasks. So, I mean, to reform the prosecution general office, said the threat and so on. But you said that you've been disappointed. That's why you've dropped everything down. So there is a risk, therefore, even now. So the system which is not going to receive you with open hearts, you may also become disappointed. What will be your reaction for this time? See, my pause, my break, and my disappointment at that time did not prevent me to come back, to get back into the public life. I am very stubborn by nature, and if I don't like something, usually I insist. But anyway, eventually, yes, it might be a pretty lengthy process, yes, of getting back into the right track. Well, if no more questions are from our part, then thank you very much for the time, for the attention paid to us. Good luck to you, and let us see again. Thank you very much. Good, understood what you are speaking about. So, to start with, I would like to introduce you to Petru Bob, because the rest of the committee members, you know, because Mr. Bobo is replacing Mr. Prostovan, who is not able to work anymore on this committee, so he is a new member of our committee. You'll be given from the beginning like 7, maximum 10 minutes to present the priorities of the overview of your concept. After that, we'll have our questions, and I think it's not the case to use the headphones when Mr. James Hamilton will give to you his questions. But anyway, good evening. But before starting speaking, I would like to declare a conflict of interest, and think it's right. Mr. Botezato is a member of the Center for the Legal Resources, where I'm founder. Okay, then Mrs. Botezato also declared this conflict of interest at the very first meeting. It is noted in the minutes. No, Mr. Botezato, you may attend, but you will not be the one who will take the decisions on him. I may leave the office, the room. I think the best way is right. You rightly said you would better leave the room. Yes, I think this is right to make in order to get rid of any doubts about your eventual decision. So good evening once again. I'm Vlad Gribincea. I am yes, so I'm quite often being questioned why I decided to run for this competition, for this contest. And I admit it was a complicated decision for me, but there are three reasons, the main ones, due to which I am right now before you, in front of you. The first reason is a personal challenge. That's a personal challenge for me. The challenge, so you see, for more than 15 years I'm working in the civil society sector, which is issuing different opinions on public policies, on administration of this country. And I always was used to be blamed, saying that I'm only give advices and not getting involved at all. And I thought that now it's the time and possibility to come up front and to get involved. It's my challenge, it's a challenge for me. Indeed, 15 years in the associative process is pretty much. And the second reason, I used to work together with the colleagues on the new law on prosecution service, also including the amendments to the Constitution, on Superior Council of Prosecutors and so on. And I've heard lately that these laws would be bad. It's easy to say that the laws are bad when you are not respecting them, when not observing them. I would like to become Prosecutor General in order to prove, to show that the law from 2016 is a good one, and in good hands it may bring about good products, good results. And the third, it is rather motivation for the system. I mean, I feel that I know the problems from within the prosecution service. I feel that I know which would be those solutions that may establish a positive trend of making this prosecution service better. I understand that it is not doable alone. I need a team, and the problems related to prosecution service during the cannot be recovered or cannot be settled or fixed even during the next 7 years. But it's possible to lay down a good foundation so that eventually in 7 years the prosecutors would not be afraid of Prosecutor General or of their bosses, would be brave enough to initiate criminal proceedings against anyone if they honestly feel or believe that a crime was committed, and when they feel that they have all the necessary tools and kits to finalize everything that they initiate. And of course, a lot of challenges will face us, and I'm aware of this. Of them. First, it would be difficult, personally speaking. It will be difficult. Why? Because I never ever was a prosecutor. And winning the trust of the prosecutors' colleagues would be probably the biggest challenge from the very beginning. I am coming with the proposals to change the system, change the administration, but they would be pretty painfully felt within the system. And I'm aware, actually it goes for any kind of institution, that the system will be resilient. Whenever the person will, who are resisting too many, then this task is pretty complicated, even to do by with the Prosecutor General with pretty large competences. And the third thing, I think I will face certain losses, personal losses. I'm aware of this, like losing my image, because I understand that the fast, quick results will not happen if they are to be sustainable. And I may have some losses in my personal life, even financial losses that I'm aware about. But again, I'm aware that every person, each person is the constructor of his own destiny, future. And a person may inspire a lot of other ones in order to make good things happen. I understand that alone the Prosecutor General would not be able to do a lot of things, but a good Prosecutor General may at least be surrounded or manage to be surrounded with good people, so that in perspective those good people would attract even more people, and in 7 or 8 years nobody would have any doubt that the prosecutors are acting in the best interest of society by observing the law, by applying uniformly it to anyone, for anyone.
Ce propun
Now,
eu?
what do I suggest?
În primul rând,
First of all,
eu aș vrea să
I
încep de
would
la
like to
viziune.
start with a
Unde vreau să
vision.
ajung în 7 ani?
Where do I want to get to in 7 years?
Eu vreau ca în
I want that in
2026
2026,
încrederea în procuratură să
the
nu fie
trust in
18%
prosecution
cum
wouldn't be
este acum,
18%,
de 50%.
but 50%.
Încrederea publică.
Public confidence, I mean.
Dar acest lucru,
But this,
adică încrederea
I
în
mean,
procuratură
this
nu vine
public
de la
confidence
sine.
doesn't come, it's not
Ea
granted,
vine în primul rând din exemple bune.
it comes with good examples.
De aceea eu cred
Therefore,
că
I believe
prin exemple bune,
that through good
prin
examples,
fortificarea independenței
by
procurorilor,
strengthening the prosecutor's independence,
prin
by
eradicarea corupției din procuratură,
eradicating
prin
corruption from
aplicarea, prin
prosecution,
respectarea legii,
by
prin aplicarea
respecting the law,
uniformă a
by
legii față
the
de toți,
uniform
inclusiv
application
față
of
de
law
politicieni,
to
în privința
anyone,
politicienilor,
including politicians. And
eu
about
cred că aici trebuie să
politicians, I
discutăm
think we need to
separat.
have a separate discussion,
precum și prin
as well as
încurajarea
by
procurorilor
encouraging
buni să
good
exceleze.
prosecutors to excel.
Se poate
One
ajunge
can
la situația în
arrive
care
at a situation
oamenii să
when
înțeleagă
people will understand
că încălcarea legii
that violation of
inevitabil
law will unavoidably
va duce la
lead
răspundere,
to accountability.
că această
That
răspundere va
this
fi cea
accountability
prevăzută de
will be
lege,
the one provided
Cei
by the law.
nevinovați
That
nu au
those
de
who are
ce să
not
teme,
guilty shouldn't
iar cei
fear,
vinovați
but those who are
inevitabil
guilty
vor
will
răspunde.
unavoidably face the consequences.
Că procurorii
That
sunt onești
prosecutors
în
are
ceea ce
honest
fac,
in what they're doing.
că îi tratează pe
That
toți
they
în mod
treat
egal,
everyone equally.
că
That
fac ce fac
they
cu maxim
do
profesionalism
whatever
și
they do
eficiență.
is with maximum professionalism and efficiency.
Și eu am propus
And I propose
6 priorități
6
principale
priorities
în programul
in
meu.
my program.
Sunt mai multe,
There are more,
dar
but
un manager bun
a
ar
good
trebui să
manager
prioritizeze.
should
Mai mult de 5
prioritize.
priorități deja nu sunt
More
priorități.
than 5 priorities, this is not a priority anymore.
Primul este
First
independența și
is
insuficiența
independence
procurorilor.
and
De ce
insufficiency.
independență
Why independence
și de ce,
and why
de ce independență?
why independence?
Un
A
procuror
prosecutor
care este
who is
fricos
a coward
nu are cum fi eficient,
couldn't be efficient,
fiindcă atunci el se va teme de procuror.
because then he'll be afraid of
El
his
se va teme de
boss.
politicieni,
He'll be afraid of politicians.
el se va teme chiar și de părți
He
în
will
proces.
even be
Știind că
afraid
fenomenul
of
corupției este
parties,
mare.
because we know that the phenomenon of corruption is big.
În acest domeniu,
In this regard,
eu voi pune accent
I
pe
would
două
focus on 2
principii.
principles.
Primul
The first
este
one
corectitudine
is to be fair or correct.
și doi,
The
să
second
nu facă excepții.
is not to have any exceptions, without exceptions.
Și trei,
And 3,
să promovezi
to
în
promote
funcții.
into
Bineînțeles,
function.
procurorul general nu
Of
are
course,
competența
prosecutor general
disciplinară,
cannot
dar are
promote people in
un
function, but he has
cuvânt mare de spus
a
atunci
big
când este vorba
say
de,
when
de politică
we talk
adecvată în
about
procuratură, să
the
promovezi
staff
cei mai buni
policies, to
oameni
promote the
în cele mai
best
bune
people
funcții
into the
în procuratură.
most important positions in prosecution.
A doua este suspiciunea de
Second
corupție
is suspicion of corruption
ca o problemă.
as
Și
a
aici,
problem, and here
eu vreau
I want
ca principiul
that
zero
the principle
toleranță
of zero tolerance
față de corupție
to
să transforme
corruption
într-un slogan,
to become a motto,
într-un motou, care e urmat în fiecare zi.
which is respected every day.
Cum?
And how?
Unu,
One,
capacitarea procuraturii anticorupție.
to empower
Procurorul general nu trebuie să facă dosare.
prosecution.
El trebuie să
The prosecutor
facă
general
ca sistemul
shouldn't
să
create
funcționeze.
cases, he should make it so that the system functions properly.
Doi,
Second,
este ca procedurile disciplinare
the
care
disciplinary
există
procedures which exist today,
să fie instrumentate potrivit.
they
Aici
should
inspecția
be
procurorilor este
conducted
în
appropriately.
mâinile
And
procurorului
here,
general.
the inspection of prosecutors is in the hands of prosecutor general. 3,
transparentizarea procuraturii.
making prosecution transparent. We all know that you have a lot of big crocodiles. They live in murky waters.
Și cât
And
mai multă
the
intransparență,
more
cu mai
lack
mare
of
este șansa de
transparency,
corupție.
the bigger the
Mai
chance
ales
of
având în
corruption,
vedere justiția
especially
în
when we
care
talk about
discreția este foarte mare.
justice where discretion is so large.
Eu cred că
I
Procuratura
believe
Generală
that
poate
prosecution
deveni un
general
exemplu de
can
transparență
become an
atât în
example of
comunicarea
transparency,
adesea
both in
cât și
talking to the
proactiv în
press
informarea
as
societății
well as
despre ce se
proactive in
întâmplă
informing the society about what happens
și de ce se
and
întâmplă
why things
ceva
are
în
happening
justiție.
the way they're happening in justice systems, in the justice system.
De asemenea, eu cred că discreția în
I think
identificarea
that
sancțiunilor
discretion
penale
in
trebuie redusă.
identification of criminal sanctions should be reduced.
Atunci când lăsăm o
When
discreție în
you
aplicarea
leave
unei
a
sancțiuni
lot of
penale de la 5 la
discretion
20 de
from
ani de
5 to
închisoare,
20 years of imprisonment
fără niciun fel de
without
ghidare pentru
any
procurori,
guidance for the prosecutor,
acest lucru
this
inevitabil într-o societate ca
unavoidably
Republica
in a
Moldova
society as Moldova
trezesc prea multe provocări
leaves
în
raises too
activitatea
many
de zi cu zi a
challenges in
procurorilor.
everyday activity of
Aceste provocări
prosecution.
trebuie
These
reduse.
challenges must be
Eu îmi
reduced.
propun
I
să
suggest
unific
to unify
practica
the
de aplicare a
practice
legii
of
în cadrul
application of
procuraturii.
law in prosecution.
Procuratura Generală la
Prosecution
moment
General
emite
currently
instrucțiuni
is
metodice,
issuing
dar aceste
methodological
instrucțiuni metodice
guidelines,
sunt prea
but these
generale
methodological guidelines are too
și nu
general
răspund la
and they
întrebările
do
de
not
bază,
answer to the main
lăsând
questions,
spațiu pentru
leaving
interpretare.
room for interpretation.
Și,
And
împreună cu Curtea
together
Supremă de
with the Supreme Court of
Justiție,
Justice,
voi încerca
I will
să
try
promovez
and
așa numitele
promote
ghiduri
the
de aplicare
so-called
individualizarea sancțiunilor.
guidelines to
Așa încât
individualized
fiecare
sanctions,
pentru
so that it
anumit
is clear that for a certain time of first
cu
certain
anumite
type of
circunstanțe
offense
atenuante sau
or
agravante,
certain aggravating or
discreția se
attenuation
limitează. Ea nu
or certain
dispare,
types
discreția trebuie să existe, ea trebuie să
circumstances.
fie rezonabilă.
The discretion doesn't disappear,
dacă n-ar fi
but discretion should be
discreție, atunci n-ar
reasonable.
fi
If there is
judecători,
no
ar fi
discretion, then it will not be judges, it will be computers.
Calitatea.
Quality now.
Despre calitate, cred că
About
vorbim mai
quality,
departe.
I think
Când e vorba de
when we
calitate,
talk
mă
about
interesează
quality,
trei lucruri.
I'm interested in three
Primul
things.
este
First one
consistența în practica
is
procuraturii,
consistency in the practice
A
of
doua
prosecution. Second,
este colaborarea cu organele de
cooperation
urmărire
with
penală.
law enforcement bodies.
Și trei,
And three
este viteza cu
is
care
the
sunt
speed
instrumentate
with
cazurile.
which cases
Eu cred
are
că
being proceeded with.
urmăriri
I
penale
think
de
criminal
6,
investigations of 6,
9 luni de
9
zile
months
cu arestări
with
sunt chestiuni
arrests,
inacceptabile.
this is unacceptable.
Apropo,
And by the
numărul
way, the
dosarelor
number of
penale în care
criminal
urmărirea
cases
penală
where
durează mai mult de 6
the
luni, în
criminal
anul
investigation takes more than
2018
6 months in
a crescut de
2018
patru ori în anul
raised by 4, is
2017.
by 4 times bigger than 2017. Is 4 times as big
Încrederea
than 2017.
societății
The
e o altă
confidence of
chestiune,
society is a different thing,
transparentizarea plus
making
exemple
things more
bune.
transparent and good examples,
Investigarea cazurilor de rezonanță.
the investigation of high-profile cases. And
vreau să mă
here,
întorc.
I will get back
Sunt
to it.
Dacă procurorul
If
general,
prosecutor
într-o perioadă
general,
relativ scurtă de
during
timp,
a short period
nu
of
va arăta
time,
rezultate
will not
bune
display
în
show good results
investigarea anumitor
in
cauze,
investigating certain cases,
atunci
then
va veni inevitabil o deziluzie.
unavoidably
Iar
people
fără încrederea
will
publică în
become
procuratură,
disheartened.
e foarte
And public
greu să ai
confidence,
un sistem de justiție funcțional.
without public confidence, it's very hard to have a functional
Eu
justice
cred
system.
că investigarea
I
fraudei
think that
bancare
investigation of the banking fraud,
a laundromatului rusesc,
Russian laundromat,
a ilegalităților de la primăria
of
Chișinău,
illegalities from the town hall of
a
Chișinău,
facilităților acordate
of
la trecerea în cont a TVA,
of
a ilegalităților de la vamă.
illegalities from the customs, of registering VAT
Sunt,
in
și
an illegal
achizițiile
way,
publice.
and public
Sunt
procurement.
domenii în care
These are
procurorii
ways
trebuie să
where these are areas
concentreze în
where
mod prioritar.
prosecutors have to focus
În
as a
perspectivă.
priority.
Iar în ceea ce privește
Now, when it
domeniile
comes to
concrete la care
specific
trebuie
areas
să concentreze
where
procurorul general, convingerea mea
prosecutor
personală
general should focus, my personal conviction
este
is
că procurorii
that the
trebuie în primul
prosecutors
rând
have to
să-
first and
prioritatea mea
foremost,
va
and
fi
my priority would be
numit
if I were
procuror
prosecutor general,
să mă concentrez
I would
pe
focus
eradicarea
on
corupției în
eradicating
justiție.
corruption in justice system.
Fiindcă luptul cu
Because
corupție în toate domeniile,
Fighting with corruption in all areas,
asta va însemna
that
lupta
means
cu corupția în
fighting
niciun
with
domeniu.
corruption in no area.
Eu cred că o să
I think
mă opresc aici.
that I'll stop here.
Mersi tare mult.
Thank you very much for that.
Urmează câteva
Now,
întrebări de
a couple of
precizare, în baza
questions
planului de management pe care dumneavoastră l-ați propus.
based on your management
Eu aș
plan.
începe
I
cu
will
prima
start with
întrebare,
the
dacă îmi
first
permiteți.
question, if I may.
Din planul pe care
From
l-ați
your
propus,
management plan,
citez.
I
În faza
cite
incipientă,
at the beginning,
Procuratura
Prosecution
Generală
General
trebuie să
should
devină
help
un adevărat organ
the
care
Superior Council of
asigură independența
Prosecutors to
procurorilor
become a
și
true body
contrabalanță
which would
pentru
ensure the
ține
independence of
perspectivă. Dacă ați
prosecutors
putea
and
să
counterbalance for
elaborați
itself
cum
in the future.
vedeți
How do you
realizarea
see that?
acestui
happening?
Eu nu susțin un
I
procuror
don't
general
support
puternic.
a strong prosecutor general. I support a strong prosecution office. When you have a strong prosecutor general, he would undermine unavoidably other bodies from prosecution office.
Eu conștientizez acest
I'm
lucru, de
aware
asemenea
of this, and I'm
conștientizez
also
puterea
aware
absolută,
that
puterea absolut corupe
that
absolut.
absolute power corrupts absolutely, or absolutely
Puterea pe care o
corrupts.
are acum
The
procurorul
power that
general
the
este
general
foarte
prosecutor
mare
holds
obiectiv
now
de lege
is
și el
very
trebuie
big
să o împarte
through
cu
law,
ceilalți.
and he has to share the power.
Conform legii,
According to the
Consiliul
law,
Superior al
the Superior Council of
Procurorilor este
Prosecutors
garantul
is the
independenței
guarantor
procurorilor.
of prosecutors'
Dar în
independence,
practică,
but
în ultimii
in
3 ani de zile,
practice, in
el
the
s-a
last 3 years,
Consiliul s-a
this
comportat
council
timid.
behaved timidly.
De ce?
Why?
Înțeleg de ce,
I
deoarece
understand why.
6 membri ai
Because 6
Consiliului
members
sunt
of the
procurori în
council
funcție.
are
Și nu prea ar avea
prosecutors
ei
who
mare
exercise
chef
duties,
după
and I don't think they want,
mulți ani
after
din
many
sistem
years
sovietic de procuratură,
of work in a Soviet prosecution
ia
system, to
la harță cu procurorul
actually
general.
fight with the prosecutor general.
De aceea, eu
So
cred că
I
voi fi un
believe
procuror
that will
general
be a prosecutor
onest
general
și
who is
corect,
honest and fair,
dar strict. În
but
limitele
strict
legii.
within the limit of the law.
Așa
and
încât să
demanding,
încurajez
so as to
procurorii
encourage
să spună ce
prosecutors
au a
to say
spune
what they
dacă
have to
ei simt că
say
cred în asta.
if they
Asta e unul.
really believe
Doi,
in that. Two,
să ofer tot
to offer
instrumentariul
all
pentru
the
CSP ca
tools
să acționeze
for
în
the Superior
activez
Council
normal.
prosecutors
Eu am fost
to work.
consternat să constat
And normally, I was bewildered to
Consiliul
find
Superior al
out that the
Procurorilor la moment nu știe
prosecution,
vacanțele din sistemul
that
procuraturii.
that body doesn't know the
Resursele umane
vacancies
sunt în
from
mâinile
the
procurorului general.
prosecution,
Nu a
because
Consiliului
human
Superior al
resources
Procurorilor.
are in the hands of prosecutor general, not in the hands
Și
of the
atunci cum CSP
Superior Council
poate
of
anunța
prosecutors.
concursul?
Then
Dar de ce s-a
how does this
întâmplat
body
acest
can
lucru?
announce this competition
Din
then?
cauza că
Why
procurorul
did it
general,
happen?
în
Because
urma
prosecutor general, as a
modificărilor
result of the changes
din anul
from
2018,
2018,
a obținut dreptul
has
de a
obtained the right
detașa,
to
fără acordul
second,
Consiliului Superior al
without the
Procurorilor,
agreement of the
procurori
Superior
pentru o
Council of
perioadă de până la 2 ani.
prosecutors for 2
Așa
years,
încât în
so
multe
that
funcții
in many
vacante au fost
vacancies
transferați
they would
procurori pe
transfer
perioadă foarte lungă
prosecutors
de
for a
timp,
very long period of time
fără ca CSP măcar să știe
without
despre acest lucru.
the Superior Council of prosecutors to know
A
about
treia
it.
chestiune este disciplina.
The
Inspecția
third one is
procurorilor
discipline.
este
The
în mâinile
prosecution's
procurorului
inspection
general
is
la
in the
moment.
hands
Eu
of
cred
the
că în
prosecutor general
perspectivă,
currently. I think in
controlul
the
asupra
future, the
inspecției ar
control
trebui
of
să
the
treacă
inspection should
într-o
be
oarecare măsură de
given
la procurorul general,
from the prosecutor general
fie într-o instituție autonomă,
to an
fie
autonomous
sub Consiliul Superior al
institution or
Procurorilor,
to
dacă
the
Consiliul Superior al
SCP,
Procurorilor
if
va
the
dovedi
SCP will
suficient
prove
capacitate să
enough
gestioneze
capacity
această
to manage this institution.
Și încă o chestie.
And one more thing.
Eu înțeleg că
I
există
understand
lege,
that there is
dar
law,
există
but there is
un management.
a good management.
Procurorul general nu
The
trebuie să
prosecutor
fie
general
contrapondere
shouldn't
cu
be
Consiliul
a
Superior al
counterbalance to
Procurorilor.
the SCP.
El trebuie să fie
He should be
cineva
someone
care mobilizează
who should
Consiliul Superior al
mobilize the
Procurorilor, care
SCP,
discută cu
who
ei
should
planurile
talk to
sale.
them about the
Cele mai
plans.
importante decizii
The
în
most important
procuratură.
decisions in
Chiar
the
dacă ele
prosecution
nu
office, even
vor
though,
trebui să fie
even if
consultate
they
cu Consiliul Superior al
are not
Procurorilor,
consulted
le
with the
vom consulta.
SCP, I will
De ce?
consult them. And why I'll consult
Pentru
them?
ca să am
Because I
o
want to
susținere din
have
partea Consiliului
full
Superior al
support from the
Procurorilor
SCP
atunci
when
când vor fi decizii
there
dureroase.
will be painful decisions.
Sunt multe alte
There
lucruri
are many
care
other
trebuie
things
spuse
which
aici,
need to be said here,
dar eu aș
but
prefera să mă
I'll
opresc
prefer
aici.
to stop here.
Could I just, I'll just ask you two questions. Excuse me. First of all, you've emphasized independence in your concept and in what you've just said. But the reverse side of that is accountability, and there's an obvious difficulty in balancing the two. Where do you see the balance lying, and to what extent do you think what sort of levels of accountability should there be? Should they be only internal, or to the public, to Parliament, to anybody else?
Shall I answer
In
in
ce limbă
English or
să-
in Romanian?
Romanian. You should answer in Romanian.
Bine. Da, eu am vorbit de independență.
Yes, I talked about
Conceptul
independence,
meu
but
este
my
intitulat
concept is entitled Independence, Correctness,
responsabilitate, curaj și
Responsibility,
eficiență.
Courage, and Efficiency.
Nici o independență
No independence
care nu este urmată
which
de
is not
responsabilitate
based on accountability
și transparență
and transparency
nu poate aduce la altceva
can-
decât corupție
it can only lead to corruption
și corporativism.
and a corporate structure.
Și când este vorba de
And when you talk about
responsabilitate, nu
accountability,
mă refer doar
I
la
don't talk about
responsabilitatea în
the
fața
accountability
procurorului
to
general.
the prosecutor general.
Eu mă refer
I
la
talk about
responsabilitatea
accountability
procurorului
of the
și social.
prosecutor, which is social
De aceea
accountability.
și
So
puneam
that's why
accentul pe
I was
unu.
focusing on
Cum
one.
voi face asta?
How
Spuneam,
will I go about it?
corectitudinea
I
din
mean,
partea
to
mea.
be
Eu vreau să defin un
fairness. I
model
want to become a
pentru
model
ceilalți procurori,
for other prosecutors
cum trebuie de
of
comportat.
how you should behave.
Și aici,
And
unu,
here is one.
un procuror care
A
respectă
prosecutor
legea
which
nu are
respects the
decizia
law
procurorului general.
shouldn't fear prosecutor general.
Dar un procuror
But a prosecutor
care
who
a comis chestiuni
has
ilegale
committed
ar trebui
illegalities
să se
should
gândească
think
ce ar putea să urmeze
what can
inevitat.
follow, and that is unavoidable.
Cum acest lucru poate fi
How
făcut?
can this be done?
Primul, prin
First
instituirea
of
în
all,
cadrul
by creating
Eu
in
nu
the
sunt
prosecution,
adeptul
look, I
măsurilor
don't want to, I don't want to go criminal cases
Dar
against them,
asta nu înseamnă că nu
but it
trebuie
doesn't mean
aplicate în
that
situații
you
extreme.
shouldn't apply them in extreme cases. So,
Eu
I
cred în
believe
instrumente de
in
management,
management
cum ar
tools,
fi un
such
sistem
as
foarte
a
performant de evidența dosarelor.
very good system of tracking cases.
Eu văd
I
responsabilitatea
see the
procurorilor
accountability
șefi,
of head prosecutors or
în primul rând a
prosecutors.
procurorilor șefi,
First of all, of
prin
chief
asigurarea
prosecutors
unei
by
gestionări
ensuring
corecte
a fair or a correct
a
management
procuraturilor pe care le
of
conduc.
the prosecution offices that they manage.
Eu văd
I
responsabilitatea
see
prin
the
investigarea
accountability
adecvată
by appropriately
a
investigating
fiecărei sesizări
each
cu privire la
and
baterile
every
disciplinare.
report
Și aici, de
regarding
asemenea, am fost
disciplinary
consternat,
deviations.
potrivit
And I
regulilor
was,
actuale din procuratură,
I was struck by the
la
fact
inspecția
that
procurorilor ajungeau
that
doar
only
plângerile avizate de
the
procurorul general.
complaints which were cleared by the prosecutor general would arrive on the desks of the prosecution inspection.
Și o
And
altă chestiune este
another thing is
transparența.
the transparency.
Eu aș putea să apar aici prea radical
I
pe
may be
alături,
too radical
dar eu
here,
cred că
but
societatea
I
ar
believe
trebui
that
să
the
cunoască
society should know
câte dosare au
how many
pornit o anumită
cases were
procuratură,
started by a
la ce
certain
dată s-a pornit
prosecution,
o
at
anumită
what
cauză
date a
penală.
certain
Nu
case
spun
was
cine este
started. I
acuzat
don't say
acolo,
who's the accused
nu
there.
spun
I
care
don't
sunt
say
faptele
what
concrete,
are the
dar
facts of the case,
să
but
existe o posibilitate
there has to be
pentru
a possibility
societate
for the
să-și pună
society to
întrebări
ask
legitime atunci
legitimate
când
questions
6,
when
7,
6 or
8
7
ani
or
de zile
8
cu
years
urmărire penală
is the
rămâne
duration of
la
a criminal
faza
investigation,
urmăririi
and it
penale
only stays
împotriva
at the stage of
unui
criminal investigation
primar din
against
opoziție.
a mayor from the opposition.
Just to follow up to that, though, the difficulty is not so much explaining the cases you bring as when you don't bring a case, and the difficulties that then arise when you say things and you may effectively condemn somebody that you're not prosecuting. How would you deal with that difficulty?
Bineînțeles că
Of
procurorul
course,
general
prosecutor
și nici chiar
general
procuratura
and
generală
not
nu
even the
poate
prosecution
asigura
general,
un
prosecution
deliberul
office could
control
not
asupra la
ensure
orice.
a control of everything.
Dar o bună
But a
ghidare
good
din
guidance
partea procuraturii
from the
generale ar
prosecution
putea să
office
permită
could allow.
să înțelegem când este
Look,
vorba
we
de o
understand
chestiune de
when it's
discreție a
about a
procurorului
discretion
sau
of
când este
prosecutor
vorba de
or
o
when it's
chestiune de
about
inacțiune a
an
procurorului.
inaction of the prosecutor.
Când sunt situații
When there
50 la
are
50
situations which are 50-50.
și comportamentul
And the
procurorului a
behavior
fost
of the
onest
prosecutor was
și a
honest,
demonstrat o
and he
anumită
proved
proactivitate
a
în
certain
investigare.
he was
Asta
proactive in
este- asta este
investigation.
decizia
That is the
procurorului.
decision of the
Eu cred că
prosecutor.
procuratura
Now, I believe that the
generală și
prosecution
procurorul
general and the
general
prosecutor
trebuie să
general
intervină cu
should
controale
intervene with
doar
controls
atunci
only
când
and
există
if
aparențe de
there
situații din comun.
there is an appearance of an inappropriate situation.
Procurorul
The
general nu trebuie
prosecutor
să fie un
general
jandarm
should
pentru
not
procurori.
be the policeman of prosecutors.
Iar
And
da, eu
yes,
sunt
I
ferm
am
convins
firmly convinced
că procurorul
that
general nu trebuie
prosecutor
să uite
general
fiecare dosar,
shouldn't
nu
look
trebuie să
in each and
analizeze
every case.
probatoriu.
He shouldn't look at the indictment.
Procurorul general,
prosecutor
procurorul de
general-
caz trebuie să aibă
Sorry,
discreția să decidă ce
the
va face
prosecution
eficaz, dar
prosecutor
să
on the case
asume
should have the
decizia
discretion
pe care
of
o
what
ia.
he's going to do with the case,
Și
and
atunci
he should
când procurorul de
should
caz
understand the consequences of that. And
Atunci
when
când procurorul de caz
the prosecutor
face acest
of,
lucru
on the
cu
case
încălcarea
does this by
clară a
clearly
regulilor de
violating
interpretare a
the
legii
rules of law interpretation,
sau prin
or
trecerea cu vederea
by
unor probe
actually
evidente din
overlooking some
dosar
obvious evidence in the case,
sau prin
or
neîntreprinderea
by
anumitor
not
măsuri
taking
care să
certain
impună în
action
mod obiectiv.
which objectively should have been
Doar în
taken.
astfel de
Only in these
situații eu văd
situations I
necesitatea de a
see the
interveni.
need to intervene.
În primul rând din partea
First and
procurorului
foremost,
ierarhic
by the hierarchically senior prosecutor,
în modul, bineînțeles,
but
prevăzut
of
de
course within the law, according to the law.
Can I ask you as well? I mean, it seems there has been a culture of impunity and a culture that was favourable to corruption in the office, and cultures don't change overnight. How would you go about trying to change the culture? That's assuming you agree that there is a problem with culture in the office.
Da.
Yes,
Cultura există.
the culture exists,
și
and
deprinderile, practicile se schimbă
the
cel mai greu.
habits are hardest to
Mai ales
change
atunci când ele sunt confortabile.
when
pentru
they are
cei care le
comfortable
aplică.
for those who apply them. especially in those situations, when they are
Dar,
comfortable
de
to those who
asemenea,
apply
eu
them. But I
înțeleg
equally understand
situația care a
that the
existat până
situation
acum
which
nu mai
existed
poate
so
fi
far
tolerată în
cannot be
societate.
tolerated anymore by the society.
Și aici vreau să
And
spun de la
here
început,
I should tell you that
dacă
if
eu aș fi venit
I
aici să
were-
fac nimic, atunci n-aș fi apărut acest concurs.
look, if I were here to do nothing, then I wouldn't be standing in front of you. And
Iar schimbarea
the
practicii
the
trebuie să
change in
vină
the
de sus
behavior
în
has to
jos.
come from above.
Exemple
Top down,
bune
top down.
de la
Good examples
superiori.
from the seniors.
Eu sunt ferm
I'm
convins
firmly
că atunci când
convinced that
superiorii nu
when
sunt
the
corupți,
seniors
atunci
are not
când
corrupt,
superiorii au
when the
un comportament
seniors
onest, când
have
dau
an
un
honest
exemplu bun
behavior, when
și
they lead by
ceilalți
example,
de
then
jos
others from
se
below
aliază.
will ally.
Eu de asemenea am
I
văzut dorință
also
în ochii
saw
multor
a wish
procurori
in the eyes of many
ca să aibă
prosecutors,
un
a desire
comportament bun,
in the eyes of many
conformitate cu
prosecutors
legea,
to
că e mai
behave
ușor
well,
așa.
because it's easier like this if you comply with the law.
Dar eu nu am văzut
But I haven't
în
seen
procuratură,
in
culegre,
prosecution,
modele
unfortunately, role models.
și
I haven't
lideri
seen them.
în spatele
I haven't
cărora
seen
ei
leaders
se
behind which they could
Eu îmi propun să fiu
ally.
unul dintre ei,
I want to be one of them,
dar nu singurul.
but I don't want to be alone.
Eu îmi propun
I
să
want
numesc în
to
calitate de
appoint
agenții
as
mei
deputies
persoane din
people
procuratură,
from prosecution,
procurori în funcție,
prosecution who exercise
asupra
duties,
cărora să nu planeze
but
suspiciuni de
there shouldn't be
corupție
any doubt of corruption against them.
și care să fie respectați
And
de
they
către
should be
procurori,
respected
nu
by
pentru faptul
prosecutors
că sunt
not
parte
for the
din
fact that
grup,
they are part of groups,
ci pentru profesionalism
but for their professionalism
și dedicație față
and
de
dedication to their work.
Eu cred că doar prin exemplu
And I think
superiorilor
only by
se poate
these
schimba mai
examples,
ușor
seniors, it's
modele,
easier to change
exemple,
the behavior
și
of models.
consistența în
So
aceste
examples and coherence.
adică nu
I
doar un
mean,
comportament
not
odată sau
just
de două ori.
one time
Comportamentul trebuie să
behavior.
fie
The
sistematic.
behavior
Și eu
should
sigur că
be
în 3-4
continuous and
ani de zile
systematic. And
se poate
I'm sure that in
schimba
3-4 years,
serios
therefore, we may change
situația. Dar mai este o
seriously
altă
this
chestiune.
situation. But there is also something
De asemenea,
else.
sunt conștient
I'm also
ca urmare a
well aware
aplicării
that
unor
following
măsuri
some measures,
corecte
which in my opinion are fair,
și introducerea unor reguli previzibile în
and by
procuratură,
introducing predictable
anumit număr de procurori vor
rules in
pleca.
prosecution service, some of them will leave, some prosecutors will
Deoarece va
leave
fi
from the
greu.
system because it will be
Va fi greu
difficult.
pentru
It
ei
will
să
be difficult
trăiască
for
într-o altă
them to
realitate
live
în
in another
procuratură.
reality of the prosecution service.
Este inevitabil
It's
pentru mine
unavoidable
ca să
for
insist
me to
asupra
insist
creșterii
upon
numărului
increasing the number
audienților la
of
ENG
students
funcție de
within
procurori,
the
de 3,
National
eventual
Institute of
4 ori.
Justice
La
who would
moment
like to
avem
embrace the
deja
professional
80
prosecutors.
de vacanțe
Right
în
now we
procuratură.
have already 80 vacancies in
10%.
the system, like
Noi
10%.
avem un nivel de
So we have a
audiențe
level
deja acum
of
de 20. Noi nu
students
acoperim nici
which
măcar
are 20 by
o
number. We do
pătrime,
not
adică
cover
acoperim
even
o pătrime din
1/4,
vacanțe.
only
Nu
1/4 of the
suportăm aceste
vacancies. So,
vacanțe.
but we
Plus,
should
în
manage to
momentul în
find them
care
somehow for the rest
se
of
va
the vacancies.
merge pe
Moreover, once we will
măsuri ferme anticorupție în
will
procuratură, eu
undertake
sunt
some
sigur
firm
că
anti-corruption measures, I'm
un
sure
anumit număr
that
de procurori
a
tot va
certain number
pleca
of
de
procurers will leave the
fluxul
offices,
de
meaning that
procurori
the
care vor pleca din
turnover
procuratură,
of
perioada incipientă, va fi
the
mai mare.
personnel will be pretty high
Prin
in
promovarea
the
tinerilor,
very initial phase. So by
prin aducerea
promoting
unor
the
sânge nou,
youngsters, by bringing new blood into the
se
system,
va putea
we will be
ajunge în
able to
perspectivă o
reach,
schimbare
respectively speaking, to
calitativă
a qualitative
și
change
potențial sustenabilă
and sustainable, I
procuratură.
hope, change in the prosecution service.
Mulțumesc.
Thank you. You have a question? Mr. Grebinciu, you've mentioned the track record of the criminal case files. So meaning that you know some drawbacks in this tracking record of keeping record of the criminal investigation and including the crimes which are investigated. I know it was a problem, a perpetual problem. But how do you want? I mean, you said that you already have some thoughts about this. So how would you accomplish those? What will you accomplish in order to improve the track record for those criminal investigations, so that everything will be investigated and everything will be done in a professional way? How would you improve this
Noi la moment
system?
avem e-dosar, sistemul
Well, we
e-dosar
have
în
the system
procuratură,
e-case in the prosecution
care a
service,
început să fie
which
implementat în
started to be
anul
implemented back in
2018.
2010, if I'm not wrong.
regret,
And
acum
unfortunately,
procurorii s-au
now the
relaxat.
prosecutors are too
Nu prea
relaxed.
actualizează
They are not updating the
O bază de
database,
date neactualizată
but
este inutilă.
an unupdated database is useless.
Dar noi avem e-dosar în
At the same time, we
procuratură,
have that
dar
case
pare
set
că
in
noi
prosecution
nu folosim
office,
aceste
but it seems
date.
that those data are not being used by us.
Noi aveam un sistem
We
de
have a
evidență a dosarelor,
system
dar noi
of
nu avem un sistem de
track
gestionare a
record,
dosarelor.
but we don't have a system of
Noi nu
case
vedem
management.
foarte
We
clar
don't
cât
see
durează urmăririle
exactly how
penale,
long criminal
de ce
investigation
anumite
takes,
urmăriri penale
why
durează
certain
excesiv,
criminal cases
de ce
are
anumite
investigated
urmăriri penale se
excessively long,
clasează,
why some
ce
others
se
are being
întâmplă cu
seized,
transmiterea lor în
and what
judecată de
happens to
lucru, ce se întâmplă cu
their
complexitatea volumului de muncă
to what happened to them
și
when
multe
they
alte chestii.
reach the court and so on and so forth.
Vrem noi sau nu vrem, dar noi nu ne
So
putem
violence
opune
knowledge,
trendurilor.
but we cannot oppose certain trends.
Iar trendul general în
And the
justiție
general trend in
este
justice is
automatizarea.
automatization.
Noi trebuie să dăm
We
computerilor cât
should
mai mult
give
din
the
ceea ce pot
computers as
face mai
much as
bine decât
possible
oamenii.
what they could do better than people.
Și în această
And in
perspectivă, eu cred că un sistem
this
foarte
perspective, a
performant de
very
gestionare a
performant
dosarelor în
system of
procuratură
e-management,
la
e-case
iveală foarte
management
multe
may
chestii.
highlight a
Nu doar
lot
pentru
of
procurorul general,
things
pentru
useful
și
not only
procurorii
prosecutor
șefi,
general,
pentru
but also for
Asta e
anyone.
prima
For
parte,
anyone, that's first side.
eficientizarea
I mean,
mecanismelor
increasing
care
the
deja există.
efficiency of the mechanism already in place.
A doua parte
The second,
este publicarea periodică
to
a
publish
datelor
regularly the
statistice,
statistics,
nu la solicitarea
not
jurnalistului,
following the request
dar
of journalists, but automatically.
a datelor statistice despre ce se întâmplă în
The
procuratură.
statistics about what happens
Ce
in
se
the
întâmplă cu
prosecution
fenomenul
service, what
infracțional.
happened
Dacă
with the criminal investigations.
sistemul
So
electronic
in case
gestionează
if
astfel de date, nu și le
this is done electronically,
Și
why
aici
we
merge
should
o
hide
altă
them?
măsură care va
And
fi
there is
dureroasă.
another
Dar eu
step
cred că e
which is pretty
necesară în
painful, but it's necessary in
Să renunțăm
perspective, and
odată
that is to
la dosarele
to
hârtie,
forget about hard copy of
la
our
evidența dosarelor.
case files and
În
records
momentul în care vom
records
renunța
being
la
made
evidența
on
dosarelor
hard copy, on
hârtie,
paper, in other words. So if
asta
you
va
will
duce
get
la o
rid
mai
of paper
bună
in this
introducere a
system,
datelor în
this
sistemul
would
electronic.
mean a
Și
better
mai
input
bună
of
posibilitate de
data
a
into
gestiona.
the
Eu înțeleg că
electronic
există
system and
riscul
better
ca anumite
e-management. I
date
understand there is a
din
risk
sistem
that certain
pot fi
data from
manipulate.
the system might be
Ele pot
manipulated
fi
as well.
manipulate
Of course, they
oriunde.
might be manipulated
Dar cu un sistem de
anywhere,
securitate
but
adecvat, putem
with a
trece.
very good
Dacă
security
în
system,
Olanda
it's doable.
este posibil, dacă în
In
Georgia
Netherlands, it was
acest lucru
doable.
este
In
posibil,
Georgia, it was
cu
also
siguranță
possible.
acest lucru este posibil în
For
Republica
sure.
Moldova.
It's doable in the Republic of Moldova as well.
Și încă o chestie.
And
care
another
vreau să
thing that I would
menționez.
like
O
also to
parte din
mention,
acest sistem trebuie deschis pentru public.
some of these
O
systems
parte
should
din acest
become open for the public.
Gen, numărul urmăririi penale.
For example, the
Articolul
number
în
of
baza
case,
căruia
the
va fi
article of
urmărirea
charge,
penală. Data pornirii
the data of
urmăririi penale.
initiating the
Și
criminal investigation, and
pentru ca societatea să vadă cât de
the
durează,
word
cât
to
e procesul durează.
to make sure that the society sees how long
Și
this
o
takes.
chestiune.
Another
Acest
thing should be
sistem nu
added.
trebuie să fie un sistem
The
unic
system should
pentru
not be
procuratură.
just for the
Trebuie un sistem-
prosecution
trebuie să existe un sistem
service.
interoperabil
It should be
dintre procuratură
should
și
provide
alte
the
organe de
possibility of
urmărire penală.
interoperability for
Și doi,
other criminal
acest
investigation
sistem trebuie
bodies
să
as
devină
well. And second,
interoperabil
it should become
cu
also
programul de
interoperable
gestionare a dosarelor și FEMIDA.
with
Astfel încât
FEMIDA
dosarele de la
and
procurori
the
nu simt
random
ei că
distribution
articolul
cases
inutil,
of the judiciary,
dar simt că există un
so that the
beneficiu
system would be indeed
concret în această
useful,
calitate, ca
useful,
procurorii
so
scoată,
that this database would be useful
transmit
for
dosarele
anyone.
electronic
For
în
example,
instanțe
procurator
judiciare,
would
fac citare
send
electronic persoanei.
electronically
Poate
the
să
case file to
caute
the judge, to
în
the court,
birou, în,
and would
bază de date
summon
de
the parties
adrese.
electronically, would have
Poate
the
să
possibility
verifice
to look for
electronic dacă au
addresses
fost sau nu au fost
of the parties
semnate
in the database to
să
see
fie
what
de
is the
altfel.
criminal record of them, and then
Dar
it would be
spuneam
different.
că
It will make a
birocrația
difference.
trebuie
But
să
again, the
vină în mână cu
bureaucracy should go hand in hand
pentru
with the
procurori, dacă
benefits
ei nu
for
se
the
simt, ei nu se
prosecutors. Otherwise, they would not apply those new measures. You said that you are ready to analyze the criminal investigations which are ongoing ones, and in case if you would see that there is no ground to initiate criminal investigation, you said that you're ready to seize them or to drop them. But just imagine a situation. First of all, this is voluminous, it's bulky work, you may imagine. And secondly, the main point. Let's say somebody from the Prosecutor General Office may reach the conclusion that the case is initiated without any grounds. But the prosecutor, who is controlling, let's say, or supervising this criminal investigation, believes differently. So how you then would act? How would you impose your decision upon him? Would you please help me to find what you're referring to? Well, it is on the page which is priority solutions that you propose, chapter 4, item 7. So those unjustifiably or ungroundedly dropped or seized or initiated should be ceased or dropped, and those the other ones would be reopened, if of course the law would allow it. Let us speak about those who are seized. Let's say that you've been notified about this situation. Well, first, Prosecutor General does not check every criminal case. Well, of course not personally, but you stated like this, that those cases which have been initiated without grounds, you would subject them to analysis. Of course, somebody will be like a group of an analytical group, and you will receive reports. No, each chief prosecutor and each office should do his job. I mentioned this as a very beginning phase, as a beginning step. For example, I tell them, please take a decision on what kind of criminal cases might be finalized by you, and what of them you don't have enough evidences for the accusation. And you are not expecting additional evidences. So if you have this kind of case, that would be the question. I would propose to seize them, because evidences are already not enough and nobody is going to give you more. So that is not, strategically speaking, positive attitude. That's why I would ask them to focus on important case files, on those who are investigatable. And the second category would be different. I was surprised to find that during the last 3 years, 1/3 of the mayors from our country were criminally investigated. So I'm not speaking about court decisions, I'm speaking about criminal investigation process. So they have been charged, and that's it. It was just sort of a tool to influence them. I would like to see what happens to this, why this is done. Because once there are evidences on some illegalities, then the criminal investigation continue. But if there is no evidence, then the cases should be not delayed. They should be finally stopped pretty quickly. We understand what we are speaking about. This is just feeding the suspicion that the prosecutors are involved in the political affairs. And these kind of stuff, these kind of things are just preventing or hampering the mayors to do their job. That is what I meant. But again, the decisions on each particular case should be taken by the prosecutors responsible for that case. I think it would be useful in 1.5 years to make an inventory, unexpected inventory, and to see how well those prosecutors have been doing their job. Were doing their job, and once we would have suspicion showing that certain cases which lacked any kind of evidence being delayed already for 4 or 3 years and not being dropped or seized, but those other criminal investigations which are very strong also have been stopped and dropped, then it's clear that we should focus and discuss very well with the chief prosecutor and the responsible prosecutor. Okay, your role as prosecutor general, how would you check, how would you control this? Because you issue the order, for example, chief prosecutors, let us analyze your cases, and they will report to you that everything is okay, How you do then? How will we then check or recheck, verify that there is false reporting, fake reporting? Because they tell you that everything is okay. In your prosecutor general, okay, I was mentioning already about independence. Independence go hand in hand with the responsibility or accountability. The inspection of prosecutors is still there, and it is in the hand of the prosecutor general, who can do those unannounced verification anytime. Moreover, statistically speaking, the prosecutor general receive annually 3,000 complaints about those criminal cases. So if the chief prosecutor would tell me that everything is okay, that is first step to check more details those cases under him. If the prosecution would tell me this, then okay, we will check them, we'll verify them with the inspection. Mr. Grebincha, my question is following. Implementation of the concept, your concept and provisions in the concept, will this bring the need of changing the legislation about, the legislation concerning the prosecution service and related legislation latest
linii
effects.
mari,
Well,
soluțiile pe care le
I
propun
understood.
sunt
Well, to
soluții de
great
management.
extent, my solutions
nu
are
exclud,
related to
mai ales
management
având în vedere
measures.
cultura
But again, I
juridică din
don't exclude
Republica
especially
Moldova, în
the
care
legal
dacă
culture
legea
in
nu
the
spune
Republic of
neapopriau
Moldova, saying
și
that
trebuie să
if the law does not say
funcționarea
that
de
this
ce
is
numești un
not to be done,
probabil că
then
va
they will
exista
do it.
de
That is why
intervenit
I think
anumite
we'll need
prevederi
to
legale, dar nu
propose certain
cruciale.
legislative changes,
Pentru
but
a
not
clarifica.
radical ones, in order to improve
Eu
some
totuși
aspects.
cred că
And I still
80%,
believe that
dacă nu
80% or
90%
even
din ceea ce
90%
propun
of what I
pot fi
propose
făcute
is
în limita
doable within the
cadrului
limit
legal
of the
existent.
existing legal framework.
Iar
And
Procurorul
the
general,
Prosecutor
și aici
General, and here
probabil mă întorc un
I
pic înapoi,
perhaps should
Procurorul general trebuie să
refrain
fie
it,
reprezentantul
repeat it.
procuraturii.
The Prosecutor General
El
should be
trebuie să fie,
representative of Prosecution Service.
el nu trebuie să fie
He should
șeful
not be the
procurorilor.
chief
El trebuie
of
să fie
prosecutors. He
unul din
should be
egalii,
one
principalul
of
dintre
the
egalii în
equal,
procuratură. El trebuie să
or
fie
equal
liderul
among the equals.
procuraturii.
He should be the leader
Atunci
of
când
the
vorbim de
prosecutors.
lider,
And whenever
el
we
trebuie
speak
de
about the
asemenea
leader,
să
then
aducă
he should
la
also
cunoștința
bring
decidenților
inform
problemele care
the
sunt
decision
întâmplă
makers
care
to
le
inform the
întâmplă
decision
procurorul
makers
în
about the
fiecare zi.
problems that our prosecution service is
Conlucrare bună
facing
la nivel
daily.
legislativ cu
That is
Ministerul
why good
Justiției și
cooperation
Parlamentului
with
este
the
una din
lawmaker,
principalele
with Minister of
sarcinile
Justice, one the
Procuraturii
main
Generale.
task,
Și aici,
priority
eu nu
of
cred
the
că vor
Prosecutor
fi
General Service. And here I don't
excludite,
expect
adică vor
any
fi
kind of
reduceri. Eu cred că vor fi
necessities
totuși
of
anumite
reducing our
modificări legislative pe care le
cooperation.
voi
Of
susține.
course, I
Prima
would support some
este
legislative
modificarea
proposals.
articolului
First is
37
to
cod
change
penal.
the
Eu
Article
cred că articolul
307 of
37
the
cod penal
Criminal
trebuie
Code.
să dispară.
This Article 307 should
Eu înțeleg
disappear, in
că
my
acest
opinion. I
lucru ar
understand that
părea
this
mai puțin
seems
popular în ochii
less
procurorilor.
popular among
El dă
prosecutors
dreptul procurorilor
because
să
it gives
inițieze dosare
the
împotriva
right to
judecătorilor,
priority to
dar eu nu
initiate
cred că un
cases
judecător
against
adoptă
judges,
cu
but I
bună
don't think that the
știință
judge
o hotărâre
would
dovedit
adopt with
ilegală.
good faith an
Dacă un
obviously
judecător
illegal decision. So
a
if
luat o hotărâre
a
dovedită
judge
ilegală, există o
took
explicație
such
pentru asta.
an illegal decision,
Fie e
even
vorba
there
de
the
cineva
expectation
rugat,
is in place. For example,
fie e vorba
somebody
de
is
cineva la
requesting this, or somebody
fie e
making him
vorba de
interested in
altceva.
this, or something
Dar
else.
cu bună
But
știință
again,
încalci legea,
with
nu-mi
good
închipui
faith to
rațional de ce o
violate the
persoană
law, it is irrational. I mean, I don't believe it. I
sănătoasă, mentală ar
don't
face.
believe that a mentally healthy person would
Și
do it.
atunci,
And then,
dacă există așa ceva, haideți să
if we
vorbim
have something
de
like this,
corupție,
then let us speak about
corupție
corruption,
pasivă. Haideți să
passive
vorbim de trafic de
corruption,
influență.
or traffic of
Haideți să vorbim de
influence,
abuz.
or abuse
Dar să nu vorbim
of
de articolul
office,
37.
but not the Article 307.
Deoarece,
Why?
da,
Because
ipotetic,
indeed,
articolul
hypothetically
37
speaking,
ar putea să ne ajute să prindem
307
un judecător.
may help us to catch a
Dar
judge.
el îngenunchează
But
ceilalți
again,
485
he would
de
he
judecători care
would
există.
humiliate all the other judges who exist in the system.
Acest
More
307
than
aduce mai multă daună și
300, 400. So
procuraturii
this
și justiției
307 article brings a lot of
decât
damage to
plus valoare
justice, to
procurorului.
prosecution,
Asta
rather
e
than
unul.
bringing
Doi,
an added
eu cred
value
că pe
to the
anumite
prosecutors.
componente din
That's
infracțiuni,
first.
sancțiunile
Second, I
trebuie
think
reduse.
for certain crimes, the sanctions are to be reduced.
Sunt
There
tradițional la
are,
noi
traditionally speaking,
infracțiunile împotriva
some
proprietății
offenses
sunt
against
sancționate
property
mult mai
which are
dur decât
sanctioned
sancțiunile
tougher
împotriva ordinii
than
publice.
the offenses against public order.
Înțelegem istoric de
We
unde vine,
understand
dar
historically speaking
nici
where
chiar
it
să
comes from,
avem
but again,
printre cele
we
mai
should
înalte rate
not
de
have the highest
populare
rate
nepenitenciară
of
din Europa.
population as detainees compared to the rest
O
of
altă
Europe.
chestie care
Another
eu cred
thing
că ar
that I
fi
think should
importantă
be important, is important, and is
este
important
de
in
a discuta
speaking
cu
about further action, that is to
procurorii.
discuss with the
Procurorii știu mai
prosecutors. I
bine
mean,
problemele
prosecutors know
tehnice
better the
dincolo de
technical
procedura
problems
penală. Și eu
beyond
cred
the
că
procedures, I mean,
Procuratura
criminal
Generală va fi un bun
procedures.
partener al
And I
Ministerului
think the
Justiției
Prosecutor
și al
General
Parlamentului în
will become good partner with Minister of Justice and lawmakers in simplifying the criminal procedure code so that the prosecutors would not focus too much on bureaucracy in the proceedings, but on the evidences on guilt or non-guilt of the person. Right now, the criminal procedure is quite sophisticated. For example, to apprehension, the prosecution should write down 3 papers. Why? If you please allow me, two more small questions. First, how would you explain it yourself that a law which you said, well, it was not ideal, but relatively speaking was good, adopted in 2016. And actually in 2019, we are now in the situation to say that only about 18% of our society trust the system. What is the problem? And the second question, if you will find in your activity, if you identify those prosecutors who deserve to be promoted in certain positions, how will you do it, take into account that nevertheless these competences belong of the Prosecutor General are pretty limited? Thank you very much for the questions. First, so trust is small, yes? So why? The law is good. yes, the law is good. The confidence is low. You see, in a wrong brain, even the law, a good law is wrong as well. I don't think that the benefits provided by the law and prosecution services have been capitalized fully by the prosecutors. I would say that rather prosecution service is a corporation acting in the interest of prosecutors and not in the interest of the society, forgetting about the task of the prosecution service. The second, that these are examples which are not very beautiful from prosecution because they have been not disclosed. These were not disclosed. For example, by initiating the political cases, or by initiating criminal investigation based on political reasons and not on some evidences, and complaints against prosecutors have been simply neglected, denied by the Prosecutor General. Moreover, the general trust in the intelligence institutions is very small, so that is why the same goes for the prosecution. Otherwise, it cannot happen otherwise. The people, the second, so about the second, so it's changing the people. Of course, the role of appointing, promoting prosecutors belong, first of all, to the Senior Council of Prosecutors. But here we should take into account two aspects. So this is appointing the deputies of the Prosecutor General. This is being done by the Prosecutor General. He is selecting them. The second, statistics. We have 15, if not 15 subdivisions within the Prosecutor General Office. All of these have been felt in 2016 to 18. If you would look at how many candidates ran for those 15 positions, then you would be astonished. Only 15. So it means, de facto, the competition have been fake. The people who have been agreed by the state, they have been proved. But those good people who are not the ones who are loyal to the boss, they knew that they have zero chances. So by providing good examples of good contests, I'm sure that the good ones will excel, will run for those positions. And again, as I said, a good role model of the boss is have very good impact on others. Mr. Grebincia, in your concept, you've phrased very exact tasks, speaking about the improving the image of the institution. At the same time, from what we've heard now from you, I understood that you are pleading, you would like to decentralize the power. It was said by you that the Prosecutor General should not be strong, the prosecution should be strong with the balanced competences within the prosecutorial structures. So my question goes like this. So you want to focus on the high-profile cases, and saying that those high-profile cases should be settled, should be resolved in order to improve the image of the prosecution service. So how will you do this? So you say decentralization. The initiative comes from you that you have less competences or less power, and this power goes to the subdivisions of the prosecution service, and you have concrete tasks. And you would like also focus very much on investigating those high-profile cases. But again, how? By which mechanism? How this is going to happen? How this mechanism of highlighting the necessity of investigating certain high-profile cases that you say would improve the image of the prosecution? How you will do this? So thank you very much for the question. I'm not naive, and I understand that decentralization means losing the influence. But again, I should be responsible to make decentralization as long as you are sure that this decentralization would be properly used. Otherwise, you should not decentralize the power. First of all, we should fight the corruption and then decentralize. That's first. And the second. So why I would like decentralization to happen? The prosecution service should work efficiently regardless of who is the Prosecutor General. And in order to make it happen, the prosecution should be strong, like an institution, not like individuals, but like an institution. That's why without decentralization, this would not happen. Without decentralization, the prosecutor general will be perceived as a god, and this is not a sustainable attitude. In 7 years, it would be good for the prosecutors not to think who is the prosecutor general, but which are the rules to be observed and how the prosecutors should work so that the best would reach the best positions. And the high-profile cases, well, the high-profile cases might be accelerated, speeded up by two means. It was proved lately, I am not wrong, recently the Prosecutor General Office admitted that certain cases from their office might be moved faster than it used to be done. I think there are very simple explanations for this. Once the things are not moving on for pretty lengthy time, as a prosecutor general, I may, of course, request an explanation from the chief prosecutors, and if something strange would happen there, I also, the prosecutor general, also get the leverages to interfere and to provide some instructions, some guidelines. And if that prosecutor office is not doing its job, then that case might be taken from them, but in this case, Prosecutor General should assume personal responsibility for this kind of decision, exceptional decision. And then in Prosecutor General office, we should have several prosecutors, and they are there, I mean, the so-called special mission prosecutors, who are competent in investigating those cases. But again, I repeat, this practice should be exceptional one whenever other leverages are not bringing the right result. I'm sure that once we'll have good examples, and once we'll have persuasive examples saying that corruption is not anymore acceptable, then the attitude will change very fast, very quickly.
To accomplish your concept, you'll need to supplement the prosecution budget. How do you plan the financing of prosecution if you were to become prosecutor general? The budget of prosecution will not significantly increase based on this platform. What we have now in terms of finances is the bad financial management and not the lack of money. The budget of prosecution has doubled in the last 3 years. I'm a realist, and I mean, not to request for a twofold increase, but with the current money, you can work with them. You can redirect money in order to cover the needs. For instance, to triple the budget of the prosecution, which investigates serious criminal cases. Look, we can have sources to efficiently manage. We can increase salaries of prosecution. We would need investments, and those would be discussed separately. I think the development partner is going to help. This is one, too. When it comes to infrastructure, I would be happy if the Ministry of Justice would agree that when it comes to optimization of the judicial map, to include prosecution, so that some of the courts would be given to the prosecutors. That would be more efficient for witnesses, for the escort, and for the participants in the case. A question to you, Mr. Grebincha. Do you remember from your experience a professional failure? What would be that failure, and what would you do different this time? I've had a number of failures. One that I'm still thinking about is what I've tried to do in 2015. In the bar. I tried to create a group of 13 lawyers who would create new rules of selection of lawyers, to have new rules of transparency in selection of lawyers, to promote efficiently the policies for lawyers. And we were able to do that. We were able to select 7 out of 13 in the council of the bar, but not enough. But then,
7 luni
we
de
were,
zile,
after
în mod
7
ilegal,
months,
a
we
fost
were
justificat.
illegally
Am fost
thrown
aruncați
away,
în
thrown out,
conducerea
out of the bar's
Și aici cred eu că
management.
este o greșeală
So this is a
tactică.
tactical mistake, and I've learned
Prima,
my
să
lesson.
nu
First
subestimezi
one is
tupeul unora
not to underestimate how far people can go,
și mizele pe care eu greu
and
le
then
înțeleg.
it's hard for me to understand the stakes.
Se vorbește despre
People
mită în
say
avocatură,
about
eu nu exclud că
bribes
există dacă există în societate. Și
in
aparent,
among lawyers. Well, I
aceste
don't rule
chestii
this
au
out, and I think
Plus,
this prevailed. In
Procurorul
addition,
general
prosecutor
trebuie să fie un bun
general
manager.
should be a good
Adică
manager.
să înțeleagă
I mean, he should
când trebuie să
understand
făcut un
when
pas
you need to
dureros și când
undertake
nu.
a painful step and when not.
Fiindcă în momentul în care va
Because
merge ca
if,
un taur în fața unui
if he
perete,
goes
nu
like
este
a bull
exclus și
against the
cu
wall,
coarnele.
he could break his horns.
Pe mine mă interesează
Well,
rezultatul.
I care about the result.
În condițiile respectării legii,
All right, complying with
pe
the law,
reguli de onestitate,
honest
și
rules,
transparență.
and transparency.
Vorbeam de...
I was talking about
vorbeam de...
I was talking about
aici este
failure.
am
Well, that's my
subestimat
failure.
pe unora,
I've underestimated
am
how
subestimat
far
pe
people can
alături
go.
comunicarea cu
I've
avocații.
underestimated communication with lawyers.
Cum puteți, hai să zic, să compensați uite
How
așa o
can you
subestimare, fiindcă
compensate
mergeți într-o
this? Look, you go
instituție
into an
care...
institution,
Nu.
which, well,
Lecția pe care am
Well,
Tupeul va
lesson
fi
learned.
prezent.
Lecția pe care am învățat-o este că
look,
reforma pe care vreau să o promovez nu
the
este pentru
reform
dânci.
I want to promote is not for myself, it's not for his deputies, it's for
aceea eu voi încerca să
prosecutors. I
conving
will try to
procurorii
convince the prosecutors
de beneficiile care
about
vin
the
din urmă.
benefits that come with it.
În momentul în care va fi un număr mare
If there will
de
be a
procurori care
large
mă vor
number of
susține,
prosecutors who will support
îmi va
me,
fi foarte ușor să mă mișc mai departe.
it will be very easy for me to move forward.
Și schimbările vor mai
And change will happen.
Asta este unul. Și doi,
This is one. Two,
de arătat mai clar ce
to
faci.
clearly show
Nouă ni se
what
pare
you
că
do,
noi facem
because
un
we
lucru bun
think
și toți
we
îți
do a
bat din
good
palmă.
job and
Degeaba
everybody will
faci lucruri
clap.
bune dacă nimeni nu știe despre ele.
No, you shouldn't do good things if people don't know about them,
În special procurorii.
especially
Fiindcă spuneam anterior,
prosecutors,
câștigarea
because you
încrederii
know that
procurorilor
gaining
este
confidence
principala
among
provocare a
prosecutors
mea
is
pe
the
care o văd în
main
această
challenge
funcție.
that I would face
Nu
if I were to
luptele
be
cu
chosen,
politicienii.
not fighting politicians.
Apropo, în ceea ce
By the
privește
way, when it
politicienii,
comes to
spuneam
politicians, and I was saying that I
anterior
wanted to get
acest
back to this,
lucru, procuratura cu regret a fost
prosecution,
deseori
unfortunately, has oftentimes
mijloc
been
de politic.
a means of political
Procuratura trebuie
fight.
scoasă din
Prosecution
luptele
should be
politice.
taken out of the
Cum
political
acest lucru va
games,
fi făcut?
political fights. If you
Prin
do
trei
that,
mijloace.
how do
Primul
you
lucru,
do
am
that?
spus
For
anterior,
three means.
respectarea strictă a legii
By
și aplicare
strict
egală a
compliance with the law
toți.
and equal application
Doi,
to everyone. Two,
asigurarea procurorilor,
ensuring,
asigurarea
so
politicienilor,
ensuring
procuratura
politicians
nu va mai fi
that
implicată
prosecution
în
will not
reguli
be
politice.
anymore involved
Reguli clare de
in
joc, că political
games,
nu ating
political rules.
politicienii
Prosecution,
nemotivat, iar
prosecutors
politicienii
don't
nu trebuie
touch
să intervină în niciun
unjustifiably
fel asupra procuraturii.
politicians, and politicians
Trei,
should not get
procurorii
interfere
trebuie
with
să înțeleagă
prosecution. And
că
three,
politicienii nu au nicio
prosecutors
influență asupra
have to understand
procuraturii.
that
Așa
politicians
încât
have
să
no
fie-
influence
să aibă
whatsoever
curajul
against them.
să facă
They
ceea
have
ce
to have
dictează legea
the courage
atunci când
to do
situația
what
cere.
the law tells them to do.
Noi vă mulțumim foarte
Thank you.
mult.
Please, you have the floor.
Onorată Comisie,
Honored committee,
în planul de dezvoltare
in
strategică a
my
Procuraturii
plan for the prosecution
pentru perioada de
for
7 ani
for 7 years,
a fost
I've
expus opinia mea, a
outlined
fost
my opinion.
structurată în
I've
4
structured it in
capitole.
4 chapters.
Primul capitol
First chapter
prevedea
provided
verificarea
for the verification of the
procurorilor la etapa actuală și
capacities
propunerea
of
de
the
modificare a
prosecutors at
unor
this
aspecte
stage
de dezvoltare în
and to
continuare
making
a
some changes
calităților profesionale.
to
A doua
how
etapă
we
prevedea
develop the professional
misiunea,
qualities. Second one is to
profilul și
review
analiza SWOT
the mission and to do the SWOT analysis of the
De asemenea,
prosecution.
punctul 3
And
prevedea
third, also provided
prioritățile,
for the
obiectivele.
objectives and
Și
priorities.
punctul
And
4,
fourth, would provide
prevedea concluzii.
for the conclusions.
Ca o
Now,
concluzie
as a
în
conclusion,
conceptul de dezvoltare
based on
strategică,
my
am
concept,
analizat
I've
pozițiile
analyzed
forte care
the
le
strengths,
văd și
the strong
care
points
consider că
which I
vor
see and which I
influența
believe
benefic
would
la dezvoltarea procuraturii.
positively influence the prosecution
În
development.
primul rând,
First and foremost, or first of all,
cel mai important
the most
punct care
important
consider
item
este
is
atribuirea calității de
to
magistrat
give them,
procuror.
to give the prosecutor the position of magistrate or the
Voi
quality of
analiza
magistrate.
succint
I'll
poziția,
briefly analyze that. once they get this status and the status of magistrate, the prosecutor will not benefit only from some, will not just have rights, but he will also have more obligations. The justice delivery means that it is conducted by a magistrate. So magistrate is not just a judge, but a prosecutor as well, because when you approve solutions, the prosecutor has discretion. So he is independent while he approves the procedural solution. But the procedural law doesn't give him the status, and I believe that it is a situation which doesn't hampers the orderly development of the criminal procedure. Second condition or second prerequisite to improve the activity of the prosecution office is to decrease the influence of the hierarchically superior prosecutor. So this results from the first priority, which is the magistrate status. So once you decrease the interference of the senior prosecutor in the activity of justice delivery, so we will see a decrease in the control of the senior prosecutor, and what will increase, it will be the hierarchical control by the court, so the judicial oversight. Now, if you make an analysis of the procedural criminal legislation, in 2003, we've had the first changes where the judicial oversight was the basis of the control of the prosecutor's activity. But in some time, there were changes where in Article 2099 again includes the control of the senior prosecutor, which hampers the orderly conduct of the criminal procedure, as far as I'm concerned, because we need to get rid of the old procedural system and to get to a new system. The next item is the creation of a body, advisory body, related to the Prosecutor General, and this is the board of the Prosecutor General. So the previous practice shows that this board influenced positively the activity in prosecution, which was exemplified by approving some joint decisions. There you would discuss the issues which would be raised in relation to prosecutors. They would propose modifications and changes. The board worked, and it had a very, very positive influence. Now, Prosecutor General, while he wants to have more leverage, even though the previous law would provide for the existence of the board, but this board has never been convened. And we can see where we are at now. Now, the next item, which I believe very important, is the creation of a two-chamber Superior Council of Magistracy, created out of the prosecutors and judges' chambers. That would contribute essentially to the autonomy of this body, and it would contribute to having a efficient, accessible justice delivery for the whole population of this country. Also, part of my program is I've analyzed the current positions. Even though the strategy is a snapshot of the existing situation, and actually, if we talk about long, medium, and short-term objectives, we want to fully implement these objectives, so that the justice delivery and so that justice is independent and impartial. Thank you. Thank you so much for the presentation. I would have one question to you. 2016, there was a reform of the prosecution by implementing a new legal framework, by creating the Superior Council of Prosecutors, whose aim was to strengthen the independence of prosecutors and to limit the interference of politicians in the activity of this body. Unfortunately, the society at large and the experts are saying that things didn't improve from 2016 and onwards, despite these changes in the law. Now you suggest a different, more changes to the law. Now, why do you think that that would be efficient, given that the previous ones were not efficient, even though the law, people say, is good? Well, I've been in prosecution for 18 years. I participated in 2 general assemblies where we elected the councils. Look, people knew ahead of time who would be the member of the council. I've reacted through the vote by raising the hand or not raising the hand at the General Assembly of Prosecutors. Moreover, being member, since the Prosecutor General is a member of the SCP, and people haven't been seconded, so they were dependent. So they're administratively and procedurally, they were dependent on the Prosecutor General. How do you think that these people, when the Prosecutor General comes to the SCP, do you think that these people will be independent and they will say what I think? Well, when there will be a council which will be created out of 2 chambers, where you have the judges, where you have prosecutors, where you have the civil society, I think the interference, even if there will be an interference by the Prosecutor General in the council, I think that that influence or the influence of other people will be very much reduced in relation to these people, and then the decisions will be truly the ones expected by the prosecutors and by the judges. I look here in your paper, you say that efficient cooperation with specialized bodies in collecting information, collecting intelligence. What do you mean? Theory provides for a number of bodies which are specialized bodies which collect intelligence. This is special investigative bodies and then intelligence, state intelligence. Now, when you start criminal investigation, when they report to the prosecution, it's only information that comes from police. In very few cases, you have reports. There are few reports that come from the intelligence service. Now, it would be okay for this cooperation to be better. I mean, you don't want to have these barriers, because I worked in the unit which would coordinate the activity of these bodies, and I know that intelligence doesn't come from these bodies as it should be, because either there is no confidence in the Prosecutor General who would coordinate the activity, and they would try to talk to different territorial prosecution offices. That's why I said that this cooperation should be more efficient with the Prosecution General and with the specialized prosecution which coordinates the activity of these bodies. Thank you.
In the reasoning or motivation, you state that you are ready to propose changes in the law on prosecution service in order to include the notion of professional rotation of prosecutors that would prevent them from being in the same position for more than 5 years as an anti-corruption element, as you say here. Would you please clarify? You say also, would clarify, is it related to all prosecutors? But it goes both for the enforcement prosecutors and for the chief prosecutor. I mean, the position that I'd like to inform you about is that the person, in case if the one stays for more than 5 years in one subdivision, due to the same kind of activity, then they have the so-called professional fatigue. Besides this, we have also the risk of corruptibility. I think in the same position, you are dealing with the same kind of persons, and then we have this element that may influence negatively your activity. That's why I believe, and also proceeding from personal practice or experience, I think that changing the person from one position to another, minimum at least once in 5 years, will be beneficial for the activity of prosecution. Yes, and I also would like to add, and also the same goes, the same proceeds from the international practice. For example, in Turkey, it's 3 years. Regardless of position, the person, once in 3 years, is changed, is shifted with his activity, not just in different subdivisions, but in also different sectors of the system. But what about the specialization? Well, each prosecution have the same kind of specialization, like criminal investigation, state accusation, and the defense of human rights and freedom. So, meaning if the person from Çadırlunga district responsible for the criminal investigation is shifted to Cahul, he is also dealing with the criminal investigation. So it's meaning that he is still specialized, and he will positively accumulate this experience, because the good things that he obtained in the previous place will be an added value in the new place. And then it will be an exchange of experience, will be beneficial for both teams, both officers. And who will provide the apartments for them? Who will provide apartment to them in different districts? Well, we thought about this. There are apartments from our office. Of course, there is certain uncomfort when you are shifted, but again, Prosecutor General has also the possibility of discussing with everyone. Then, of course, he may shift them in neighboring district, from one sector, meaning from one sector to another, or from one, let's say, specialized office into another one which is close, in order to make sure that they are undergoing through all the necessary hierarchical steps in the prosecution service. Would you please clarify? I will end up the thought very soon. So be more concrete, please. You see, in the past, this rotation, as you call it, of the prosecutors, and not only prosecutors, by the way, but also the investigators and the assistants and so on, deputies. In that time, they didn't have the right to work in their place where they have been born, with some exceptions. It was the same for prosecutors, the same principle applied for judges, and I know my own experience that although it was not comfortable, including things like apartments and job for the wife and kindergarten for the kids, but on the other hand, I felt myself free. So how do you see that kind of situation? I mean, are you going to implement it as it was, as it used to be? You see, at that time, it was set out like a customs, not in the law. It was a custom. It was the decision of the Republican national prosecutor, and very rare was somebody was opposing to this. But again, it was an element of anti-corruption, very effective element of anti-corruption. How do you think about this? Because you are very close to this, but would you please be more exact? Well, this objective was taken from the experience. I started my activity in the county of Lapushna. I was in Chisinau at the time living. I was traveling daily to that county. And I'd like to tell you that, well, it's exactly why I have this idea from the experience that we used to have. This makes you feel free of certain obligations. You feel free in your actions. You are more independent in your actions. It is something beneficial, I think, for everyone. That's why I propose it.
I can see a great deal of merit, I can see a lot of merit from the anti-corruption point of view in moving people after a period of 5 years. The difficulty I see is that when you're dealing with people in an anti-corruption unit, they're dealing with financial crime. And this is a rather specialized area, and it can be quite hard to get staff who understand how to read books of account, that type of thing, who understand the technicalities. It's not every investigator who's good at this. And I just wonder about and also it can be quite hard to get suitable people to work in these units. So I just wonder about the practicality of rotating people every 5 years. While I see the good reason you have for wanting to do it, but it strikes me as being perhaps not all that practical if you want to have a well-functioning office with people who have got the ability to conduct these types of investigation.
Well, the competence of the territorial prosecution office compared with the specialized offices, of course, they differ. But again, every prosecutor is obliged, and he should carry out in prosecution, investigation, any kind of crime. So he should be able to do it for any kind of crime. Moreover, I'd like to give you to assure you that by working the anti-corruption prosecution office for 3 years after coming back from another office, from the territorial office, I'd like to tell you that it is a real added value, and that's why I say that the rotation is very beneficial for the professional development, because in the county I used to deal with different kind of cases compared to the anti-corruption office, but I was professionally interested in growing as a professional. I was interested in discovery, in holding someone liable. And later on, by the way, I started to work in the Prosecutor General office, and there I used to deal with organized crime. And this specific is again pretty different. But taking account the skills that I gain in the territory, in the anti-corruption, and then implemented in the investigating the organized crime offenses, crimes, this was very helpful for me. The experience is very helpful, and I think the rotation will be very beneficial for everyone.
Just to change the subject, could I ask, to change the subject, could I ask you, you've mentioned a great deal about independence and the status of magistrates and so on. How do you balance this type of independence with the accountability? What sort of accountability should prosecutors have, in your opinion?
Well, I've mentioned that independence of a prosecutor, by giving this magistrate status, actually also entails certain responsibility upon the prosecutor, because by adopting the decision by himself, by signing by himself the documents, then you bear this personal responsibility. And this mobilizes you, this disciplines you. And in case if superior prosecutor would disagree with the decision you take, and if it's illegal, then it might be cancelled as illegal. But in other cases, if it's not illegal, then the control this kind of control should be done not by the boss, by the court, and then the judicial control will dominate over the superior control, and it will minimize it. And then the prosecutor issuing the decision will be more independent and self-confident in the decisions he takes.
Could I ask you also, do you see the problem of the prosecutor's office at present as being to any extent a problem of culture? The culture in the office which has tended to be tolerant of corruption. And how would you go about changing that culture or altering it, so that corruption would not be acceptable to the vast body of prosecutors, as seems not to be the case up until now?
If I understood you correctly, I would like to tell you In the prosecution office, even now, they have the Soviet heritage of the old type of prosecution. I'll give you an example. I would not like to go far beyond these issues, but being in Romania in a business trip during a meeting with the Prosecutor General, everyone was discussing something, and he approached them, and he also got involved in the discussion of the prosecutors. And another situation, even the situation in Moldova, when the Prosecutor General entered into the office, into the room, everybody stand up very quickly on their feet, and then the answer would be self-understood to your question that you've raised. So changing, a radical change of culture, that is necessary. I mean, we have to change the perception within the prosecutors, and the key, I think, is also that magistrate status. So the independence, when you are alone taking the decision, when you are self-responsible, when you are increasing your own responsibility in taking the decisions, then it will change the situation as well, and then the Prosecutor General will not be that arrogant as he used to be, and then would be able to reach rather more positive solutions instead of a situation when now everybody is standing immediately up when they see the Prosecutor General.
Are you not taking a big risk? I mean, you have an office which has a lot of corrupt people still in it, and I would have said that the status of a magistrate has to be earned rather than be given as of right. And suddenly these people, a lot of whom are corrupt, are going no longer to be supervised in the same way, but will be able to make corrupt decisions without any check on them. I mean, how do you, if you don't address the culture first, how can you possibly decide that people, a lot of whom you think are corrupt, should be actually turned into magistrates overnight?
Well, being on another business trip with Norlam, Norwegian organization in Oslo, there the chairman of the Supreme Court of Justice, by making certain presentation to us, he told us that there are prosecutors, judges and lawyers from Moldova, that it is most corrupt country, and my reaction was immediate one. I'm telling you, certainly I raised, and I said, how do you know that we are the most corrupted country, and the prosecutors are the most corrupt? As an answer to your question. It's clear that in any forest we have dried trees, and the society perceives the corruption of the system as a result of certain events in the society. For example, the Prosecutor General does not want to leave the office, he is insisting to stick to the position, then the council does not follow certain rules, and so on and so forth. But per general, the things in prosecution office are not that bad as it seems, as somebody may discuss or somebody may speak within the society. The prosecutors are not the most corrupt people, and this was proven also by the analysis made by the Soros Foundation and by other non-governmental bodies who mentioned which are the most corrupted institutions. But anyway, if we establish and define the corrupt people, I'm telling you from my experience, because I worked as a prosecutor and then corruption prosecution officer, then the harshest measures will be taken. I remember the times when certain information or allegations were received by prosecution general that somebody is involved in certain strange activities, corruption activities, then immediately they will be investigated, arrested, and so on. And for example, today, 2 weeks ago, the prosecutor from anti-corruption office was arrested. So the system is already trying to get rid of these elements, because violence nolens, when the society perceives us that we are corrupt and our activity is therefore is very difficult, when every day we are being attacked by these kind of critics from the mass media and TV channels saying the same, then it's very difficult to act as a prosecutorial representative. You're saying that the magistrate status should be given to the prosecutors, and I'd like therefore to ask you, you say in the concept, you say they find that interdependence between the manifestation, axiological manifestation of the justice phenomena as such and the status of magistrates. What do you want to tell by us? Okay, once again, so you say it's obvious that we may say that we found the interdependence between axiological manifestation of the justice phenomena with the magistrate status, and further on the justice phenomenon in its essence ensures the existence of quality of the magistrate's quality in the social expression. Would you please decode it? I understand that it means something, but would you please decode it? Okay, I will tell you, I'll tell you. The social status of the magistrate does not depend just on his procedural position. Socially speaking, there are different kind of ethics codes, different rules which impose certain behavior of those magistrates, so that she would behave properly not only within his procedural occupation, but also during the rest of his life. So he follows those rules during the entire his life. You cannot exit from your office and all of a sudden you would change the rules of your behavior, because otherwise everybody will say that there is no ethics among us. So that is what I wanted to tell. I wanted to ask you, what kind of measures would you take to unify the practice for the cases of cessation, or ceasing the criminal prosecution? Because the cases are still there, nobody controls them, and there are a lot of risks of corruption as well. I mean, the control, external control, it does not exist. Domestically speaking, within the office, I know they say that the chief prosecutor is checking every case. But again, what about unification? Actually, this kind of control from seniors should not exist. What kind of control we should have is the so-called judicial control. That is what I've mentioned several times. So once the solution is adopted, for example, on stopping the case, then the parties may appeal it, may challenge it in the court. If they disagree, they should appeal it in court. That is the judicial control. If they do not appeal, then it goes to archive, and it's stored there until the time when some additional complaints would be provided, or additional notification would be provided. If not, then the case remains in the archive. Anytime it might be reinitiated due to new circumstances. For example, would annul, for example, would cancel the decision taken by the superior prosecutors. In this case, the superior prosecutor may cancel this previous order and dispose or request on reinitiating the investigation. If please allow me, I have a question, or a philosophical one, but practical. The question whether in your activity you did violate the law, or if not, could you imagine some situation when the violation of the law would be necessary, or even unavoidable? These kind of questions have been raised also within the psychological test. We didn't know. I didn't know about this. It's difficult to be prosecutor, and it's difficult to be prosecutor in the region where you've been born, in the region where you live, and it's difficult from time to time to refuse. By knowing that you may change your situation, being, let's say, helped, being assisted. But we've took the oath. It's very difficult, but it's our profession, our destiny that we've chosen. As the song says, our destiny is not understood by us, it's not accepted by us, understood. So I have a rather concrete question, but in the same direction. So
Este vorba de o
it's
cauză la CEDO,
about the case
în care
within the
cumva
European
sunt
Court
vizate
where,
acțiunile
in a way,
dumneavoastră.
your actions
Și
have
este
been
vorba în speță
dealt with
de
as well.
cauza
So
Caracet
it
contra
is the
Moldovei.
case
Dumneavoastră
Caracet
probabil
versus
cunoașteți
Moldova.
despre ce
Perhaps
este
you know
vorba.
it, yes.
Deci,
So you
pe
know
un
what's
caz
all
de
about. It
maltratare
was
de polițist
ill
la
treatment
momentul deținerii
made by
dumneavoastră la 30
police
aprilie
during the
ați
precautionary arrest on
refuzat
3rd of
să
April. You
începeți
refused
urmărirea
to
penală.
initiate criminal
Ulterior, în
investigation,
iulie,
and then
judecătorul
later
de
in July, the
instrucție
instruction
a
judge
admis parțial contestarea reclamantului și a
admitted
estimat că
the
ordonanța de refuz
challenge of
din 30
the
aprilie era
plaintiff, saying
prematură și
that the
nefondată
refusal was
și
ungrounded,
că autoritățile
and the
competente au
authorities
interogat superficial reclamantul
superficially
cu privire la
interrogated
faptele
the plaintiff
pretinse.
regarding the
Ulterior,
claimed
mai târziu, tot
facts.
în iulie,
And also later on, alleged
dumneavoastră
facts.
din
And
nou
in July,
emiteți o
you also
ordonanță de
issue
refuz
another
cu privire
order
la
of
începerea
refusal
urmăririi penale.
for starting the investigation
Conținutul
against the
căreia era
police
similar cu cea
people.
din aprilie
And the content was
2009.
basically similar to that from the April
Iar curtea,
2009.
pe final,
But finally, the
a
European Court
constatat, printre
found,
multe alte
among many
constatări,
other things,
că procuratura
that
nu a
the
luat măsuri
prosecution
decisive
office
care
was
puteau
not
permite de a
taking the
elucida
decisive
circumstanțele cauzei și
measures
că a
in order
acceptat fără
to
rezerve
investigate
versiunea
the case,
faptelor
accepting
prezentate
without
de
any kind of
poliție,
reserves everything
astfel
that police
încât
were
urmărirea
giving to
penală
them, so
desfășurată
that
de
the
autorități n-a fost una
the
detaliată și
criminal investigation was not
efectivă, condamnând
detailed and
Republica Moldova pentru
effective, and
încălcarea
the Moldova,
articolului 3
the
din
Republic of Moldova,
Convenție.
convicted for
Dacă
violating the Article
puteți
3
să
Convention. Yes, I may highlight this case. The persons, these persons were apprehended for committing a very violent offense. It was in Buyukani Commissariat. Once I started to examine it, there was already a decision, was not cancelled by my colleagues from the Buyukani sector prosecutors law, which according to Article 275, which says that in case if there is a decision which is not cancelled yet, I cannot take another decision unless it is cancelled. So based on that decision, I also adopted my decision where expressly said that there is still a decision which is not for.
Moreover, there were two forensic medical examinations. One examination showed that there were bruises, and the other one showed that there were no bruises. They hear people, and I issued an opinion which later on was maintained by the senior prosecutors and I think by the instruction judge. And then there was a decision on this case by the prosecution office of the Chisinau municipality. As far as I remember this case, my position, the procedural position was maintained by the senior prosecutor and by the court, and then it was appealed. So the petitioner's request was rejected and they maintained the decision of the body. So I couldn't say that that is justice. Look, we have looked at this from all angles and points of view. That's why you have the hierarchy of courts. We ruled the court partially cancelled and then it allowed. So they filtered, the system filters the situation, and so he won not because we didn't do our job well. We examined it and we gave our opinion. The court said that not enough activities have been undertaken, but according to the action plan on this material, we have heard all people, we have done the expertise, we have the whole evidence in order to approve a solution. We didn't see and we could not have evidence which would prove the guilt of those people and to hold liable one person, then we would lose somewhere else. That's why we adopted this solution, knowing for sure that this is the right one. And then I'm asked about this case many times, and I'm telling you, frankly, that until today, I think that I've adopted the correct decision. Mr. Gropa, I'll ask you to remember, to remind yourself of an experience in your professional life that you could say that that was qualified as a failure. And why do you think that that is a failure? And why would you do it differently? I've done a criminal investigation against this thief-in-law. His name is Moskalchuk. I've obtained a conviction sentence, 19 years. And then the members of the criminal group tried to influence the witnesses who were under protection, and then they tried to talk to the prosecution office in order to withdraw the office from me. I fought a lot. I've opposed, including with the general management at that time, in order to protect the people who were the key witnesses and who were subjected to pressures by the criminal authorities and by some people who were in the state administration, state bodies. I started an investigation against the people from the penitentiary. I've obtained a conviction sentence for some of them, but due to the senior prosecutors and due to the existence of some vested interests, they withdrew the case from me. They gave it to the anti-corruption prosecution, and I couldn't see it through. I couldn't see through the case, which means I couldn't clean the state bodies from people who were corrupt people, influenced by the members of the criminal organization. And maybe I couldn't, till the very end, ensure the state protection provided by the law for people who actually maybe gave their lives, and health, because the procedure took more than, I think it's still ongoing, and by victimizing people and witnesses so far and until now, due to the existing law. Okay, why were you different this time? What would I do different this time? If I was a magistrate at the time, and the general prosecutor and other people could not interfere so easily in the case and withdraw whenever they want and however they want this case from me, I think things would have been much better, and I would have finalized it. I should tell you that the first instance, the military court, was so ugly. They acquitted the person, even though there were more than 15 recusals. And I went further, and I made the request to the council, showing the multiple violations, filming. I filmed them. There were records, and there were pictures. And then the council said we couldn't intervene in justice because the interference at that stage would determine the approval of a solution on the case. And we agreed. We went further. The appeal convicted the person. Justice is delivered with difficulty. You have to have lots of health. But at the end of the day, even though it is burdensome, well, I still trust justice, and I want the society to trust it as well. Thank you. Any more questions, please? No. We thank you so much for time, for Taurus. Thank you very much.